Because I was supposed to have my son today to pick him up from school.
I was calling to try to find out if she was going to be actually picking him up that day.
Because I've had job interviews.
Why is it happening?
Because George is dead.
Well, I mean, remind or just find out if she was going to, or if she was just going to give him over to me as what happened.
I finally answered, and that's...
His ex-wife, when I say a monster, she's a monster. His ex-wife is bonkers about money. He's not fair. He's not fair. Send me money, send me money, send me money. This is what happened. It's not fair. How can I send you money when I don't have a job? See, that is just not fair.
It's wrong and it's unfair.
Someone needs to call Brian.
Sarah told me she was going to call 911 and go outside and have a cigarette and a drink and asked me to come out there with her, and I told her that.
Heard my phone ringing, and I knew it was Brian because he called over and over and over and over again, which is what he does.
You'll be able to use a phone.
How long will that take? Because I need to talk to Brian. I need to talk to Brian.
Welcome back. Today is the day. Well, actually, August 25th was the day, but for our channel, today is the day. We are finally diving into the final family court trial hearing. I'm going to try to keep this intro short because we have a lot to get through today. So if you're new here, welcome to the world of long-form rant content, where there is no structure or goal. It is just me reacting to whatever I want to react to, however I want to react to it. And the video is finished when it is finished. I speak a lot, so if this is a video where you want someone to play it all the way through, this is not the video for you. I also claim no authority or expertise on this channel. These are all my opinions. You take what you take, you leave what you leave. But if you leave a like on the way out. That's just good home training. Huge shout out to Human Tooth from Reddit for sending me this. I can only imagine how much work went into cleaning this up and making it usable and watchable for everyone. So thank you so much for that. I'm actually going to drop a support link to them in the description below, since they did all this work for all of us to enjoy / be in shock and awe at. I also want to give a shout out because there are a few YouTubers who actually went in person to witness this trial. That's incredible. I love like the crossover into reality, and this is why we have a public trial system. It's so cool that we actually can go do this to any trial, more or less, within reason. But I know Tanika's 2 Cents was there, Hear Me Out was there, Larry Powers was there, EBDB was there. I think it's EBDB or EDBD. I'm dyslexic, so it's one of them. And I feel like there might have been another 1 or 2 people who were there. Either way, I think that's so cool. Now that I have finished like 95% of my reaction at the time of making this introduction, I have looked at some other reactions and have seen and heard some testimonials from the people who were there, and am just in awe of that experience and what that must have been like. So also, any of those people, if you want to come on the channel and tell me your experience, have a little interview, let me know, you know. I also want to give a little shout out to Honorable Miss Jackson, because looking up her bio, I found out that she is the president of the Orange County Bar Association. I know that's right. First black woman president of the Orange County Bar Association. So this is a top tier judge. She didn't come to play around. And neither did Linda. Welcome. She is ready to get things rolling. But I think that's all the major things. So with all that out of the way, let's dive right in.
Great. Do you swear to tell the whole truth and nothing but the truth?
I do.
It was all a lie. Guys, it was all a lie. She lied.
Okay. All right. We're here for a final hearing with regard to a supplemental petition for modification of alimony and child support, as well as a petition for relocation. I do understand that there was a motion granting the temporary relocation, but it's my understanding the court needs to still consider a final relocation on that issue. Before we get into that, there were a couple of motions that were filed by Ms. Boone that I'd like to address before we start. The first of which is a respondent's motion for contempt and to compel petitioner to submit visitation application immediately that was filed with the court on August 20th of 2025.
Yeah, I surely did forget that she titled it like that, of motion for contempt and to compel petitioner to file these visiting applications immediately, which it's so unprofessional and weird, and this is why you don't write that way, because the judge has to read it as it was submitted, and she did a great job downplaying it, but I'm like, yeah, that sounds very foolish in open court.
If I recall correctly, one of the last times we were here, the petitioner indicated that he had filed something with the Department of Corrections regarding the visitation. They were slow to react, and he was going to follow up. Did the court remember that correctly?
More or less. I had sent them something.
Hold on, Ms. Boone.
I never heard anything back from them about it. So I guess they never got that one. I have since submitted it.
All right, when did you submit something?
The end of last week.
You have a date you can give?
I think it was Friday.
Friday, which would have been the 22nd, I believe.
Correct.
All right, Ms. Boone, Mr. Boone has indicated that he attempted to follow up after one of our last hearings regarding the status of the application for visitation. He never heard anything, so he submitted another one on Friday, August 22nd.
Your Honor, am I allowed to expound on that?
Yes, you are.
Well, I know for a fact that I'm actually in the classifications department now, and as of this date, no visitation applications have been received on his end for himself or for my son.
What do you mean you know for a fact? That doesn't make any sense. You know for a fact because you work in the classifications department that he didn't submit his visitation application. There's just so much wrong with this. One, this was on the 22nd, which is a Friday. This trial is on the Monday, the 25th. So in those 3 days, of course, you would not know anything about this. Also, second, you would not know anything about this. Your inmate job does not actually give you access to private personal information, at least not first. You're in a clerical support job. You file things, you look over this and all the stuff people don't want to do. You are not sitting there in like the control room being like, well, did we get the new file update? Let me just check the system. Let me log in and just look around and see if a visitation application has been submitted. You would have no idea either way. But you say these things with such confidence as though the judge would not know this. I mean, I guess it doesn't matter. No one's going to push it that hard, but that is just so funny. I actually work in the classifications department, and he hasn't submitted a visitation application, which I looked into it for Lowell, is sent to a completely different email, is checked by institutional administrators, and doesn't go through the classifications department at all. The classifications department deals with the classifications of the prisoners, housing, custody levels, programs, stuff like that. It has nothing to do with anyone in the outside world. Okay, but I will be fair. Yes, this was a cover your ass move by Brian to submit the application on the Friday before trial on Monday. But the court never gave a deadline saying you need to do this in advance by such time. It just said you need to do this before we come back here, and you did it. You had an answer, she wrote it down, so you're good. So we are starting off strong, and we are already in for it. We know she's going to manipulate anything she can, and none of us should be surprised.
And no attempts also have been made in order for him to try to do so in the meantime. I know that our pre-trial conference was on May 29th, and you gave them a 2-week deadline to submit. And I believe also that
is the 2-week deadline in the room with us right now. Because I don't remember that. I remember she kept bringing it up saying that happened, but she always says this. She says in the trial, in the court hearing, you gave this blank verbal order and you told him blank and he didn't do it, but somehow those specific words never end up in the actual order.
his attorney even volunteered to submit them himself due to the prolongation of time for the now ongoing 9 months that I've been trying to get him to submit for no reason of him withholding submitting the visitation application. So that's why I put in my cross notice and again my motion for contempt at this point, because they have disregarded your verbal order or instructions to submit him within the 2 weeks as of May 29th.
What do you mean verbal order? Why do you keep saying that? There's no such thing as a verbal order. I never understood that. And she says it so confidently every single time.
All right, I'll have counsel respond.
Yes, thank you, Your Honor. So in order for someone to be held in contempt, the court has to find that they willfully and intentionally violated an express and clear provision in a order or an agreement that was ratified by an order. I'm looking at paragraph 5 of the order that references this Department of Corrections application. And it says, Respondent also raised concern about petitioner not preparing an application required by the Department of Corrections so that the minor child could visit her. There was no pending motion before the court on this issue, but petitioner did provide information to the court on his efforts in submitting the requested application, and he advised the court that he would attempt to follow up on the status of the application.
What? You mean that doesn't specifically state you have a 2-week verbal order deadline that you will be held in contempt if you do not submit these visitation applications immediately? No way. Like, literally, I don't think a single word of what she said was in there.
There's nowhere in this paragraph where it gives gives Mr. Boone some sort of clear and express deadline to submit anything, or that he would be held in contempt or put on notice that if he didn't do something by a specific date that he could be held in contempt by this court. With that being said, Your Honor, I do understand that it's the court's wishes, and it's my client's wishes too, to get this set up as quickly as possible. Mr. Boone has resubmitted a second time now the application on the 22nd of August, according to his sworn testimony. I'm assuming that whatever Ms. Boone is seeing right now, maybe it's not updated in the system.
She's not seeing anything. She's just saying that. She would have absolutely no access to that. The most she can do is beg, nag, and plead officers or guards to look into it for her. And if the last time that she begged them, they said that they didn't see it, if they even looked at all, then she wouldn't know. Just because it would be a visiting application for you does not mean you inherently get immediate access and updates to those applications. But whatever. And he knows this too. He's just not going to call that out.
I don't know what else Mr. Boone can do to address this concern, but certainly being held in contempt would not be an appropriate remedy based on the language of the order in question.
All right, I will allow you to briefly respond, Ms. Boone.
Thank you. After the pre-trial conference, he also was under oath as well and told the court that he made an attempt and he has not made an attempt. Nonetheless, that was 3 months ago. And you did give them verbally a 2-week deadline. And again, verbally, his counsel volunteered to
All right, Ms. Boone, I cannot enforce any verbal statements that were not in an order.
Exactly. And there it is. About time. I mean, like, and she just had it, like, she just kept going because people were letting it slide, and she's like, and you did verbally, and you did verbally, because it's the only thing that she thinks can't be fact-checked. And that's why verbal orders don't exist. But she did the same thing in her interview, or the car interview with Chelsea, when she keeps saying, I'm afraid for my life. I'm so afraid for my life. Well, they haven't actually threatened you or done anything to you, so we can't do anything. They threaten me all the time.
So we're going to cross that bridge when we get to it. I know you're fearful of it now, but nothing has happened to where you're in fear based off past history and what they think of you and how they threaten me all the time. Do you have proof, or is it all verbal? Like, would it be in your phone?
No, it's verbal.
Okay.
It's verbal.
So it's he said versus she said, or she said.
Yeah, they've been really nasty to me. Really nasty to me.
Well, do you have proof of it in your phone? Oh, no, it's verbal. It's verbal. It's all verbal. Because it has to be verbal. And then she wants you to act like verbal is a full-blown admission and confession. And she says your last time he was under oath and he didn't submit it. How do you know? He just said that he never heard back from them. So he resubmitted it again this past Friday. And if that's a lie or not, that's his business. However, he has an answer to that. You have no proof he didn't. In the 2 weeks you just pulled out of thin air, maybe she brought up the number of 2 weeks in the hearing. And she does that a lot too, of if she brings up her own version of events and she gets anything that's even somewhat on her side, then that means they adopted her entire answer. She said 2 weeks and then the judge told you that you need to submit it. So obviously, Linda, exactly. It's because whatever number she comes up with in her head is the number that the judge said. Oh, bars? And this is just a pattern that we've seen repeated time and time again with her. You can just imagine how she was on the outside. However, now you're actually saying it in front of a judge. You like using the judge and you like threatening people with the judge. Do I need to tell pretend judge this?
It doesn't matter how dumbed down I am to myself to try to coexist with her. I've even come up with a solution to have a pretend judge in the interactions with her, so she would try, hopefully, to treat me appropriately and professionally, which she does not do.
I added pretend judge to our interactions so she could calm down and ease up on her condescension. Do I need to go to the judge? You realize this is why we need to go to the judge, Brian, right? Because you won't cooperate. Is it because I'm trying to send all of my documents to the judge about you that you are not allowing me? I ask as many times as needed to finally get an answer. If not this way, which would be more simplistic and less time consuming, especially for you in Gainesville, than in court where you can answer everything when the judge asks you or orders you to answer? Don't you think? The reason for a very needed court date is simply over you not cooperating. You understand that, right? And now that we're in front of the judge, you keep trying to pull the same manipulation tactics, and she's gonna smack that shit down every time.
I specifically put in the order because there was no motion at the time. We did address it, and I did want there to be note that we addressed it, but there is no specific order requiring Mr. Boone to do anything by any specified period of time. And by law, because there is no order, I cannot hold him in contempt.
Bon appetit.
For failing to comply with an order.
Is there a way that, it's been 9 months that I've been asking from him to submit these visitation applications. There's no legitimate reason for him doing so. And I don't have any record of who he spoke to supposedly when he did try to contact DOC, and then also a confirmation that he's done it this time, 9 months later and under oath. How can I go about doing so to make sure that this is actually being done?
All right. With that, I am going to deny without prejudice the motion for contempt.
Yeah, double homicide.
Damn. She completely sidestepped that and said, excuse me, skirt, that is not what we are here to do. I'm going to deny the motion. You submitted a motion for contempt. That is what we were discussing. There was no time limit in the order itself. You were allowed an opportunity to respond. There's nothing you could have responded to. So literally anything you said would not have changed the outcome. However, she did say, I'm going to deny it without prejudice. Without prejudice means you can refile it in the future if you do it properly. Linda is locked in today because you are absolutely right. She has had this misconception of judges in general since the beginning. She thinks the judge is there to solve her problems. No, they are there to mediate and apply the law constitutionally and fairly. They take what is in front of them. They cannot add context or facts that you did not put in there or allow room for them to add. That's why you have little things like, and also provide any relief that you deem just and proper, giving the judge that authority to do whatever they want. Otherwise, they can only go by what is presented in front of them. Okay, we have to move on.
I do not find that there is any willful violation of a specific court order with regard to a visitation application. All right, there was another motion that was filed by you, Ms. Boone, respondent's motion to appear in person for trial that was also filed on August 20th. I will hear you on that motion.
Obviously, since she's on the telephone, it didn't work out for her, but I never read this on this channel, so let me just read that motion real quick and we'll pick this up. Respondent's motion to appear in person for trial. Comes now pro se respondent Sarah K. Boone and respectfully moves this honorable court to issue an order for her transport to rightfully and properly represent herself by being included in person for the final hearing in her family law trial on August 25th, 2025. In support of the respondent's request for equal, full inclusion, 1. Respondent has been ordered by the court without hearing, July 28, 2025, to appear and participate telephonically in this trial due to her incarceration. 2. By, quote, appearing via telephone for this trial, life-changing trial, the respondent's rights and position are heavily impaired, increasing an unfavorable outcome in her self-representation by being excluded in the courtroom with all other parties, and which she is and should be included as such. 3. In-person representation is crucial for the respondent to ensure meaningful access to the court by having the ability to present evidence for her defense, cross-examine witnesses, respond appropriately to arguments made by the petitioner, and accurately perceive the dynamic of the courtroom as a whole. 4. As a self-represented, pro se, litigant, the respondent is at a significant disadvantage when, quote, appearing by phone, especially in a complex trial setting where immediate review and understanding of documents, real-time responses to developments as they arise, communication with the court, presentation of exhibits, observing the opposing party's demeanor is necessary. It is essential for her to engage in all court proceedings for this trial. 5. Remote participation impedes the respondent's ability to fully advocate for her position and interest, particularly given her documented difficulties in accessing legal materials, submitting and receiving documents from the court and opposing counsel, and communicating effectively from within the correctional facility. 6. The respondent's physical presence and participation greatly minimizes the risk of technical difficulties, which can delay, interrupt, or obscure communication, and allows the respondent to interact directly, clearly, timely, preserving the court's invaluable time. 7. The respondent's transport to the court and proper inclusion in the courtroom serves the legal interest of due process, increasing her ability to be rightfully understood as a serious and committed party in this case in respect for the court, ensuring fairness and justice under her extraordinary circumstances. The Florida and United States Constitutions. Wherefore, pro se respondent Sarah K. Boone respectfully requests from this honorable court to enter an order for transport to fully have the ability to represent herself in this family law trial, and after her continued determination, eagerness, hard-fought effort to do so for a hopeful legal and just outcome for over five years. Respectfully submitted this 8th day of August 2025, Sarah K. Boone. Oh my gosh, everything is so loud around me. That is aggravating. Hope whoever's in trouble is okay, but not as aggravating as this motion. No, I get it. You want to appear in person. I didn't think they'd have you by telephone, but also this isn't a criminal trial, so they are not held to the same standard to make sure you have all the access in the world. Communicating by telephone, I'm sure, is rough, but it doesn't impede your access to the court. As we see right now, we can hear you clearly, you can hear them clearly. You being able to observe the body, the demeanor in the courtroom doesn't mean anything. I guess it would help you understand when you're going to flounder and to stop and be quiet. But that's never been your style. Even when you were in the courtrooms, you acted the exact same way. But she's just going to use this as an excuse to say, this was so unfair. The only reason I'm so disadvantaged is because I wasn't in the courtroom to manipulate you myself. You only got to hear my lies. You didn't get to see my pouty little sad face.
Well, I'm on the telephone, so it does me no good at this point, Your Honor.
All right, are you withdrawing that motion?
I am.
Thank goodness. I mean, we knew she did because there's like 3 hours left of this trial, but she could have made a huge stink about it and said, no, I need to be in that courtroom. I haven't been heard. There was no hearing. You made me go on the telephone. I wasn't prepared.
Sometimes I'll start a sentence and I don't even know where it's going. I just hope I find it along the way.
The judge probably still would have denied it anyway, but there is a future where she could have paused everything or postponed it in order to have you transported. Who knows?
All right. All right, hearing that you're withdrawing that motion, I'm going to deny that motion as being moot.
Bon appetit.
Now we can move on to, with regard to the petitions that we're here on today. I'm going to start with the petition for relocation. Ms. Boone, do you oppose the petition for Mr. Boone to relocate with the minor child to?
I do not oppose.
Well, I'm sure you don't, but this is the first time you ever said it. You've been in opposition for years over this move, saying, how dare you? You're just assuming. Because she got so mad, he said, well, we're going to be closer to the prison. Told me, when you're finally put away, this move will be the best thing to happen to us. Him, son. We can't wait to get out of Orlando and away from you. Laughing. Also, where we're moving is very close to the prison. It's going to be very easy and convenient for us. And she could not believe anyone would even conceive that she would be sent to prison for the rest of her life.
Court sentences you to life in the Department of Corrections.
Yet here we are, and now she has no issue with them moving. We knew she wouldn't, but I'm pretty sure this is the first time she's officially acknowledged that.
All right, hearing that there is no opposition, I'm going to adopt the findings from the, I believe it was February 2023 order, finding that there was a substantial change in circumstances that necessitated Mr. Boone moving the minor child to, and hearing no opposition to the motion, the petition for relocation, I'm going to grant that petition.
Your Honor, am I allowed to say anything in regards to the contents of?
If you're not contesting it, I don't need to hear anything about it.
And Sarah is not going to understand anything about this whole trial of, this is not a conversation. Once things have been ruled on, we are moving on. You don't get to just pick apart some of it. If you agree to the relocation, you agree to the relocation, and we keep going. You don't get to say, well, I didn't like in there how they framed this and framed that. Okay, next.
I am contesting some of the points that they have in regards to some of their other motions and modifications. Just things that I would like to apply to it from this motion.
All right, the petition for modification is solely for Mr. Boone to move to with the minor child. Are you opposing him moving to with the minor child?
Your Honor, you said the petition for modification, the petition for relocation.
Excuse me, the petition for relocation. We're not dealing with the petition for modification just yet.
Okay, no, I do not oppose the modification for relocation.
All right, so as I stated before, I'm going to grant the petition for relocation, petitioner's verified petition to relocate that was filed on February 14th of 2023. All right, that puts us to the petition for supplemental petition for modification.
Your Honor, if I may just have one question about the relocation petition.
Okay.
Does Ms. Boone also agree to adopt the proposed amended parenting plan that we submitted in regards to the relocation? Because that is still...
Okay.
I just need to know if I need to present evidence as to that point.
All right, so we will hear evidence with regard to the parenting plan as it relates to both the verified petition to relocate and the supplemental petition for modification. All right, do we wish to have brief opening statements?
I would like the opportunity, Your Honor.
All right, so Ms. Boone, I'm going to hear brief opening statements first from the petitioner, and then I'll hear your brief opening statements. And again, we're only dealing with the issues on the supplemental petition for modification of alimony and child support. And I believe also you all wanted sole parental responsibility, is that correct?
Yes, Your Honor.
And then also the proposed parenting plan with regard to the relocation. Okay, once counsel for petitioner has done with their opening statement, I will give you an opportunity to also present an opening statement, and then we'll go right into evidence, okay?
Yes, Your Honor.
All right, I will hear petitioner's opening statement.
Do you mind if I go to the podium here?
You may.
All right, well, good afternoon, Your Honor. We're here today, as you've already outlined, on a petition to relocate and a petition to modify. I can cut out a lot of my opening statement because it sounds like Ms. Boone has agreed to the petition to relocate. What the evidence is going to support and what we are going to present evidence on regarding the parenting plan for the petition to relocate is that we are proposing that Ms. Boone have a 1 monthly visit with their 14-year-old son at the correctional facility that she's located in Marion County, and that she be also entitled to a minimum of 1 weekly phone call with the child. And we are also asking for sole parental responsibility regarding the day-to-day, or not only the day-to-day decision-making regarding the child, but also all of the decisions related to the child. We believe the evidence in this case, considering what has transpired since February of 2020, would support a order of sole parental responsibility when it comes to parental responsibility. I think the most contentious part of this case, Your Honor, is going to be the discussion regarding whether or not Ms. Boone is owed money.
Send me money, send me money, send me money.
Our position is that, Your Honor, actually Mr. Boone is owed money, but he's willing to waive that and just to have both parties owe each other nothing moving forward. What evidence is going to show, Your Honor, is that since February of 2020, Ms. Boone has been incarcerated. She was charged and arrested for second-degree murder.
Why is this happening?
Because George is dead.
And has since been convicted.
We, the jury, find the defendant guilty of murder in the second degree.
By a jury of her peers of second-degree murder in December of 2024.
Juror seat number 1, is this your true and correct verdict?
Yes, it is.
Juror seat number 2, is this your true and correct verdict?
Yes, it is.
Juror seat number 3, is this your true and correct verdict?
And she is serving now a life sentence.
Ms. Boone, court sentences you to life in the Department of Corrections.
Since February of 2020, Mr. Boone has been 100% financially responsible for their now 14-year-old son. At the time that Ms. Boone was incarcerated, what evidence is going to show is that Mr. Boone stopped paying the $1,000 per month of alimony and the $100 per month in child support that was ordered pursuant to the June 15th, 2018 final judgment of divorce between the parties. Mr. Boone will testify, and evidence will support that for multiple years after The respondent was incarcerated in February 2020. Mr. Boone continued to give Miss Boone financial assistance in the form of commissary payments, other payments, and also maintained a mini storage for her for multiple years after she was incarcerated, despite having absolutely no legal obligation to do so.
Oh, so now it's official that he was the one who was taking care of the storage unit. We know that he had access and was putting stuff in there. I didn't know if she had a storage unit from beforehand, you know, after she moved out from their house originally, and then she just gave him all the stuff and asked him to take care of it. But it sounds like he got the storage unit to begin with, and then was paying for it and had all her stuff in it, and then said, I'm not doing this. He has had and will always have absolutely zero legal obligation to help you with your personal property after you get in prison for life for murdering someone. These are all you issues. He was nice enough to take it on in any respect or capacity, but he was never obligated to, and you treated him like he was. If you treated him like he was doing all the favors that he was doing for you, then you wouldn't be in this situation. Because for some reason, people seem to have so much nerve, I don't want to say empathy, but it feels like nerve is correct, to deal with you and allow you to get away with all this stuff, that he probably would have been fine if you just weren't berating him daily about where's my personal property, where's my storage unit, let me put it in these motions to try to get you in trouble, as if you weren't doing me a favor. And she tried to make it sound like, well, it was a verbal contract. You agreed to take it voluntarily and without any cost. You need this in writing. And if you don't have it in writing, then this is not a verbal contract. Why? Because for verbal contracts normally to be binding, both sides have to get something from it. He's taking care of all your stuff. In my mind, I thought all of this would originally offset the alimony payments, but nope. She's here saying he never paid me anything ever. He did all of it out of the goodness of his heart, and now he's legally obligated and responsible for my property. If he did it out of the goodness of his heart, it was a favor, and that's on you. If you had said that our trade-off was he was going to keep track of my personal property in exchange for subtracting that from alimony payments, and then he stopped doing that, that's when you can start to demand the $1,000 again. But you were demanding that on top of absolutely everything that he did for you. She will never truly know all the things she had until it's finally taken away, which is about to happen.
To maintain that mini storage. What evidence is going to show is that when she was incarcerated, actually, Mr. Boone helped her remove her stuff from the apartment that she was living in at the time, and was really one of the only people that assisted her during that time and acted in good faith to help the mother of his child during that time period. What Mr. Boone is going to testify to is that throughout that time period, he averaged about $600 a month in direct payments to Miss Boone and also in-kind payments towards expenses that should have been Miss Boone's obligation. Also, what evidence is going to show is that since February of 2020, Miss Boone had approximately a $370 child support obligation to Mr. Boone. And the reason why we believe evidence will support this is that under Florida Statute 6130, subparagraph 11, subparagraph C, despite the fact that the petition to modify was filed in April 12th, 2022, that the court is within its authority to modify child support retroactive to the date a parent first failed to exercise their time sharing pursuant to the final judgment.
Exactly. Something she has never acknowledged, nor does she care. She doesn't care that she was only receiving child support, $100 a month, because she had equal time sharing with the father. And that without having the child, that means she had the obligation to support him. The fact that he still had to keep paying her, or at least put the money in another account as if she did have the child, is wild. But in real life, if you miss your time-sharing obligation like that, you now owe your own child support obligation, which she's going to completely ignore and say, well, I was incarcerated. I didn't choose to be here, so I shouldn't have to pay. I have no money. What am I supposed to do? Well, how about you give up the money that you keep begging for? But Sarah will want you to ignore that, and she will ignore it. I can guarantee she's not going to bring up her own child support obligation in this entire trial, and will get mad when you do.
Ms. Boone, pursuant to the final judgment, had an equal time-sharing schedule, and then, of course, in February of 2020, that time-sharing went down to 0, and she had 0 overnights. She's had 0 overnights ever since. So therefore, the court can go back to February of 2020 and consider what the child support obligation should have been, considering that she did not exercise her time-sharing, and give Mr. Boone a credit for what the child support should be, and we'll be presenting evidence as to what we believe that number should be, imputing minimum wage to Ms. Boone and also imputing $60,000 a year of income to Mr. Boone, despite the fact that he's currently unemployed. Also, Mr. Boone, since Ms. Boone was incarcerated in February of 2020, has accumulated over $14,000 in attorney's fees.
Yeah, double homicide.
Bitch.
I'm sorry.
Trying to modify the final judgment and trying to be able to successfully relocate his son to Gainesville. This morning was the first time that Ms. Boone has made any concessions regarding any of the outstanding motions that were filed by Mr. Boone and the petitions that were filed by Mr. Boone, despite having really no articulable argument against the relocation. And the court should note that in the order on temporary relocation that was entered by a predecessor judge in this case, articulated that Ms. Boone, even at that hearing, seemingly had no articulable reason to object to the relocation, yet she still has forced this final hearing and forced Mr. Boone to incur attorney's fees for another 2+ years while we continued to litigate this matter.
Exactly, because at any time she could have withdrawn her objections to the relocation and they could have just gone about it. She could have just signed it away, but no. The judge ordered it to be temporarily allowed, and she even said in all those things or whatever, the order to relocate is temporary. I'm not going anywhere. You're taking my son 150 miles away. How am I going to get my life back together when I'm freed from murdering someone? Please provide the permanent documents, full custody and suspension of child support former husband's attorney was instructed to forward for your modifications, Your Honor, to temporary as requested. After I was able to explain my circumstances with having no money or family to hire an attorney once I am released,
Court sentences you to life in the Department of Corrections.
And my desperate need to be fully and completely reunited with my son ASAP.
Life in the Department of Corrections.
You graciously made the decision to make everything temporary. Thank you. And now that she's not free, she's like, well, obviously I don't object to it. However, the temporary relocation is now done and we have to make that permanent. So it has to be brought up here again. So I can see how that could be annoying, at least enough to mention of there's no reason that she had for us to not move in the past. The only reason she did not want them to move is because that admitted that she was guilty, or that meant that she was going to be found guilty, and her personal big girl feelings got hurt. So she decided to make him hire a lawyer in order so he can legally bring his child to safety, which is as far away from you as possible.
So another thing that we believe evidence will support and what we're going to be requesting here today is that the court take into consideration in its equitable powers the amount of attorney's fees that Mr. Boone has incurred to fix basically all the chaos that occurred due to Miss Boone's voluntary act, criminal act, and also her ongoing defiance and unwillingness to acknowledge the reality of her situation and the reality of this family's situation, which has had a direct result in Mr. Boone having to incur tens of thousands of dollars of attorney's fees. And so if there is, even after the consideration of the payments that were made to Mr. Boone, from Mr. Boone to Miss Boone during the period after February 2020 moving forward, the retroactive child support that Miss Boone ordered, if there still is potentially a retroactive alimony amount this court is considering, we are asking that the court also, in its equitable powers, consider the $14,000 in attorney's fees that Mr. Boone had to occur, and that the court would apply that to any potential technical arrearage that Mr. Boone might have. And when we say technical arrearage, Your Honor, technically speaking, while child support is retroactive can be retroactive to the date that a parent stopped exercising their time-sharing, alimony modifications are only technically speaking retroactive to the date that a petition to modify was filed. And so we're looking at that basically 26-month time period between February of 2020 and April of 2022 when modification was filed. It's also important to note, Your Honor, that evidence is going to show from the date that that petition was filed moving forward that it is appropriate to terminate Ms. Boone's alimony obligations, obviously, or alimony award, because she has no need for day-to-day living expenses when she's incarcerated and having the state pay for her day-to-day needs. And so it is appropriate to terminate alimony from April of 2022 and also to give Mr. Boone a credit, and we'll be presenting evidence on that. Also, we're going to be presenting evidence, Your Honor, as to a sum of money that is currently being held with the Orange County Clerk of Court. It's over $4,000 in child support and alimony that's being held that has not been released to Miss Boone. And we're asking that the court order that money be released to Mr. Boone so that he can use it to help raise their child that now he is unfortunately having to raise completely by himself, both physically and financially. Lastly, Your Honor, there's been some motions filed, and this was mentioned in Ms. Boone's pretrial memorandum, so I'm assuming it's going to be brought up here today. Ms. Boone is alleging that Mr. Boone is unlawfully in possession of some personal property of hers.
Immediately upon the respondent's incarceration, Petitioner took possession of her vehicle directly from the sheriff's office and secured at the marital home. After verifying the placement and safety, he verbally promised the respondent to manage, and both parties mutually agreed upon him taking full responsibility of her property while her case was in progress. Petitioner also proposed and coordinated a storage unit where her belongings from her townhome were placed and secured. She repeatedly inquired about her personal property from the petitioner to ensure protection during, including setting up other arrangements at no cost in case the petitioner refused and discontinued to cooperate in paying his obligated alimony to cover. Petitioner would continuously tell respondent to, quote, not worry, quote, I've got it covered, quote, nothing is going to happen to them, quote, it will be taken care of. When she would ask for a status update to make sure he was really doing as promised to save her last ultimate resources and generational legacy to share with her son. Respondent felt the petitioner was being untruthful after not receiving any updates other than the aforementioned for years, and coordinated turnover of her vehicle's keys, locks, and keys for storage with information to be given to her brother, who lives locally, for safekeeping and to provide relief for petitioner, peace of mind for the respondent. After concerned repeated efforts and no-cost solutions by the respondent to acquire her personal property, keys, etc., petitioner finally stated, quote, the keys were lost in the mail. Since this last statement made by petitioner, respondent utilized her outside resources to locate information for this case and possibly filing an unlawful disposition suit against him, found out her vehicle was scrapped, junk salvaged, and storage unit auctioned off due to abandonment. What? Respondent made every effort to save her personal property, provide answers, multiple solutions, and arrangements to the petitioner for these to be successfully taken care of and protected during her incarceration, after petitioner promised and continuously assured her would be. Petitioner had legal duty to return or inform respondent before disposing of or abandoning her property and should lawfully be liable for total cost and damages of.
There is no court order that Mr. Boone is in violation of regarding that.
What?
But here's what evidence will support, and here's what Mr. Boone is willing to do, is that he does have, when he finally stopped paying for the mini storage, Your Honor, he did move items out of the mini storage to his home that are Miss Boone's personal property. He still has those items there, and if Miss Boone has any relative that wants to pick those items up, he has them packed in boxes, and he will be testifying that he has no objection to releasing those items to a family member of Miss Boone. Thank you.
Solid, clear opening statement. Couldn't ask for more. The case really is this cut and dry. Just like the criminal case, she is an enigma herself that makes very simple situations seem like the most complex escape room imaginable. The issues are never that deep, despite her endless objections to the contrary. In her criminal court case, you killed him because you admitted that you zipped him in there and you filmed yourself right afterwards, acknowledging that you did so. But she can't believe you won't make that situation more complex than it is. And we see the same thing in this case. He should not be paying you alimony after you have been imprisoned for life.
To life in the Department of Corrections.
After murdering someone. He should not pay you child support, as you will never have custody of that child again. He should have sole parental responsibility since he has sole 100% parental custody of the child, and having to wait and balance and check in with an inmate who has only demonstrated a pattern of non-compliance and being more difficult unless you make her, in her opinion, the most important, correct, best things out there. Of course, he shouldn't have to go through that. Yet, here we are. It's been over 5 years, and she's been drawing this out as though she has been a parent on the outside, just as involved and entitled to how Mr. Martell puts it, the benefits of parenthood. But we're all aware how simple it is. Now let's see how complicated she tries to make it.
Before you begin, Ms. Boone, am I understanding that petitioner concedes there is 15 months of alimony that should have been paid, and so there is a amount that's owed, I believe it's $1,000 per month, so that would be $15,000?
Well, we're going to be arguing that he did make other payments if Mr. Boone's going to testify that he made payments to an average of $600 a month during that period of time. So
we're agreeing that he did not make $15,000 worth of direct alimony payments that were ordered pursuant to the final judgment.
That is correct.
Okay. All right, Ms. Boone, would you wish to make a opening statement?
I will do my best, Your Honor.
I'm sorry,
Thank you.
say that again.
I said I will do my best. Thank you for the opportunity.
And she's already trying to get the sympathy card. I'll do my best. Thank you for the opportunity. Sounding like she didn't know this was going to happen today. But I get it. She's mad she's not in there, and she's mad that they didn't appoint her a free lawyer and do this and do that, whatever.
All right, you may call your first witness. Oh, I'm sorry. You said yes. I'm sorry. It's hard to understand you.
Yes, I would like to make an opening statement, please.
Okay, you may proceed.
See what happens when you answer a question properly? People know what you actually mean. So when she asks you the first time, do you want to make an opening statement? And you're like, boop-a-doop-a-doo, well, I'll try my best, thank you. Is that a yes or a no? We don't know. She was about to move on to his witnesses. Then when you finally say yes, you get to go.
First off, I would like to say that I am having to represent myself. I am pro se. I am not an attorney. I am not educated. I have not gone to school.
What?
And I'm doing my best with the limited resources that I do have. And also when the petitioner and his counsel decided to include me on documents and whatever exhibits and evidence it is that they are proposing that they have to present to you while in the courtroom and I am here on the telephone.
Is the pause for dramatic effect supposed to do something? Yeah, we got that. That's so weird. Like, you're at the trial. You are there to convince the court. She's right there. She knows all this. She knows you're representing yourself pro se. She knows you're on the telephone. And yes, she will give you little brownie points for that. Not really, but like leniencies towards that. But when you try to shove it in people's face, it makes people want to do less and less for you. But it's what you do.
I also would like to say, please, Your Honor, that the evidence that they are trying to hold against me in regards to the $600 storage unit, the $370 child support, the attorney's fees, a lot of these things could have boiled down to simple communication. Would they have taken advantage of any of the mediation opportunities that were presented by the court? That a lot of these could have been resolved, including the temporary location that could have been discussed and proposed and agreed upon. Also, another opportunity could have been had in the mandatory attorneys meeting and unrepresented party meeting that we were supposed to have pre-trial conference before that. And again, the defiance is not in myself, as I have been 100% transparent, cooperative, and trying to do my best with whatever it is I can in order to prove my side and the truth and to show my adamant intentions of being included in my son's life and trying to prove what it is that I have been legally entitled to in regards to alimony and any arrears attached to that.
Well, that was a mouthful. That went nowhere, as per usual. Saying the evidence they're trying to show with the storage unit, the child support, the attorney's fees, this could have all been solved with a simple conversation. How? How is a conversation going to offset the attorney's fees, the money for child support, and the money for the storage unit? You have never once indicated that you are okay with them not paying that, or that you were going to pay that and compensate him for what he has done in the past and what you still asked him to do present and in the future. So no, a simple conversation would not have fixed that. You think that if you just had this, quote, mandatory attorneys meeting, which, you know, what I will say is it would have fixed the temporary relocation. They could have come together and agreed, okay, we don't need to bring up the relocation in the trial because we agree on that. That is what could have been resolved at the meeting. But the things that actually had to deal with money that's in the balance, a simple conversation was not going to change that. You were going to have to concede to things, and if you were not going to do so, we were going to end up right back here again. Because I think she believes that if she had the conversation, she could convince him to convince/guilt him into keep paying for all these things for her. Because he's done so in the past, and she would have been like, I'm the mother of your son. And she says, the defiance is not on me. I have been 100% transparent and cooperative to prove my side, ... and the truth, because the truth and her side are not the same things. And regardless, she's not trying to prove either. She never really proves her side. She just wants to say, I have a side, and you should give me what I want because I said so. You have not been 100% transparent, because how many times have we brought up this example, which I imagine is going to come up multiple times in this hearing, and it's because of the fact she keeps circling saying that the petitioner didn't do anything with mediation. They didn't take any advantages of the mediations that were offered by the court. The court didn't offer any mediation. The court said that you all can have a mediation on your own. You can schedule it. We can put this on the docket, but it wasn't the court that was the one who was doing the mediating. The court said, cool, y'all are going to do this, figure it out, and come back to me when you've gotten that figured out. And They came back and said, hey, we tried to set up a date so that we could do this. She did not want to cooperate whatsoever, regardless of what she says. She refused to be the least bit cooperative with what they were asking. The fact that all they did was ask her for some dates of when they would be able to meet to go over this and to have the mediation. But Sarah always has to get the guilt trip, the woe is me type thing. So it's the I have cancer, there's no way I can do this, woe is me. We shouldn't even have to do this to begin with. You should just automatically give me money and be okay with paying for everything until the end of time.
Mr. Martell, I am in receipt of your letter requesting a date to be set for former husband's petition to modify, but have a few concerns and questions before doing so. First, I would like to make it known I have been diagnosed with cancer and am awaiting outside professional medical consult and treatment options. I do not know the level of severity, duration of time, or outcome for any of this, nor the effect it will have on my case, which I am currently incarcerated for, or the case at hand with former husband. As said in my previous letter, no one has a crystal ball. I do not know 4 months in advance my location or status, making it impossible to determine the best date to choose from which you have proposed. 1. What are the requirements under Florida law stating a mediation needs to be scheduled for the petition to modify, other than a letter from your firm telling me what I have to do? Is the point of this mediation to try to force me into signing or agreeing to the only terms available presented by former husband? Or are my modifications going to be allowed for discussion also in order for both parties to be included in the final agreements for and with the best possible outcome? 9. What if I do not agree? As said, I do not know what date is best for me considering my current situations and now health complications. By answering and explaining further the aforementioned concerns and questions will most definitely assist in my decision making. Your expedited response is greatly appreciated, as well as providing all requested documents and information.
Yet in her world, none of that was defiance. That was her being transparent and trying to cooperate in every way imaginable. And it's actually the petitioner who's not cooperating by giving her absolutely everything she asked for and yet again was not going to pay for. So there's always going to be a reframe of, regardless of what you do, what you give her, what opportunities you try to make available, she will always deflect and redirect. If you had the meeting and you still wanted her to pay or wanted to not pay her, she would have said, well, they didn't take advantage of the meeting. I went into the meeting trying to be as cooperative as possible, trying to come up with solutions for everything about anything, and they just wouldn't do it. I told them I need $67,000 and they said no. What else am I supposed to do besides take us to court and then complain in front of the judge saying it's all unfair and da-da-da-da?
Sometimes I'll start a sentence, and I don't even know where it's going.
I just could never imagine writing those letters and then having the audacity to say in open court, I've been cooperative and 100% transparent. You have been transparent in your demands. Transparency does not equal cooperation. And it's all to try to prove your side and the truth. It should never be this difficult to prove the truth. And so then she tries to dilute all of this into, because I'm trying to show and prove my adamant intentions of being in my son's life and all the things that I'm entitled to lawfully and the arrearages. You can't forget about the interest I'm also owed. It's not enough for me to try to take $67,000 from my son's household. I need the taxes on top of that. I need the interest on top of that because I'm entitled to that after killing someone.
The defiance is coming from the petitioner and his counsel by not abiding court-ordered payments and any other court orders in regards to the parenting plan and anything else that the court has proposed as of the official divorce. And that's including also attorney fees, which are self-inflicted when they have been truthful and ethical in providing the proper paperwork in a proper amount of time so I can actually review and correspond timely with the correct
All right,
information.
Ms. Boone, you're way off base here. I need to know an opening statement is kind of a outline of what you intend to present at trial on the issues regarding the parenting plan proposed for the relocation and the modification of alimony and child support.
Thank you, Honorable Judge Jackson, for putting an end to this never-ending rant, because she has no idea what an opening statement is. She thinks this was just her time to air every grievance imaginable, as if that's how the court system works. She's been going through the court system for over 5 years now, arrested George 5, 7, a million times beforehand. She is very familiar with how court systems work. She just refuses to abide by standards and just freestyles, says whatever she wants, and says we need to be on my page whenever I say we are. Saying they're not following any of the court orders since the divorce. Yeah, and you didn't follow the orders of law in not killing someone, so things change. I never understand that, because how can you be the one to commit one of the gravest atrocities a human is capable of inflicting upon another human? Death, murder, killing them. Yet with your whole chest, you can point the finger at someone else and say, how unlawful, how unethical, how dare they not continue to pay me? I mean, we didn't put in my order of dissolution marriage agreement that I can't kill people and still get money. So if that's not written in there, then you're the one breaking the law. And this is completely unfair. And all the attorney's fees are self-inflicted. So is your life sentence.
Ms. Boone, court sentences you to life in the Department of Corrections with credit time served.
Your life sentence is completely self-inflicted. Yet you want us to act like this is all happening to you. You had no control over this, and thus are not bound by any of the losses and the consequences you have to face because of your intentional actions.
Well, if it isn't the consequences of my own...
Intentional.
Actions. What's up?
That's what you've shown. You want to show your adamant intentions to be a part of your life. You should have shown those adamant intentions to keep George alive, but you didn't. You showed your adamant intentions to keep him locked in there, laughing at him, having the best time of your life while his life is dwindling before your very eyes. Yet that means nothing compared to the injustice you are facing by not getting money you never earned.
Is my motion for contempt also included at some point?
No, ma'am, I've already dealt with the motion for contempt dealing with the application. Again, I told you what the issues were that we're here on today. You may continue, but let's talk about those issues. What do you intend to present as your evidence and your position regarding the relocation proposed parenting plan and the modification of child support, the modification of alimony, and the request for sole parental responsibility? Those are the issues that we're dealing with right now.
Yes, Your Honor. I was asking in regards to the motion for contempt in regards to alimony that does not have a judgment and has been continued up to this point. That was my question for the motion for contempt.
All right, ma'am, continue with your opening statement.
Oh, I love this judge so much. Just instantly put an end to the BS. Well, is my motion for contempt going to be decided? Since you won't let me air my grievances out, I need to make sure that my grievances will be aired out. And she said, if you don't move on, that is not why we are here right now. So please continue.
Has the court received my exhibits, please, Your Honor, that I sent?
We're not talking about exhibits right now. We're talking about your outline, your overview of what you intend to present to the court today.
What my case law and my exhibits that I'm hoping that you all receive.
You can continue with your opening statement.
Other than what I've actually already said, Your Honor, I'm not sure what I'm supposed to be doing, to be honest with you. So
I'll stop for just a minute. Let me give you some guidance, okay?
Honorable Miss Jackson is nicer than me.
I'm sorry, Miss Jackson. Ooh, I am for real.
Because I would have been like, okay, bet. Brian's lawyer, call your first witness, because this is just going to go in circles anyway. But I don't know why she is so confused when she literally just went through an entire trial a year ago and had to go through all of these processes, like all of this before. You've seen opening statements by both the prosecution and defense, and now by Brian's attorney as well. You know what this section is for. You came in with an agenda and grievances you wanted to air out and accusations you wanted to make, and the fact that this is going out of order and you can't just wildly make them is throwing you. So the judge is going to try to offer you some guidance. I can guarantee you I know that's right, Linda. I said, I know no matter what guidance your Honorable Miss Jackson gives, it's still going to fall on deaf ears. And she's going to act like you didn't give her any guidance whatsoever. And everyone's just floundering and letting her fail at the
Sometimes I'll start a sentence.
They are requesting that you have one visitation per month with the child and one phone call per week. What do you intend to ask this court for as far as contact with the child?
Okay, yes, please, if you don't mind, I'm going to pull that from my pre-trial statement.
Oh Lord, not this pre-trial statement, this 33-page manifesto of a pre-trial statement. And I'm going to go ahead and call it right now. She's going to use this for probably 90% of her answers because she didn't write it. She had her little flying monkeys, her friends outside of it, type it up, print it, fact check it, poorly apply case law, just putting the name at the bottom, because she definitely didn't do that herself. And it's just like in those prior hearings where she told Kranick, well, I have my 58-page letter because it's easier for me to write it out to you than to tell you.
Thank you. I actually have an envelope, please, that I would like to give to you regarding a letter. It's a lot easier for me to tell you in writing, and it's also put on the clerk of the court's website, so everyone is aware.
Where is the letter? Okay.
I believe it's 58 pages.
Meaning you don't actually know what you're talking about. You just know how to hide behind a pen, behind a keyboard, and behind words you don't think you have to back up. But now that we're in person and you have to back up these words, it's just going to be a mess. It's going to be like watching a student who plagiarized an essay try to give a book report on it.
Thank you, Your Honor. My request that I put in my pre-trial statement were to have daily telephone calls, if I would like to have them, with my son, which he would like to have as well, personal space, and funds already added to the phone, so there's no interruption, please. Tablet credit, so he and I to be able to correspond with one another and utilize the features of the tablet to stay in communication. Virtual visits on the kiosk. The in-person visits, I put 1 to 2 per month with a maximum allowable time afforded by the correctional facility, please.
You're saying 2 in-person, hold up, stop. I just want to make sure I understand. You're requesting 2 in-person visits for the maximum time allowed?
1 to 2.
Just pick one. Just pick a number. Just say 2. If they're already proposing 1 visit a month, then just say you agree to that aspect, or say you want 2. Why say 1 to 2? That means they could do once a month forever and still be following your set parameters, when in fact, you know you want 2. So just say 2.
Okay. Okay, you can continue. I just wanted to make sure I understand you. Go ahead.
Yes, Your Honor, thank you. I would like to be included in all holidays, including schooling holidays and any other time a minor child would like to include me.
Future me cut in. I'll do that from time to time whenever I want. Anyway, this one always annoys me more than anything. That's a lie. I'm going to say that exact quote so many times during this video. But being included in all holidays is absurd. She really said, watch out, Yom Kippur. I need to call you in advance of the Chinese New Year or else my whole year will be thrown off. How else am I going to prepare for our visit on Eid? I mean, I have to call you because you need to tell me what you ate on Juneteenth and if Cinco de Mayo is on a Tuesday. What? It's just absurd, right? Even when you had custody on the outside, not in prison for
life in the Department of Corrections.
You didn't have every holiday with him. Y'all alternated them. So why would you think, you know what, now that I'm locked up,
life in the Department of Corrections,
I'm really going to go for it and take all holidays. Also, just how selfish is that in general, that every single time you're allowed to have a break and celebrate, I need to be included. No matter what, you must include me. Even if I yell at you for days on end telling you you're a terrible former husband, you're a terrible son for not loving me enough, I still need to be included on St. Patrick's Day or there's going to be a problem.
I would like to compel the petitioner, please, to include me in any decision-making regarding the minor child. To enforce communication, regular correspondence of the petitioner with me in all available options, including phone calls, tablet messages, letters, third-party representatives, any manner necessary, please, that I request, so we can communicate between one another, which has been a huge problem in this entire process.
Third-party representatives is crazy. What? That is absurd. Like all the other things, I mean, it's still a crazy request, but whatever. Putting third-party representatives, strangers, in there is wild because you like to just throw around legal concepts and words. If they're your legal representative, they need proof of that. Are they your lawyer? Are they your family? Do they have power of attorney over you? How are they your legal representative to justify sending a serial stalker to this man's house because he won't answer a phone call? Nasty work.
And to please keep the respondent, myself, updated regarding the minor child's proposed vacations, appointments, meetings, any happenings in his life so I can be included. To please enforce perpetual cooperation of the petitioner with myself in order to simplify, relieve, prevent ongoing and future problems for myself and the son. And please to stop his intentional lack of, which he has been doing so throughout this entire case. To please cooperate and just try to simplify things. Include me.
It's always so funny to me that she gets to determine and to name everyone else's intentions. 100%, this is intentional. These are his intentions into not cooperating with me because he's not paying me exactly what I want and doing everything I want. This is intentional non-cooperation. However, you show her a video she took of herself saying, "This is for everything you've done to me." This being me locking you in a suitcase and filming you is for everything you've done to me. Yet she says that's not intentional, and how dare you accuse her of this.
So, what's next?
They're going to come and swab your fingers.
No, I'm talking about, like, in the long run. Like, what do I need to, like, do I need to be doing something, or, like...
I can't tell you, like, what to do.
I mean, like, so, like, for... Like, I don't understand, like, I don't know if you guys are just gonna, like, because it makes it sound like, to me, like, I'm being accused of something that was not intentional. I'm being accused of it.
Mm-hmm.
And a handful of other things that I'm being accused of.
Okay.
So I don't want to be at home with, and you guys show up.
Okay.
Meanwhile, she throws out every accusation imaginable over her personal feelings, not the actual facts of the situations, and not the actual facts of the reality in which she lives. But she's legit asking the court, I want you to compel perpetual cooperation with me in order to alleviate any stress or anything for myself. Oh, also, and the minor child and the son, but it's always centering around herself. And the judge knows this, and it's never going to work.
All right, I get the gist of that. They're also requesting that the alimony of $1,000 per month be terminated. What is your position on that?
Please, if you don't mind, I'm going to pull my paper.
All right, you're going to get a chance to present evidence. What I'm trying to find out now is just simply an overview, an opening statement, what the overview is of your position on everything, so that when I do hear the evidence, I know what I'm listening for.
Yes, Your
Okay,
Honor. Thank you for your paper.
I don't need specific language. Are you contesting? Do you believe that you should still be paid $1,000 in alimony per month?
I do, because the orders were active, including arrearage.
She's going to make sure that you know, including arrearage, because it's probably a word she just learned right before the pretrial statement. But this isn't an actual argument, and, you know, she'll have time to elaborate on this. But her only argument since moment one for why she should keep getting alimony is, well, the order was active, including arrearages. That's it. You are here because you need to prove and argue why you deserve to get $1,000 a month despite being in prison for murdering someone.
We, the jury, find the defendant guilty of
life in the Department of Corrections.
Now that you are in prison, you are being taken care of. You have food, drink, water, shelter, and more friends than you ever had on the outside. Forced friends, people that you live with, your own community. You have more than you ever had on your own on the outside. Yet you still think you deserve just as much money as you were getting on the outside, with no explanation to back it up.
Right? Do you believe you should still be paid $100 per month in child support?
I do not. The petitioner and myself came to that conclusion when Judge Dean was on the bench, so that should be concluded.
Right. So you agree that Mr. Boone should not be paying you child support?
Correct. Yes, Your Honor.
All right. They made a statement that there is approximately $4,000 that is sitting in the clerk of courts with regard to child support. They're asking that that be returned to Mr. Boone so that he can use it to care for the child. Do you agree with that?
I do, only if he decides to include me, please, on some of the things that I would like to have my son to have also, and things that he had made mention to me that he would like to have in order to become more of an adult and his growth in his teenage years.
Like what? Like what? You need to detail what this means. This is the trial. This is not a we're going to check back. This is not the time for vague, undefined terms. If you want to be included with the money, which that's never been a stipulation, so of course that's not going to be actually up on the table. But if you're going to make that argument, at least get specific. I want to be included in being able to buy clothes for my son, Christmas gifts, or this or that. I mean, there's no way that's going to happen in terms of you don't get to have partial custody of the child support. Either it's going to you or it's going to him. Not, you're supposed to give it to me, but I don't want it for me, but I still want to have the control over how it's used as though it were mine. No. If you want to buy your son some things to help him grow as an adult, get a damn job. What you say, you now work in the classifications department. Congratulations. Solicit the internet for money as you do anyway, but instead of putting it on your commissary for all your snacks and whatever you want, how about you actually use it to buy your son the things you want him to have? And I know she doesn't know, but she's saying, well, we already discussed this and that should be concluded, but it's not because we have to make it official here. Why do we have to make it official here? Because you still asked for it to begin with.
All right, so Ms. Boone, what's going to happen now is because the petitioner is the one who's filed the petition to relocate and the petition for modification, he has the burden of proof, and so he goes first. So I'm going to allow him to present his evidence. He's going to be able to call witnesses and offer documents to the court. If he calls a witness to testify, you will have an opportunity to ask cross-examination questions, okay? Then once he is done with all of his witnesses and all of his evidence, then the court will turn to you, and I will hear any testimony, any witnesses you want to call, including yourself. And if you call a witness or if you testify, then his attorney will be able to ask you cross-examination questions, okay?
Yes, Your Honor.
And I have confirmed that we did receive in the mail some documents that are your exhibits. When it becomes your time to present your case, we'll pull those exhibits, and then you'll be responsible for moving those into evidence, whatever you want to move into evidence. The attorney will have an opportunity to either object or to say he does not object to the court considering any specific pieces of evidence, okay? But you will get an opportunity.
Yes, Your Honor. Thank you.
All right, so we'll go ahead and we'll have petitioner call your first witness.
Thank you, Your Honor. I'll call Mr. Boone.
Give me just a minute to set up.
This is for the relocation, please.
I'm sorry, say that again.
What is the first document that we are attempting?
It's not a document. Counsel has called Mr. Boone to testify as a witness. And Mr. Boone, can you just say your name from sitting there?
Brian Boone.
Can you hear Mr. Boone?
Yes.
She says, all sulking. Yes, I can hear him. I don't think she understands that this is a trial and not mediation. So this isn't what document are we looking at? Again, maybe mediation, you do go document by document, I'm not sure. But for this is just like a regular trial. We're calling witnesses, giving testimony, making arguments, and then the judge is going to rule on the motions presented before her. No longer is this a back and forth conversation. You're at trial, adversarial process, you in one corner, he in another corner, and now y'all duke it out. So I think she is going to be very confused this entire trial. And I don't know why. She should be more prepared than Brian is in terms of she actually went through it. I'd understand this confusion a little more if she had not gone through her own criminal court case within the past year and made all these claims and assertions of how brilliant she is and how everything's being run incorrectly and how she's the one who's the only one following the rules until she's forced to represent herself. Then she flounders and says it's unfair. And now we're here again. She's forced to represent herself and she's going to say everything's unfair.
Okay, well, it's not fair. It's not fair. It's not fair. It's not fair. That's not really fair. See, that is just not fair.
I was actually wondering, Your Honor, if it's okay if he goes up there to the witness stand. Is that okay? Or is that going to be too complicated?
No, I don't think it will be, and it's probably wired so that it's probably you can hear him better from there. So I'm going to go ahead and have you go ahead and move to the witness stand.
We are officially transitioning to Brian's testimony. I think this is his first time he is actually giving testimony, a verbal statement to any of the harassment that he's received over the past 5 years, at least publicly that we get to hear/see. Oh, look at him. I remember, I think Tanika said on her initial debrief reaction that Brian had slimmed down a little bit. And it's like, good for you. I love how every time Sarah goes against someone else in court, they come back with a good little body transformation. Chelsea did it in the first trial, and now Brian gets to do it in the second trial.
I mean, I was 130 pounds at that time.
So she's overweight, right? In your opinion? Objection, no.
She's a little...
You don't need to answer me.
Meanwhile, it's probably better that she wasn't there in person so people can't clown her looks, just her voice.
But she is like...
What? Say it.
Security heavy.
And I remind you, Mr. Boone, you are under oath.
Yes, Your Honor.
Okay.
Okay, Mr. Boone, good afternoon.
Afternoon.
So Ms. Boone has consented to the relocation, so we're going to skip a lot of questions about how your son's doing there, and we can fast track some things a little bit. I wanted to start off with going through with you your proposed parenting plan, and that has been marked for identification purposes as Petitioner's Exhibit G. Now, Your Honor, these were all mailed to Ms. Boone, and we have I have a copy of the tracking receipt. I just want to make sure Ms. Boone has these.
Yeah, he knew he needed to bring the receipts because she likes to always act like she didn't get anything mailed to her. I never got my copies. It's all your fault. Good on you, Mr. Martell.
So if you, I don't know if...
Ms. Boone, did you receive Petitioner's exhibits?
For the notice of filing proposed amended parenting plan?
Yeah,
Yes.
that's one of them. Okay. So I guess, does she have any objection for me submitting this as a exhibit?
All right, Ms. Boone, do you have a legal objection to the court considering that proposed parenting plan?
No, Your Honor.
I understand that you do not agree with it, but do you have any objection to the court considering it?
No, Your Honor.
All right, hearing no objection, I'll receive into evidence what was pre-marked as Petitioner's G is Petitioner's Exhibit number 1.
Mr. Boone, I'm going to give you a copy of what I just
Okay.
Okay, sir. So we'll skip right to the meat of what we're proposing here, and that would be located on bait stamp page 082, which you'll see the bait stamps on the top right-hand corner of the documents. You see that there?
Mm-hmm.
Okay. In this proposal that you submitted to the court, you're asking that the father have 100% sole parental responsibility and shall make all major decisions affecting the child's welfare. It says children's, but you only have one child with Ms. Boone. Is that correct? Okay.
Yes.
And how old is your son, by the way? So I want to ask you a few questions regarding your request for sole parental responsibility. First off, since February of 2020, has Ms. Boone had any overnight contact with your son?
No.
Okay. Has she been involved in any major decision related to your son since February of 2020?
No.
Okay. Practically speaking, if there was a major decision that needed to be decided upon, how would you go about having, if Ms. Boone did have shared parental responsibility and was had equal power to make decisions related to your son, practically speaking, how would you even do that if she's in federal or in prison?
No idea. I have no way of contacting her. It'd be sitting around and waiting for her to call or something at some point.
Okay. And has Ms. Boone had telephonic contact with your son since she was incarcerated?
Yes.
Okay. Does she have frequent telephone communication with your son?
Off and on. There are weeks when there are tons of phone calls and then weeks where there's none. It's just kind of, I don't know.
Which seemed to fall in line with her parenting outside of prison as well. But yes, we definitely know she has been trying to call that son non-stop. Son, I tried calling 9 times today, 8 yesterday, just for you to yell and not care as usual. The jail messages where she's just following up, trying to berate him about how many times she's tried to call him, just make it seem even worse, because it's just like you're acknowledging that you know what you're doing, and then you're shaming him anyway for him forcing you to be this awful. Just for you to yell and not care as usual while typing on your computer, blank, stupid, uncaring response your father gives me, then hangs up on. But then, as we saw in Volume 4, she hardly messaged Brian or her son at all, which I personally have no issue with, and I'm sure they were happy with the break. However, that's a huge whiplash, having someone hounding you saying, I call every night. I try calling you every night with no answer. Don't you know by now the evening time is when I am able to call you so you have your phone with you? I call every night, every night. Tonight it rang and rang, then went to voicemail, then voicemail directly when I called back. You don't want to talk to me? and you don't answer, include me, this, and then have weeks of just silence, and then weeks again of being overwhelmed, that's just a lot for anyone to handle. Nevertheless, a child. And talking about decisions, 100%, that's the whole reason she wants to be included in all major decisions when that is not feasibly possible. She lost those rights due to her own actions, and now expect Brian to lose his rights and their son to lose their rights in order to make sure that she is included. Paulina wanted to make sure that she was included too, and I hear you. But what Sarah doesn't hear is that you cannot make decisions when no one can contact you, and also the decisions you do make end up with people dying and you in prison for life.
Life in the Department of Corrections.
It's just the all or nothing rhetoric. It's not just, I want to be included more. It's on all major decisions, and she gets to determine what is major and what isn't. Okay, but whatever.
Sometimes I'll start.
And when she is talking to your son, how does that go? How does it go? Is it good? Is it
coin flip? Sometimes he's very upset afterwards at things she had said to him, and sometimes she's in a great mood and they have a great conversation. It's very, you never know what's going to happen.
And when she's talking to your son, does she support your decisions, or is she a contrarian? Can you tell me exactly how she interacts with
mainly
your son?
Mainly contrarian, from what I understand from. I can't hear too much of them because she forces him to make sure he is nowhere near me when he talks on the phone with her.
Okay. Can you give me a specific example of where, after she's had a phone conversation with him, you've had difficulty with him?
Well, generally it's with buying things he wants, which, I mean, kids want all kinds of things. That's what birthdays and Christmas and stuff like that's for. Everything's not instant gratification. And he'll tell her about these things, and her response is, well, just Dad should get it for you, so.
Okay. Given the decisions that she made that led to her arrest and eventual conviction for second-degree murder.
Guilty of murder in the second degree.
Yeah, double homicide.
Bitch.
No, I'm sorry.
Do you have any concerns about her decision-making ability?
Oh, of course.
Okay. What are some of those decisions, or some of those issues, the specific issues you have with her decision-making ability?
I don't think she makes good decisions. Even without the alcohol, I think she has some problems that need to be worked on.
To say the least. But see, this is how you act civilly in court. He could be saying a whole lot of other things right now, and even by just what the court has witnessed today, I think the court would understand some different descriptors, but he is filtering his feelings very nicely because the evidence speaks for itself and we can fill in the blanks. But then he brings up the phone calls, which this is when all of those harassing phone calls and messages are going to bite her in the ass, because she thinks, oh, I'm showing how good of a parent I am by endlessly harassing and calling my son again and again and again, not realizing how truly terrifying it is to have a murdering mother harass a son who does not want to talk to her as much as she wants to talk to him, and then blames him for not wanting that and says, you have no reason for treating me differently. How could you do this? The whiplash is just, the coin flip is correct, because she goes from, you're the best thing ever, I love you no matter what, to, you will never treat me right, you need to treat your mother right, I'm your only mother, you'll never get away from me. Happy New Year. Or just New Year. I'm praying you will help make it a happy New Year. It's not like I'm asking you to grow a third arm or lasso the sun. Just answer your phone. I hope one of your resolutions, if you have any, is to be nicer and respectful to your mom. If you have nothing to say to me or care enough to include me and share your life, just be honest and say so. You are my son. I am your mom. Forever. No matter what, where, when, why. No matter anything, you can't delete, erase, blot out, omit, change, or remove. Stop being mean to me and not caring. So yeah, he wants to cut that phone time down to 1 call a week. So there's A, consistency, and B, it's not overwhelming for him. And then talks about on the phone, does she support your decisions or is a contrarian? Mostly a contrarian, solely a contrarian. There is no evidence, at least in what she has documented, that she's agreed with any of his decisions. And it is solely going against, why didn't you do this? Why didn't you do that? You should have taken him to a baseball game. You should have done this. And says the son, normally it's when he wants something. And this happens in most households where if you tell one child no, they try to go to the other parent and get a yes. And honestly, with all the mess that boy has had to go through, might as well get as much as you can out of it. So if you do a little manipulation here and there, I don't have an issue with that. But Sarah is the one who takes it to the extreme and makes it her martyred mission to force Brian to buy things for her son. And she thinks forcing Brian to do that makes her a good mom. I will never I will never get over or recover from the put it on my tab. To Walmart. He wants a bird feeder. He said there is a blank lands and tells me about the cardinals and other birds. He said blank. We're talking about springtime and Easter. Put it on my tab. Put it on my tab. Buy blank. Know what I owe you. Because even then, it's not her getting anything for him. It's her saying, I'm still begging you for money that you have clearly stated and shown that you will not give me, but I am so entitled to that, I'm ordering you to buy something for my son, and then I'll just subtract that from what you owe me. Oh. Brian, this has been a long time coming for you because that is a nightmare of an existence to live with, or at least be chained to the orbit of someone who is so detached from reality that they force their way into your life any way they can. Brings up that he doesn't even hear what's on the phone calls because she forces isolation. And she's brought this up in the past too, that she's mad that he was in the room when the son was there and this and that. 3. Private phone call time with my son. Former husband is constantly in the background interjecting his comments, answers questions I'm asking my son, laughing and telling me through my son what I can and cannot say to him, e.g., asking about friends, school dances, sports, etc. Also, former husband is always seen heard during my 15-minute video visits, impeding my valuable time with my son. I call him not former husband. Foremost, my son is a completely different person when not around his father. I am lovingly spoken to most of the time and am told about everything under the sun. So much is said when just me and him. There is also no pressure to be mean to me like dad is. Private phone time will be my time and made to be important and meaningful. It will also get him off the computer, which has been a huge topic of attempted discussion with former husband with no success. Wherever my son wants to sit, inside or out, and whatever he wants to talk to me about should be allowed freely and without difficulty. This includes phone and video visits. And it's all because she was asking him something inappropriate or they got in an argument. This happened multiple times on different occasions. And Brian has come in to stop whatever was happening and then ended the phone call because either she was causing the son distress or the son was yelling and he knew that needed to end right then and there. We don't owe you anything and are waiting for you to be guilty so we can get out of here and away from you. I don't want to deal with you anymore. I'm going now. Click. Yelling at me so loud, the phone is distorting. So loud, former husband, his father, came in and told him to stop being mean to me before hanging up. So from then on, I imagine she does try to force isolation so that she can talk to him whenever she wants. And she also does this thing of he's always in the room. She still asserts that, I'm pretty sure, to this day, when other accounts show that even if that thing happened once, that it wasn't continuous and that she has gotten what she wants more than she hasn't, but she still frames it like he is always in the room. I never have alone time with my son. He always impedes on this and that, which truly is what he should be doing, because isolation is how abusers get to take advantage of their victims the most influential. It's harder to take advantage of your victim when they feel empowered or at least more safe with someone nearby, someone in the room, someone they can lean on. She doesn't like that. She needs your full, undivided attention so you know exactly what she wants to happen and you know how bad of a person you are if you don't give it to her.
Okay. And when she was not incarcerated, prior to incarceration, what was the time-sharing schedule on paper that you two had?
It was a 50-50. One of us was Monday, Tuesday. The other one was supposed to be Wednesday, Thursday, and then we alternated Friday through Sunday.
Okay. And prior to her incarceration, was she exercising all of the overnights that she
No,
had?
it was about 30%, and it was sporadic as to kind of when she felt like it. Not even on days she was supposed to. She wouldn't have him for like a week and a half, and then she'd be like, I want to have him tonight and tomorrow night. And I'd be like, well, those are my days. And she's like, well, I haven't seen him in over a week. And that's kind of how things would go. So it'd just be like that. And then occasionally I'd be called over to pick him up at night because she had started drinking or wanted to drink and didn't want to take him to school in the morning or what have you. So, yeah, it was a lot of that.
Okay. And during that time period before her incarceration, was she actively involved in the decision-making process with your son? Was she?
Not really. She was kind of in her own little world at that time.
And if there is a decision that needs to be, a major decision that's needed to be made regarding your son that involves some type of monetary commitment, does Miss Boone have any ability to contribute monetarily to that commitment?
No.
Insufficient funds. You ain't got no money. Woo.
So is it possible that when if she were to be able to have equal say in decision-making around your child, that whatever she decides, you're going to be 100% responsible financially for that decision? Is that correct?
Correct.
Is that one of the other reasons why you're asking for sole parental responsibility, since you're the only parent that can financially execute any decision that needs to be made?
Yeah.
Okay. And do you see any problems with the fact that if there was a joint decision that needed to be made regarding a major decision of your son, do you see any problems with Miss Boone having input on that decision if she is not going to be financially responsible for it?
I mean, I don't mind her giving some input on it.
Okay.
No. I just don't want her to have any kind of legal availability to make a decision.
Okay.
Which is beyond fair, in my opinion. Like, it's just clear as day. Does she have any power to make any financial decisions or to help you execute any of the decisions that she would be involved in? No? Then why is she involved in them? She can be involved, but she should, like Brian said, not have like legal rights to enforce her decision if she can't execute them. It'd be one thing if the roles were reversed, or if the bank accounts were reversed and Brian was on the outside but using her money. Then yeah, she should be able to be included on the decisions that involves using her money. But that's not the situation. She wants to have control over how he uses his own money. And she just has a proven track record of being financially irresponsible, making terrible decisions, not working for herself, and only draining the resources of everyone around her. He brings up the inconsistent custody. We were supposed to have it split. She never really gets it. His story is pretty much word for word the same that he gave Chelsea at the crime scene the day she killed George. or the day she was caught after killing George.
It's her day to pick up the kid, but
Okay.
it doesn't always happen. 1 or 2 days a week, maybe she gets him.
Out of the 5?
Yeah.
Okay.
Yeah. So.
And what do you pick, like every other day you're supposed to?
Well, we're supposed to. She's Monday, Tuesday, I'm Wednesday, Thursday, and then we alternate Friday through Sunday. Is how it's supposed to. I was actually my lawyer back a couple weeks ago as I was looking to get it changed because she can never stick to it. There's always some reason why. So it's general that I start calling her around to find out if she's actually going to get him, even though yesterday she told me she would.
And that leads more truth and credence in my mind to his position because it hasn't changed from the beginning. He has asserted the same exact claims and they have held true this entire time. Sarah, on the other hand, has reframed, twist, turned. Her opinions, her thoughts, her assertions are always morphing because they're not surrounding the facts of the situation, but her feelings. And since her feelings are always being hurt and always being morphed, then she is continuously being abused in her mind, and everything is always in everyone else's favor, and everything's unfair for her.
Sometimes I'll start a sentence, and I don't even know where it's going. I just hope I find it along the way.
Thank you, Linda. I needed that one. But then he talked about how she would be inconsistent and then say, well, I want to see him, even though it would be his days. And she's like, well, I haven't seen him in a while. You can 100% imagine her doing that. Forget the schedule. She wants him when she wants him, and she doesn't want him when she doesn't want him. Just like how she treated George. When she wanted him, she would force him to come over, even threaten his birth certificate.
I beat you to the punch. Want to do the dartboard with me? Come. Tell him to come finish the dartboard with me, please. I miss him. Ask Jorge to call me, please, when he gets a minute. Can you have Jorge call me, please, when he gets a chance, if he's with you? Hello? Can you please have Jorge call me? Really want to see him. Please call. Come over. I'll come get you. Come over, please. I need a super hug. Hugs? Please, need. You. All up to you now, big boy. Look what you made me do.
When she didn't want him, she'd call the police and have him arrested.
My son can't come over here because he's here.
He doesn't live here.
He doesn't live here. Let's just get him out. I want to see my son. It's not fair. And you have to understand, too, I have, prior to classes in PO, kicked him out. How many times? I had him arrested. How many times?
But you also went down and bailed him
I
out
know.
the next day.
I know.
What's on your laptop?
Again and again, this back and forth, because she, in her life, because all the other modes and relationships and people that she had in her life allowed this pattern to continue, where she gets to determine how everyone around her interacts with her. And now that she can no longer make those sole decisions, she's losing it. But since she decided to be such a stickler about the rules once she was finally incarcerated and had to sit her ass down and then wanted to actually be involved in her child's life fully and completely, she kept trying to say that he was breaking the rules because he was taking her son places when they were going on trips to Alaska and whatever. You need to tell me 48 hours before you do something or before you change the schedule. Because I believe that's what was in the original parenting plan of any changes to the schedule need to be communicated within 48 hours unless there's like a super huge emergency. I am a part of your budget and should automatically be included in your spending and am doing without needs because you did not. Also, for your $2,000 plane tickets, you have not even mentioned or said to me your plans and intentions of where you are taking my son. Please explain so I know and have a right to. Nonetheless, I am his mother, no matter where I am. That does not include vacations. What that did include is this situation. Parenting custody. If you were going to change the scheduling to where you wanted him on your days or days that weren't scheduled to be yours because you couldn't take him in the past, you need to communicate that. You can't just show up the day of and say, well, I haven't seen him in a while, so now give him over. That is changing the schedule. That is breaking that rule. And that is completely disruptive to any child trying to follow any kind of schedule, because the messages are mixed and continuous in both directions. Sometimes she wants you nonstop and wants all of your attention. The other times she needs you taken away so she can have fun drinking all night.
And I think sometimes just she wants to stay up and drink and can't really do that if she's got to wake up and take him to school the next day.
Right.
Any number of different reasons.
So she can always come up with an excuse to not take him to school, which is why the irony culminated on the fact that the day it was discovered that she killed George Torres was also the day she was supposed to pick up her child from school.
I started calling her probably 10:30 or so. It's her day to pick up the kid, but it doesn't always happen.
About 11:30 is when I started calling to find out, because this is supposed to be her day. Her child.
Okay.
She's generally not very good about always doing it. She tends to drink.
They called back and said she was still there, or she came back.
So I was calling to find out if she was going to be getting him or not today.
From school?
Yes.
Okay.
Yet the night before, she's getting absolute blackout hammered to the point where she is comfortable enough to torture someone to death.
Or I'm going to go for a bike ride, or I'm going to do something else. Where I don't want to drink. I don't want to drink. The occasional wine, whatever, or if it's a weekend, that's when you have a good time. You don't have to wake up the next day. I have to wake up the next day and do things. I have to tend to, I have to take him to school. I have all this stuff to do.
And then just said, oops, well, tomorrow's my day to have my child over, so let me live it up today, and then tomorrow I'll take care of my parental responsibilities. Oh wait, George is dead. And you never got to pick up your child from school ever since. It's those little things you take for granted, those little chores that you try to undermine and to ignore and to overlook, that once they're taken away and you realize the value that had and that could have had towards you, not just in the chore itself. Allegedly picking up your child's not really a chore, but it can be seen like that from a zoomed out perspective. In hindsight, those moments become the most crucial and important. Having that alone time with your child when you pick them up and getting to greet them after school. And, you know, I feel bad for her because I bet she does want that more than anything now. She didn't want that then. And because of her actions in the past, she can't have these things anymore. Spot on again, Linda. Cherish the chores we take for granted now, because they may become our greatest treasure in the future. You can boo me now.
Now, is she informed of what's going on with your son?
I mean, when she talks, I guess he tells her. Once again, I never hear the phone calls, so I don't know.
Okay. But does she have the ability? She's had phone calls where she can ask him about what's going on in his life.
Course.
Is that right?
Mm-hmm.
Okay. And you're not looking to restrict her ability to be able to contact her son and talk to her son about what's going on in his life? Is that correct?
No. I mean
within reason, I should say.
The amount of calls,
okay.
Yes, but no.
Okay. And let's get into that. Your proposal is that Miss Boone have one weekly phone call with your son. Is that right?
Yeah.
Okay. Now, first of all, are these phone calls free?
No.
Okay. So how much do they cost every time Miss Boone wants to have a phone call with your son?
It's about $5 for a 30-minute call.
Okay. And in the last month, do you know how much you've spent on those phone calls?
Well, I mean, I said like last week. She didn't even call him last week, so that was like a zero. But the week before that, I mean, she probably, because she called a bunch, she probably had 6 or 7 calls, so that's like 35. She called last night, so that's 40, and then maybe $50, $60 in the last month.
Okay. When she does try to contact your son, do you try to accommodate her most times?
Of course.
Have there been times where you weren't able to accommodate her?
Well, I mean, yeah, his phone's dead, or he didn't have it with him, or it was on silent, or any number of things.
Okay. Now, regarding actually in-person visits, has there been any in-person visits at the current facility she's located in? Okay. When she was in the John Young facility, was there in-person visits that were?
They're not allowed.
They're not allowed. Okay.
Yes. It's not even a possible. Well, you can go there, but you're in a building across the street doing it through a computer. There's no possible way to physically see somebody there.
Okay. So this new facility is the first time that there's a possibility to be in the same room as her son. Okay. And how far is that facility from where you live in Gainesville?
I think it's like an hour 20, something like that.
Okay. So a round trip just to visit mom is going to be approximately 3 hours?
Probably, yeah.
Okay. And when do these visits, when are these visits scheduled? Do you know?
Well, if we were to do one, it would be on a weekend. I don't know if they do them on the week or not, so.
Okay. So if you were to execute one of these visits on a weekend day, that's pretty much going to take, is it going to pretty much take the entire day?
It would be a day, yeah.
Okay. And are you going to be the one that has to drive him there? There's no other family members that Miss Boone has or any that could take?
Well, I mean, I have family members who could,
but no one on Miss Boone's side?
It would be me doing it.
Okay. So it'd be either you or your family members that would have to take him? Okay. And so why do you believe that one visit per month is appropriate?
I think that's plenty enough. I mean, I wouldn't want that necessarily like set in stone. I would like it to be a little more flexible because, I mean, there's quite possibly, going to be situations where, it's only on weekends. So you've got like 4 weekends out of the whole month to get it done. And if he's got extracurricular things, we have season tickets for football games at UF. We go to games all the time. We have basketball season tickets. So there are lots of things we're doing. So, it's entirely possible we'll have a month where all 4 weekends are just taken up that month.
Would you be willing to commit to 12 visits a year, which would average out to be at least once a month?
Yeah, something like that would probably work.
Okay. And tell me, where does your son currently go to?
High school.
Okay, and is that a magnet program or is that a regular school? What is that?
Well, it's a biotech magnet program he got accepted into.
A biotech magnet program. Okay. All right, son, we see you. Congratulations. That's incredible. Just in general, but to go through what you've gone through. You hear that? Paulina is proud of you too. To have to go through what you have gone through and to still make it into a biotech magnet school, that's incredible. Very proud of you. You should just hold on to this, know the accomplishments and know what you are capable of, and know that you just getting where you've gotten so far means you will not end up where your mother has ended up. And regardless of what she's done, your future is very bright on the horizon as long as you pace yourself. We did that whole sidebar tangent about the talented and gifted programs and how they're more detrimental for children growing up than they are helpful in my mind. However, this is different. This is a biotech magnet school program. I could never do that. I did go to at once upon a time, I went to a governor's school for the arts, but not for the tech science one. That's for the smart people, so.
Since you got your degree and you know every fucking thing.
You enjoy that, though.
Okay, so explain to me, what are the commitments of a student that gets accepted into a biotech magnet?
Well, it's a lot more heavy math, science, stuff like that. There's a specific biotech class he takes every year over his 4 in high school for it. Also, the school itself is over 11 miles away from me, so, and there's no busing, so I get to drive him to and from school every day.
Okay. And does he usually have a lot of homework on the weekends?
He does, yeah. He'll have homework, yeah.
All right. All right, let's get into some of the other issues, the monetary issues here. So I stated in my opening statement, but I'm going to ask you here while you're on the stand, is it true that when Miss Boone was incarcerated in February of 2020,
Why is this happening?
Because George is dead.
you stopped paying the exact $1,000 a month alimony amount that was in the final judgment.
Yes, I would, through Zillow, through my bank, I would send her the $1,000, and with her incarcerated, she couldn't even use her checking account, so there wasn't really a reason to do that. So, at the very beginning, her idea was she kind of kept notes of everything I was buying for her to kind of tally up how much I was doing, and then we'd figure it out at the end, and then 1 year turned to 2 years and to 3 years. And
Okay. And eventually you stopped making any payments to her?
yes.
Okay. So in February of 2020, do you know approximately how much per month for that period of time that you were continuing to make her payments, how much money you were giving her that was not things you were paying for her for, but actually direct money to her?
Probably say about $600 a month.
Okay. And when did that stop? When did you stop doing that?
Probably close to 3 years into it, something like that. It was after like her first coin-appointed lawyer quit on the case is kind of when I gave up, because I just felt she was kind of delaying things at the time and we were never going to get to a trial.
Okay.
Which is exactly what she was trying to do. And no matter how many times she pleased to the contrary and said, I didn't do this, they all gave up, they were this, they were that, it was all a tactic.
My question, please, who acts like that and still be able to call themselves professional? She, like other former attorneys who always blame their dysfunctions on me, said, you don't like the answers I give you. What answers? See pages 1, 2, and 3. I am not the problem, except I want to and should be treated fairly, with respect, acting more professional than the paid. I've been doing this for over 40 years, professional. After so long and in all the experience, common courtesy, customer service, and listening skills should have been acquired. All attorneys, do you remember why you even wanted to be one? Remind yourself. No one listens, and it works for everyone's favor but mine. That I am a murderer, stuck in jail so they can pin on me. They're uninterested, unmotivated, hopeless. They're going to believe me over her haughty attitude. I am not wrong for not thinking less of myself, because everyone else has and does. This present attorney foremost. The justice system expects me and other inmates, aka clients, to accept its subpar, nonchalant, hypocritical, next on the list attorneys they keep aimlessly throwing darts for, malappointing, praying they don't withdraw. I have not fired any attorneys appointed in my case. For me expecting the highest equal standards possible, for wanting the absolute best outcome in my preposterous, mismanaged case, and representing myself is not an option, as both judges have now threatened me with, from being outspoken and intelligent in all my observations of the ongoing abuse I am and have experienced. I have no new experiences from it, always being the same blame Boone. I refuse to be moved in wanting respect, no matter who everyone thinks I am. Clarity, inclusion, honesty, and professionalism.
It was the most transparent tactic out there. Of course, someone who is facing life without parole, because there's no parole in Florida, so someone who is facing life in prison is going to try to prolong this as long as humanly possible, when this was always the most simple case imaginable from the beginning. She handed you the tape that said, I killed this man. Yet somehow it took nearly 5 years to convict this woman.
We, the jury, find the defendant guilty of murder in the second degree.
Which is almost impressive, to be able to stretch out a 6-day trial, hour-and-a-half verdict over 4.5 years. Takes some skill, a level of shamelessness that most people aren't, derogatory to themselves enough to stoop to. People do have some self-respect and won't absolutely make a damn fool of themselves just to get a little extra time to avoid the inevitable.
To life in the Department of Corrections.
And it 100% had to do with this exact trial. If this trial wasn't ongoing and she was receiving the $1,000 payments and she knew that she was going to continue to receive the $1,000 payments, she would have went to trial with Mr. Padilla from the jump. But no, once she realized that they're going to keep appointing her lawyers, that she can complain and carry her way to the top all she wants until she finds the lawyer that she actually likes, even though the judges point blank told her.
But one thing I want to caution you about, if this becomes a problem on another court-appointed attorney, I'm going to look more closely at what the alleged disputes are. You have a right to a court-appointed lawyer. There are certain decisions a defendant gets to make in the defense of their case that are absolutely theirs, such as whether they go to trial or not, such as whether they testify or not. But there are many decisions in a case that a lawyer gets to make. And while you certainly have a right to consult with your lawyer and discuss with your lawyer, they don't automatically just do whatever you say. They use their professional judgment and experience and look at the evidence, look at the law, and do the best they can. Also, you've got court-appointed counsel. As I've explained to you before, court-appointed counsel rarely have the luxury of representing one person and only having one case to focus on. I have concerns that your expectations of what any court-appointed counsel might do as far as spending time with you and the depth and degree of communication may be unrealistic expectations. You always have the right to retain a lawyer to represent you, and then that's between you and that lawyer. You can demand whatever expectations that you have as part of that agreement. But when it's a court-appointed lawyer, you have to accept and understand that they have other cases, other courtrooms, other responsibilities, and I'm cognizant of that when I'm addressing these types of issues about communication. So that's just food for thought, nothing to do today. I don't need a response from you. I just wanted to make sure you were aware of that and were thinking about that as we proceeded forward. Ms. Boone will be returned to the Orange County Jail pending disposition of her case.
Am I able to say anything?
You are not legally guaranteed all the lawyers you want until you find the one that you personally like. So she kept coming up with more and more arbitrary standards. She kept moving the goalposts. He wasn't communicating with me enough. Well, then he didn't answer my phone calls. Well, then we didn't have video phone calls. Well, then she's too mean to me in the phone calls. Well, then I actually ended the communication and walked out because she wasn't going to explain things to me.
She likes to tell me it's not necessary, but I know for a fact it is necessary. She likes to, in quotes, put things to rest all the time and constantly tells me I'm not having this conversation with you. So I'm not going to waste my time, and I, being in jail, have supposedly abundant amounts of. She's not going to waste my time because she's not going to explain something to me. And I have taken it upon myself to explain it to myself because she refuses to do so. I don't understand what it is that she has against me. I have told her from day one that her snotty attitude was inappropriate, and I try very hard to bear with her and her attitude. I don't know what it is that I'm doing wrong to her, but I feel that her attitude has equaled prejudice, which is not in my favor, especially considering she supposedly represented my life.
To life in the Department of Corrections.
There was always going to be something wrong unless they groveled on their knees and said, please command me what to do and I will do whatever you say, my queen. She was going to complain about it. And that's why Kranig said in his order, actions speak louder than words. And even though her words state that she wants to go to trial, her actions are repeated over and over, and they just prove that she wants anything but that.
QQ. As set forth above, defendants' recalcitrance to the attorneys who were not conflicted out, Padilla, Bankowitz, Hobson, and Cashman, antagonism, hostility, and attacks on the professionalism of Padilla, notably over a year after the fact, see footnote 9 above, of Bankowitz and of Cashman, and personal attacks on Padilla, Bankowitz, and Cashman. Each of these attorneys were required to withdraw. RR. It has become apparent to the court that defendant will not permit herself to be represented by anyone. As of February 9th, 2024, the instant case had been continued 16 times. Triple B. Actions speak louder than words. Although defendant's words seemingly reveal a desire to go to trial, however, as set forth herein, her actions and inability to work with court-appointed counsel are repeated over and over, allowing defendant to her 8th court-appointed attorney, her 9th attorney overall, will only serve to delay the case further and encourage defendant to persist in efforts to prevent the resolution of the case on its merits.
So Kranig made the smart and difficult decision to push things forward and said, take it up on appeal. We are having this trial. This is ridiculous. Nothing is going to change what is about to happen. So let's just do it. But yeah, Brian made the correct decision and to stop paying her because one, he's not going to get in trouble for it. This was always going to happen, this trial right here, and he's going to be found not liable or not responsible for any back pay. She's just going to have to get over it and realize you are not entitled to other people's resources, and it's not unfair for your ex-husband who divorced you, you are no longer together, to not continue to give you money. Again, it'd be different if he was taking money away from you, if he had your bank accounts. Your bank account was empty. Literally the night before you murdered George, thus sealing your own fate, you were in the negative.
She said her account was in the negative, so I transferred her a little bit of money to get her out of the negative.
And you begged Brian for money again because it's all you do. And you were with him for like 13 years, plus the 1.5, 2 when you were divorced, then now the 5. So we're pushing 20, 30 years that you've had to deal with this woman. She has not been told no enough times in her life, at least not enough to where it takes and retains that message. So she needs to hear it a few more times.
Were you still paying her some money after you filed your petition to modify in April of 2022?
Yes, I think I was still.
You still were paying her some money?
I believe so.
And in my opening statement, I mentioned...
I know I was still doing the storage container at the very least.
Okay, that's why I wanted to ask you
other stuff I was doing also.
Okay, so how much were you paying for that storage container?
Locker, sorry. I think it was like $240 a month, something like that.
And was that a mini storage facility?
Yeah, it was like a, what was it, probably 10 by 10, 12 by 12, something like that.
Okay. And when Miss Boone was first arrested, did you help move those things into that mini storage facility?
Yeah, I did. There was nobody else in her life to help her sell. It was me.
Okay, so you moved her stuff in there, and then you paid the monthly fee.
Yeah,
for
I had to rent a U-Haul and physically move everything, and yeah.
Okay. And when did you stop paying that? Do you remember?
I think it was a while after I moved.
Okay. And when you were buying things for her, what were the type of things you were buying for her?
Hot meals, gift baskets, just money in general on her account, whatever it is, thing in jail, phone calls, excuse me, stuff like that. There was probably other things. I mean, presents she'd want to get, she obviously couldn't buy them.
And with your broke ass.
So I would buy them, and yeah.
So you'd buy presents with your own money, and then make them presents coming from her?
Yeah.
Lucas?
Every Christmas and birthday and yeah. Okay. She'd have a list of presents she would want me to buy him, and I would buy them and wrap them up for him from her. So.
Okay. And you said you eventually stopped doing it because she got a new attorney and you just felt like the case was dragging on. Can you expound on that? What was your frustration there?
Because I didn't see an end in sight. I wanted, because we had already gotten this thing going. The judge wanted to wait for the trial to end before we could do anything with all of this. And it seemed as though she was just dragging things on almost on purpose, just so this wouldn't happen.
And we 10,000% agree, because that's exactly what she was doing. And the fact that she specifically says, this is not a strategy of mine to wear down the time, yet let me be completely dissatisfied and ornery and just combative about everything. Oh, and it just so happens that the time goes down. That's why she always asks for the free lawyer, even in this trial. She was like, can I get a new lawyer so that this will make things go quicker? Even though we all know if she were appointed a court-appointed lawyer, she would have gone through the same exact thing she did in her criminal trial and go through lawyer after lawyer. Which, side note, I don't know, Karma really does not like her, because she's now going to be on her 4th appellate attorney. Right? I think Joshua was the second one. So there was the first one who immediately had to withdraw because I guess they were no longer practicing or something. And then I thought Josh Adams was the second one. And then Josh Adams pulls out because he's no longer doing appellate work. And then this other guy showed up, and apparently he's a lawyer for a terrorist. And then he had to pull out because he's doing something else. And she's going to have to get a third or fourth court-appointed attorney for her appeal. Damn. So I have no doubt in my mind that if she were appointed a free attorney, there's no reason why they would do that. But if they wanted to, they could. If she were appointed one, she would destroy that relationship and ask for another one. Could you imagine going through multiple court-appointed lawyers in civil court? I don't think that would ever happen, because it's absolutely not required whatsoever. However, she made sure that she asked 1,000,000 times, and her whole reasoning was it would make things go quicker. Just more surface level stalling tactics. So sometimes you just have to push through no matter what. And every time she's going to get there and say, I'm so unprepared, I have no idea what I'm doing. But you do. You know exactly what you're doing. And you know exactly what you were trying to accomplish. And the fact that you keep failing at accomplishing those things, and then the thing that you were trying to avoid happens anyway, you show up and you're completely unprepared because you were too busy trying to manipulate people instead of preparing for your trial. I don't think she has an answer to any of this. She does not have an answer to any of the things that he is bringing up, other than, well, I need them and he's supposed to pay me. No other logic behind it. Okay, but even here, she kept asking for $1,000 payments a month. If he's paying for that storage unit, which was $240, then the max that you should ever ask for is $760. But we never hear about that figure. She always goes for the full $1,000. If you did not put the full $1,000 in her bank account that she lost because she was broke Isha.
Hide the money, y'all. There's poor people around. With your broke ass.
Broke. That the bank had to pull the plug and said, we're not doing this anymore. No broke people allowed.
Insufficient funds. You ain't got no money. Woo.
And if you didn't do that, then you didn't pay her anything. And she deserves the full $1,000. And He absolutely was asked to pay for hot meals. How many? A million times? I'm so glad he didn't. A lot of times. Oh, she got so mad about it, but she asked a million times. To Brian Sayre, hot meals times 2. Why didn't you order, Brian? They just came without calling my name. And because you will not give me confirmation numbers to ask the rep, I again have nothing for New Year's nor for Christmas. Even after asking over and over and over and over, starting December 6th, today is the 27th, and you couldn't find 5 minutes to order? But keep telling me you would and were going to? Are your holidays complete and even merrier knowing you did nothing so I could have nothing again? Why are you continuously lying to me about everything? Lying about everything. It's just a hot meal that you permit me to have only about 2 times a year, not even for Christmas, but kept telling me you would and were going to. How many more times did you want me to ask? Not even a hot meal for Christmas. Thank you, Brian. Oh, woe is me. Get the F over it. And then the gift bags. We know she wanted those food packages more than anything. She wanted the commissary. She wanted a million phone calls. Phone call confirmation, commissary, soap for son, hymnal, keep it kosher food pack, pizza and wings hot meal, birds and blooms magazine renewal. You stated to me to call back Monday for order info. All of these things stack up, and these gift packages and these meals, the hot meals were like $30 a meal, and the gift packages were 30 to 50. 30 is on the small end, 50 and upward is on the medium and large end. And she asks for these things like it's nothing, and as though she is entitled to them and deserves them, despite the fact that she ended someone's life, and he can't be with his kids because of her.
Okay. Now, during this time period, you had to hire private attorneys, is that right?
Correct.
And I'm not your first attorney, is that correct?
No, no. Okay. She stopped practicing and recommended me use.
Okay. And do you know how much you paid to your first attorney to file the initial modification proceeding?
Well, she didn't fit. You filed the initial one, I think. You didn't?
No.
Did she do it when you?
Well, actually, maybe.
Hold up.
All right, we can't have a conversation like this.
Oh, I'm sorry.
Let me.
Sorry. No, I believe you did.
Let me rephrase the question. Let me rephrase the question. How much did you, the first attorney that you hired to pursue the modification case, how much did you pay her? Do you remember?
I do not remember. She did write up an entire thing to change it because I was going to be submitting that.
Sir, answer the question.
And
How much did you pay the attorney?
I don't know. I'm sorry.
Okay.
Question.
I'm sorry.
Sorry, Miss Jackson. Ooh, I am for real.
And during the time period that Miss Boone was incarcerated, you were still giving her some funds, paying for her mini storage. Were you also paying for 100% of the expenses of?
Yes.
Okay. And was there any time since her incarceration that Miss Boone gave you any money to help out with?
No.
Did she direct any family members to give you any money to help out with? Okay. And tell me a little bit about, well, let me strike that. Okay, so let's go back to attorney's fees. Do you know how much approximately you have spent in attorney's fees for my representation?
I think around 14,000.
Okay. This time, Your Honor, I would like to submit what has been marked for identification purposes as Petitioner's Exhibit F. It is a summary of Mr. Boone's attorney's fees he's paid to our firm.
You offer that into evidence?
Yes, I just want to see if Ms. Boone has any objection.
Ms. Boone, do you have any objections to what was pre-marked as Petitioner's Exhibit F?
No, Your Honor.
All right, hearing no objection, I received what was pre-marked as F as Petitioner's Exhibit number 2.
Sir, I'm going to hand you a copy of that exhibit.
Thank you.
Okay, sir. If you look at this exhibit, if you just look at, I'm going to direct you to bait stamp page 49. It's the first page. What's the date there on the top left-hand corner of the last entry up there at the top?
7/29.
2025? Okay. And if you go back to the last page, which is bait stamp page 79, what is the first entry on those billing records?
3/21/22.
Okay. So it looks like these billing records encompass approximately 3 years and 4 months worth of activity. Is that correct? Okay. And we're now in August 25th, 2025, and we're in the middle of this trial. So the $12,050 that's on this summary here, has that increased?
Yes.
Okay. And is that where you're getting the approximate $14,000?
Yeah.
Okay. Okay. Now, Ms. Boone indicated in her opening statement that if people would have asked her, she would have been agreeable to some of the relief that we're seeking, basically, in essence, is what she said. I want to ask you, in all the calls that she made to your son, did she ever talk to you about settling this case?
In a way that would benefit her, yes.
Did she ever tell you that she would just agree to the relocation?
No.
Did she ever tell you that she would, well, I want to ask you this. She mentioned that you two had a conversation about the waiving of the child support. Did that conversation happen?
Not that I remember.
Okay. So there's never a time where she told you you don't need to worry about the child support?
No. I don't remember that happening.
Okay. In any conversations that you had with Miss Boone, did she ever tell you that specifically that she didn't want you to move to, she objected to the relocation?
Yes.
Now, Your Honor, there was a stipulation regarding the money from the clerk of court. You don't need me. Do you need me to ask any questions on that? Or has that been stipulated by Ms.
Probably
Boone?
do, because I think her response was that she objected to a condition upon something.
Okay. All right, sir. So I mentioned in my opening statement that there's some funds that you have tied up with the clerk of court right now. Is that correct?
Mm-hmm.
Do you know approximately how much that is?
I think it's like $4,000.
Okay, and
I could be wrong.
what does that money encompass?
Child support payments.
Okay. And are you asking as part of the resolution here today that that money be refunded to you?
Yes, please.
Okay. Now, let's also talk a little bit about your income. Are you currently employed?
Yeah.
Okay. When was the last time that you were employed?
Back a little while. I've had some online things off and on at times.
Okay. For purpose, when was the last time you were employed full time?
Probably 2021, 22, something like that.
And you know,
I'm going to stop you for just a minute.
sure.
If I seem to remember correctly, there was a stipulation with him earning $60,000, and I bring it up only because there was a motion to compel, and I denied that motion to compel based on your representation that you're going to stipulate to income of $60,000.
I was just going to get him to acknowledge that he's stipulating to that. That was my next question.
Sorry, Miss Jackson. Ooh, I am for real.
Yeah. So I just want to make sure that was on the record, but or at least clear to the court here today through testimony. So, sir, regardless of last time you were employed full-time, it was 2021. Today, for purposes of calculating what the support should be today and moving backwards, are you willing to impute $60,000 of income to yourself? Okay. All right. Now, all the phone calls that Ms. Boone has had with your son, have you paid 100% of all those calls?
Yes.
Okay. Has there ever been any family member or anyone else in Ms. Boone's family that's given you any financial assistance towards?
No.
All right. Now, Ms. Boone indicated in her pretrial memorandum and in other places that she's alleging that you have possession of some of her belongings.
Mhm.
Are you aware of that?
Yes.
Okay. Do you have possession of some of her belongings?
Yeah, anything that had any kind of value I had gotten out of the storage unit, so.
Okay. And you took it out of the storage unit when you stopped paying for the storage unit, is that right?
Yes.
Okay. And where did you relocate those items to?
To my house in Winter Park, and then they came with me to.
Okay. And do you still have those items?
Yes.
If Miss Boone were to have a family member come by or a friend come by asking for those items, would you release those items to that individual? Okay. Sir, despite Miss Boone being where she is and having done what she did, are you still committed to making sure that your son has a relationship with her?
As long as he wants one, yes.
While he's still a minor and he doesn't get to make decisions for himself, are you?
Yes.
Okay. Okay. I have no further questions, Your Honor.
Right, Ms. Boone, do you have any questions for Mr. Boone?
Yes, Your Honor.
I bet you do. So I let that play out a little bit because I wanted to hurry up and get here and see the disaster that this is about to be, because I heard about it. I heard about it the day of when my one video volume 4 was streaming, and then I think Hear Me Out or Summa Cum Loudmouth came up and mentioned that they were having a break after Sarah's cross-examination and that it was wild, crazy. So I can only imagine what we're about to get into. Yes, Linda, I know it is very exciting. I'm ready to see what's happening too, but first we need to recap what we just went through so that we know what we're about to walk into. So this last section covered most of the attorney's fees argument of saying you've been incurring costs for 3 years and 4 months, which is so long to deal with this when this could have been done so quickly. And so, yeah, he should be fed up because every time she delayed the criminal trial, that is more time that he had to have a lawyer and more expenses he had to rack up in order to get to this moment right here and try to get some freedom from her. So she should absolutely be responsible for those attorney's fees since they only increased because of her delays. So no matter how many times in her pretrial statement she was like, you chose to have an attorney. These are self-inflicted. They're self-inflicted in order to prevent you from inflicting more harm on them. But love this judge yet again because she's been calling out Brian as well with they're just up there talking back and forth at that one point and he's like, sorry, we can't just have a conversation. That was really funny to me. But as soon as the judge saw that happening, she stepped in. She also stepped in when Brian was trying to over-explain something, and she said, can you just answer the question so we can move on? And he said, sorry, answer the question, and then they moved on. It really is that easy. It doesn't have to be this back and forth, but what about this? Well, what about this? Where's my motion to contempt? Well, I was just trying to explain this. Okay. And when the judge says move on or answer the question, you move on or answer the question. The biggest point here that she never addresses ever, who is paying for 100% of the expenses for son? She keeps wanting this money so that she can buy him gifts or whatever. Still Brian's money. I've said this multiple times in the past. His money just goes in a circle and she just wants her grubby little fingers to touch it first before giving it right back. But she never once tried to help with any of his expenses. Even when she messaged complaining because he had a chipped tooth or something and said he needed to take him to the doctor, I'm like, look, inmate, you're not going to tell me how to handle stuff in the real world. You need to work on brushing your teeth while incarcerated. But even then, she was trying to make it seem like, go to the doctor's visit and so I can put it on my tab. And again, this tab is still his money. At no point has she contributed anything but stress and depression upon this family. And he called out she never gave her money. She never had family give her money or give money to the son to help take care of him. And she wants to say, I have no one. All my family's dead. What am I supposed to do? Do you have proof that you asked? You wanted to submit all of these jail messages because you wanted to show that Brian was not responding. Well, in those messages, did you ever ask for money from Philip or your family in order to give to your son? Not your stupid little fish soap, but actual money that can help raise him. No? And all you've done is ask for more money? There's no way any judge is going to side with you, and the only thing you have going for you is, I'm his mother. That's it. I can't stand that argument when all you have to lean on is the fact that you gave birth to this child. You're probably a pretty awful parent. And now in this hearing, she saying like she would have been agreeable if she had the mandatory attorneys meeting and unrepresented parties meeting. And so I'm glad he asked, has she ever agreed to settle this case? And Brian was like, in a way that would benefit her. Yes, exactly. The only thing she would have agreed to is the $1,000 a month, infinite credits, infinite time with son. That's it. Other than that, she was going to take it this far. That's why she kept bugging her brother for this family law book. And when we went over his messages, we saw how many times she asked for that damn book. And then we find out that book is nearly $600. So she has no issue asking for exorbitant, costly things from other people, but never asks for those costly things for her son. Sorry, getting your son some fish soap does not count as raising him. And it's still just a you thing. It's you want Brian's money to give him gifts so that your son sees you as a better person. Not just because your son gets those things and is going to have a good time and you really want him to have a good time. You want him to have a good time that you provided. She wouldn't agree to the relocation for years and kept telling everybody, I don't know why you're assuming all this and all that, because nothing has been decided yet. In that one message that we've played before where he's like, we don't owe you anything, I'm going now. That all happened because, and she says, well, we got into a fight because I was just asking about his friend. Well, yeah, what were you asking about the friend? And then she lays out his business, because she does that all the time, of his friend's upset because he's telling her that they're moving and that he's not going to see her again. And how could he do this? And I told him that he shouldn't even be telling this because nothing's set in stone and no one's moving anywhere. And he's taunting me. You hear him? He's saying he's moving to Gainesville. It's going to be closer to the prison. Can you imagine him saying that, Judge? How on earth could anyone who has seen the video of me murdering someone ever say that I'm going to prison? And then rub it in my face by saying we're going to move closer to the prison. How insulting. But now that she's in prison, she's like, oh yeah, I agree to the relocation. Now, what if she got her way the first time and they didn't relocate? They wanted the relocation. She argued through a whole scene and they said, okay, fine. We won't relocate and we will stay in Orlando until your trial's over or whatever. And so the trial happens, she's in prison, and now she's wherever she is. Now she would beg for them to move, saying, well, you said you were going to move for better opportunities. There's actually better schools out here, so why don't you move so he'll be closer to me? And it's like, okay, I get you wanting that. However, like Brian said, the only way she will agree to settle anything is if it benefits her. If it requires her making any sacrifices or living with any amount of discomfort, she won't agree to it. And because she pushes and pushes and pushes, she ends up losing everything and then is just floored how she could lose everything and then wants to be all woe is me when she's there. And it's like, yeah, normally I would feel bad for someone who loses everything like this. But when it is a self-induced injury, I can't feel bad about this. For years, he tried to settle this. And even with all the mediation attempts until you, because she keeps doing it. She'll needle and needle and needle and then get mad when people explode. And the waiving of the child support, she keeps bringing up, well, we agreed to waive the child support. No, you didn't. And I believe, Brian, y'all didn't have a conversation about it. There was a good nuance in that question. Did she ever agree in conversation? No, because she only agreed in that pretrial statement or one of her motions. Because originally she had submitted the motion saying she wants all the alimony and the child support because she's a dumbass. Then she resubmits one and says, because she realizes she has no legal basis for asking for that, she says, well, no, I don't want the money, but I want to be included and get to decide how that money is used in the best interest of the minor child. And all that pretentious wording. And then because she resubmitted a motion not asking for it, ever since then, she has been floored of, why do we keep bringing it up? I already agreed to it. You never agreed to it in a conversation or anything. If it's just an emotion, that means we have to come here to see it on that motion. And she tries to have a million conversations all the time. So they could have discussed this. And she could have point blank said, this is what I want. I want you to have the money, but I want to have control, or like for us to work together with how that money is dispersed. Still, the answer is no, but at least then you could say, oh, I was more agreeable and tried to come together on things. But no, you resigned yourself. As soon as he wasn't paying you the $1,000 a month, you were okay taking it to court because you thought the court would be on your side. And you thought that so much that you never even thought about the arguments you need to make. I am so excited to see how this cross-examination is going to go because I don't think she has any questions for him. I don't think she's actually been paying attention to what he's testified to. She has the exact same questions that she's always had. And it's just like she said in that message. Why won't you respond? I guess, or what are you going to do? Something when the judge forces you and makes you respond. So she's been waiting for this moment to force him to answer the questions from the tablet that he wouldn't answer before. Not actually going to try to cross-examine him and his testimony that is actually relevant to what happens today, but all the grievances she's been waiting for. It's just going to be a mess. Brian's been unemployed for a while, which, Sarah shouldn't have anything to say about it, which I could not believe in the pretrial statement. She kept bringing it up because her only argument, it's not good, but her only argument she can't stay away from is, he has a job, so he should pay me. When that has never been his argument. It has been an assist to his argument. His main argument has always been, there's been a monumental substantial change in circumstances. You have officially been removed from society for the rest of your life. So I shouldn't have to keep paying her. Also, I shouldn't have to keep paying her because I don't have a job and can't consistently make or ensure that I will make $1,000 payments monthly when I am a single father raising a child and supporting him financially completely on my own. And if he gets money from his parents and his family, that's fine. That's still him raising the child. 100% custody and responsibility has been with the father. We just have to make it official so she can stop throwing these alleged parental rights around like she's actually involved in the child's life whatsoever in a meaning and functional way. When the extent of your parenting can stretch only to like pen pal status, then you don't need to have the same rights as the parent who has 100% custody and responsibility of him. And then admits again, he's paid for 100% of all the communication, the phone calls, text messages, whatever. Sarah has never once tried to reimburse him or even acknowledged that in her $1,000. So we know that he is regularly or was paying for the storage unit, was regularly paying for every phone call, every text communication, video visit, driving, or whatever he needs to do to get him in contact with her in the various ways that she had access to him throughout the past 5 years. And she's provided absolutely nothing. Oh, but to pick up on my earlier thought, I could not believe that she had the audacity in her pretrial statement to say he's unemployed or he's employed, or ask him why he hasn't been employed in 2 years. Explain to the judge why you haven't been employed. Who are you Drunky the Bear, winner of the USA Miss Unemployed America pageant show. Who are you to say anything to anyone about not having a job when all you've done is held that belief that men should take care of you? It's the same thing you said to George of, I wanted you to be a man and take care of me. I wanted this, that, da. And you still hold that belief to this day. The fact that you see nothing wrong with this man paying and funding your entire life? Mind-blowing. Okay, but now let's officially transition into whatever mess this cross-examination is about to be.
All right, you may inquire.
Your Honor, is there a particular order I'm supposed to follow?
I'm sorry, I can't understand you.
Is there a particular order I'm supposed to follow in regards to items or topics?
Ordinarily, I will. You just need to. You do not have to stay in any particular order. You just need to ask him questions regarding anything he just testified about. But to save time, if we have additional stuff, are you okay with her going out instead of calling him?
Yeah.
All right. So no order, and you can ask him any questions based on the testimony he just gave or any of the issues that you're raising or your positions in the case. Okay?
Thank you. Brian. When have you ever included me since my incarceration of February 2020 in any major decisions at all regarding our son?
I mean, there haven't really been any huge decisions.
COVID wasn't a huge decision?
Well, no, we did, and you told me that you did not want him to get vaccinated, which scared the crap out of me that you thought that.
Sarah Catherine Paulson.
Excuse me. You're eating my peach.
Is an anti-vaxxer? Shocker. I wish I were surprised that the woman who thought that she could leave a man zipped up in a suitcase all night and he would survive also is afraid of vaccines while she's in prison. That didn't make any sense. So you were in prison when COVID happened. You saw all your inmates around you getting sick, this and that, and you still said, no, I don't want my child to be vaccinated, despite millions of people around the world dying of COVID and not millions of people dying from the vaccine. Just cost-benefit analysis says take the damn vaccine. It's always wild to me, those who are the most anti-vax type people are themselves vaccinated. And they're like, well, I'm fine. Yeah, you are. Of course. This is why you're not included in big decisions. Because of course this would be your decision. You would put your child at risk going into schools after quarantine, which were super spreader events. Kids getting sick left and right because parents like you didn't want to vaccinate them and then took their contaminated asses in front of everyone else, and it still spread. That is outrageous.
Relocation?
What's that?
Relocation.
Yeah,
Did you ever talk to me about COVID? Did you ever talk to me about relocation? Have you ever included me in any major decision-making question?
Well, yes, and I disagreed with you.
When was the last time you answered a phone call of mine?
Quite a while.
Why do you not answer my phone calls when I attempt to communicate with you?
Because I don't care to talk to you.
So in regards to our son, you do not want to communicate with me?
If there is a conversation you want to have about, you're welcome to have it with me. That's not what you call for.
What else is it that I call for?
To yell at me about some random thing, or tell me I need to buy things for.
You do realize, Brian Calloway Boone, that you are under oath.
All right, take it easy, Sarah Catherine Boone Paulson. you want to sit up there, act all holier than thou of Brian Calloway, whatever, Boone, you are under oath. Do you know that? Do you know that? You sat here and lied nonstop. You admitted to lying on the stand, lying to police officers.
I lied to the police, basically everyone, because I was extremely fearful of being arrested. I made the first attempt of me calling 911 by telling them what happened, and I thought they were going to help me, but instead I was arrested for calling 911.
So you made the decision to lie?
I did.
Did you stay with that lie?
I did.
Are you telling the truth today?
I am.
It was all a lie. Guys, it was all a lie. She lied.
You don't care about being under oath either way. All you do is tell lies. And he's speaking the truth and you just don't like it. You kept saying, well, why haven't you included me on these big decisions? He did include you. He's flat out said, I disagree with you. And since you're not paying for anything and you don't have custody over him, he gets to make that choice. That is completely reasonable, and no judge is going to see his actions as irrational, unlawful, or unfair to you, inmate. She defines inclusion as being the decision maker, not being a part of the decision. You were able to voice your concern. You didn't want him vaccinated. Luckily, Brian has a brain, unlike yourself, and he decided to get him vaccinated and said, I consulted you, you made the wrong decision, so I went with the right one. When's the last time you answered my phone call? She thought she was going to get him with that one of, no, I answer them. He said, it's been a while. Why don't you answer? Because I don't want to talk to you. She can't stand that the answers are that simple, that it is as simple as people do not want to talk to you because you are not a nice person to your core, not a pleasant individual to talk to. So he is being as truthful as can be, and you are like kind of gagged, being like, I don't really know what to do now. So then you go to, so in regards to our son, you don't want to talk to me as his parent? And he's like, no, because that's not what you call about. What else do I talk to you about? Yell at me at this, do that. If you have been around on this channel when we covered the jail text, you know all she does is argue and yell to him about things he needs to do for her. She then shoehorns in her son every other line in order to make it seem like it's about him, but they're all requests for her. And she gets offended when you don't get things for her, not her son. And you think just putting the word, the noun in there of this is for my son actually makes it about your son. And that's the most transparent thing imaginable. Judges deal with this all the time. She is making herself look horrible with this questioning. And we just got started. But yeah, let's go ahead and look. We played a little bit of this clip before. I'm going to extend it just to see what she thinks her reasonable requests are and what she asks of Brian on a regular basis. To Brian. Phone call confirmation, commissary, soap for son, hymnal, keep it kosher food pack, pizza and wings hot meal, birds and blooms magazine renewal. You stated to me to call back Monday for order info. Per the phone call we had today regarding my reasonable requests I am still waiting on for you to order, as said some years, months, weeks, and after I heard you physically typing on your computer said reasonable requests to know and remember. I am forwarding to you again should you not understand, after stating you do. From any of the now 118 tablet messages I sent to you.
Yeah, homicide.
Previously, and you do not respond to any to date, and the 104 recorded telephone calls.
Yeah, double homicide.
Asking the same questions. Why do you make the active ongoing decision to not order any of my reasonable requests, including for my son? Why do you keep lying about placing orders for any of my reasonable requests, including for my son? Why do you tell me to call back or you will respond to a message for order confirmation numbers and you do not order? As stated, this will confirm you placed the order.
What else is it that I call for?
Yes, Sarah, this 100% proves that you only call him about your son. Like I said, you always squeak him in there, but that is rarely all that you're asking for, or even a majority of what you're asking for. And you do all this and you say it's 118 messages, 104 recorded phone calls, as if that looks bad on Brian's end. It just shows how relentless you are and how there is no other option or avenue we can take than this one.
When was the last time you ever answered a tablet message?
I've never answered a tablet message.
Including from Orange County 5 years ago?
Correct. Mm-hmm.
Why is that?
Because I didn't want to.
So you do not want to speak to me on the phone, and you do not want to answer tablet messages?
Yes.
How else do you propose you and I communicate being the parents of our son?
He doesn't want to talk to you, okay? He's made that abundantly clear. You do not need constant, sustained, daily communication about your child, especially when you are not involved in their life. It's one thing when you are actively involved. You get a divorce for a reason, so that you are not chained to each other in the same way you were when you were married. There is no expectation that he needs to talk to an inmate about that inmate's child every single day and bend to all of her whims and demands and take all your time and make sure that you explain everything to her 10,000 times, because she's going to ask you again until you give her the answer she's had in her mind. And if you don't repeat exactly what she's had in her mind, then you aren't answering the question and you aren't listening. He has made it abundantly clear he does not want to talk to you. He is not answering your phone. He does not care. And you're still trying to guilt him, which would make someone want to not talk to you even more. Also, what does this questioning have to do with anything? He has made it clear, and he is making a fool out of you by answering as honest as he can, and you think that makes him look bad, but yet again, you keep trying to hound and make him look bad, which makes you... Exactly, Linda. Your ceaseless attempts to try to show him as a bad parent only shows how good of a parent he is by trying to distance all of this dysfunction from the child. But go ahead.
I'm not sure what it is that you wanted to communicate about him.
Major decisions are one. Also,
for instance?
When have you ever responded to any of my letters that I have written to you from no response or answer of a phone call?
Like in the mail letters?
A handwritten letter, yes, that I have mailed to you.
I don't think you've done that in like 4 years.
You just told me 2 weeks ago that you received mine in regards to the visitation applications that I sent to you.
Well, yes, that wasn't a letter to me. That was an envelope with some applications in it.
In the parenting plan, it says that you are not to use the child as a ploy or a mode of communication. How else am I supposed to communicate with you if not through our son, through the letter, a tablet, or a telephone call?
Whoa. We all knew this was true, but I did not expect her to admit in open court. How do you expect me to communicate if not through our son? That is a major part of the parenting plan. You want to say he's not responding to messages, he's making you individually feel bad? Sure, whatever, but you are directly involving the child. This is what you are 100% not supposed to do and supposed to avoid at all costs. That's why you have all of these plans and rules in place so that you don't involve the child. And so you want to point fingers and say, look at you not doing this, this, this. I'm going to break the number one rule. I'm going to use our child as a communication tool to get to you so that you do what I want. Wow. And she says it like it's nothing. She says it like it's his fault. Oh my gosh, that's crazy. Wow. I did not think, I mean, yes, but.
Sometimes I'll start a sentence and I don't even know where it's going. I just hope I find it a long way.
She is literally telling the judge right now, hi, I want all of his money because he's forcing me to use my child as a pawn to get his resources. So please give me all of the resources I'm asking for and more time with my pawn son so I can get more of the things that I want. At no point is any of this involving the son's best interest. If you wanted to have his best interest in mind, you wouldn't bring any of this up to him. If you were truly a good parent, you would lie to him. I mean, you lie to him constantly, but you would lie to him and say, everything's fine. We're just talking things out. Anything that's happening between me and your father doesn't affect you whatsoever. You are amazing, and I hope you have an amazing day. I hope you love us both equally, yada, yada, yada. And then y'all can throw hands in the background.
Shut up.
That's ideally how this should work, with the number one goal being to distance the child from any conflicts, to not disrupt his lifestyle and schedule as much as possible, and to co-parent amicably until the child is an adult and can make all the decisions for himself. And she's admitted this in the text too, which is wild that she kept wanting to submit them. What is the status of any of my gifts I keep asking for? Am I going to have to start my daily devotionals in May like I had to last year and March the year before from me having to keep waiting for you to order? When you finally felt like it and kept telling me you did, and they were on the way over and over and over? Where is my car? Have you contacted Jim to find out? Where is my car? See previous messages asking the same question with no reply, nor ever an answer on any of the phone calls you force me to make every day about the same questions and concerns for years. Yes, years. Please respond. Please do not have to make me go through my son when I call to have him ask status of everything, including his Christmas present. Please do not have to make me go through my son when I call to have him ask status of everything.
How else am I supposed to communicate with you if not through our son?
Yeah, I read all your tablet messages. If you've got something you need to talk to me about it and you put it in the message, I will see it and I will answer your call. Or maybe even write back, but I've never seen that.
You just said that you do not answer phone calls because you do not want to. You just said you do not have this text message because you do not want to. You do not respond to letters. Therefore, I have to ask you regarding our son. You are putting our son in that predicament. Is that correct?
No, that is incorrect. That is very much incorrect. Wow, again, you are saying this in open court. This case is done.
Court dismissed. Bring in the dancing lobsters.
You just said you are putting our child in that position. You know, the position we both agree he shouldn't be in. But because you aren't listening to me, I have to put him in there. That doesn't make sense. She is literally blaming him for her abusive actions, just like we heard in the text where she's like, all the phone calls you force me to make. He doesn't force you to make any of them. He has to pay for them. He's begging you to stop. He is showing you he is not responding. You are saying he is not responding. And you, being the textbook abuser that you are, can't stand that. Can't fathom the idea that your victims who finally have freedom and space away from you will not respond to you. So you will get to him by any means necessary. that shows the exact type of parent you are, the one that doesn't actually care about the child's well-being, but your well-being first. And you only want the child to be happy when the child is happy with you. Wow. That is a crazy thing to say.
Now, if you have something legitimate you want to talk to me about, then you let me know, and I will talk to you about it.
How would you know if it was legitimate or not? You don't answer. I have nothing ever to speak
Once
to you
again,
about in regards to anything other than our
Hold on.
son.
Wait to the question zone. All right, now you may answer.
Once again, you can write me a tablet message explaining the question, and then I can answer. Or two, just when you're on the phone with Luke, have him say, hey, mom's going to call you out, blah, blah, and then you can call me about it. That's not making him communicate between us.
Why you can't just communicate as an adult and a parent do not have to include our son
All right,
in
next
this.
ask a question, Miss Boone.
Judge Jackson is over her. But this is normal for family court. Family court is vicious and nasty and ugly, and she's used to dealing with parents hurling insults back and forth, so has to keep redirecting them to answer the question. Ask a question or answer the question. Because she's not asking any questions. She's just arguing. Brian didn't answer her phone for all these years, and now she's going to let him have it in front of the judge. Why can't you act like an adult and just answer the phone and not have to include our child? At no point has he done this. You have never once said that he has used the child to communicate things to you. You have only admitted to using the child to communicate with him, and you're mad that it does not work. Why is she wasting so much time on this? Does she not know this is cross-examination?
Not argument. Ask a specific question.
Why do you allow, why was your statement made that our son is upset after speaking to me on the phone? Do you know specifically why? Because you asked me or him?
Because he tells me. I can see him.
I'm asking you if he explained to you why he was upset.
Yes.
And why is that?
Can I mean, any number of different reasons. The way you talked to him, what you said to him, how you made him feel. I mean, the plethora of emotions that you corrupted.
Is it because you allowed him to curse on the phone?
I allowed him to what?
The majority of the time, I will tell you this, which you are unaware of because
You're
you
not
do not
telling anybody anything, ma'am.
Yeah, double homicide. No, I'm sorry.
I know that's right, Your Honorable Miss Jackson. Let her have it, because exactly, this is just how she's run her whole life. And she doesn't realize how horribly she's truly coming off in front of the judge. Wow, this is crazy. So he brings up in his direct testimony about how he feels terrible, the son feels bad a lot of times after talking with Sarah, because all she does is berate him and guilt him into loving her more, and blames him for not trying enough, for not putting in enough effort, for not manning up enough, for not speaking enough. That would upset anyone. It upset me just reading those things, and they aren't directed at me. But as a child, I'd probably be like just broken inside, saying my mother says these things about me constantly. The woman in prison for life for murder is calling me a bad person. Which means on some level, he's probably internalized this, no matter how many times people tell him, you are nothing like her, do not really value her opinion. She's upset because she's upset at her own life and not yours. So you can't take what she says as a serious or genuine reflection of you or your actions, but it is just something you have to deal with until you get the choice to fully be able to decide whether you want to deal with it or not. But wow, he flat out tells you it's because of the way you talk to him. And he's upset afterward. That's what he tells me because I can see him. And I've mentioned this in prior videos in the past of the reason he hangs up on her, like Brian will interrupt sometimes and hangs up on them, because he can see where the conversation is going. He can visually see how his son is reacting. And if things are getting too bad, he needs to stop that shit. And I mentioned there, I'm not going to find it, but that Brian has to sit there and decompress with his son afterwards. Whatever emotional state that she has left him in, he has to deal with that, console him, and to take the weight away from those words. So then later on, she gets mad that it seems like nothing I do really impacts him. And why doesn't he know how much I love him? Because you tell him the opposite through your actions and your insults. And then you turn around and say, I love you, so let's just forget about that. And that's not how this works. You could have done one of these abusive messages that I'm about to show so that we can see exactly what she says when she talks to her son, because I can only imagine what she actually says to her son based off of the text messages she writes recapping what she has said to her son. But if you sent even one of these messages, it could permanently ruin or distance or damage any child-parent relationship. And you can't call her out for it because she just won't hear it. So when you bring it up to her, she doesn't care. She was never actually asking for the, well, did he tell you? Well, did this? Or did you ask me? How would you know? Why would he ask you if he was upset? Because how would you know he was upset if he was upset after the phone call? Plus, your opinion of how he feels is not as important as his opinion about how he feels. And what does Sarah do? This is just emblematic of her parenting as a whole. You confront her saying your actions are causing a negative reaction in our son. And she goes, well, ignore that. Is he feeling bad because you allow him to curse on the phone? I will tell you this because you don't answer and you don't know and you don't communicate. And Judge Jackson cuts it. You're not telling anyone anything. You are here to ask questions, not to tell anyone anything at this moment in time. But she just gave it away right then and there. She is saying because he curses on the phone, that would be the only reason he feels bad, because I go in on him when he's being disrespectful. He has said mean things when I have tried to correct him from treating me poorly. Who corrects you from treating him poorly? Besides Brian, who tries to end that conversation or to put as many barriers and protections in front of his son that he can. But yeah, let's look at these text messages again and see exactly how she talks to him. And then ask yourself, why on earth would the son be upset after speaking with this woman? Oh, okay, this is her first message to her son. Hi, sweets. Thanks for setting up your account finally. I guess better late than never, huh? I'm excited to talk to you this way now too. It's strange to be messaging you, but another way to tell you how much I love you. I tried calling you 2 to 3 times so far today, but no answer. What are you doing? I hope your day is nice. Like you. Sometimes. Question mark? Go check the mailbox to see if your card came I sent. I don't want to hear Dad say you can't go check later at night, and I don't want it sitting in the box while you're gone. Don't open if it is there so you can when we eventually have our video visit. Do emojis work? Can you see them? Oh, okay. Talk to you later. Right back about card and emojis. Love you in the meantime. Nah. So I'm guessing all these random question marks are the alleged emojis. Why are you still so snarky to your son? Like, this is rude. Sent to son. Smile, love you. Hope your day is super. Just wanted you to know I'm thinking about you. All the time, actually. Please tell Dad to take pictures. Talk to you later. Be safe, please. Love, 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 love you. To her son. Happy New Year. Or just New Year. I'm praying you will help make it a happy New Year. I keep trying to call you on your phone, and still it goes directly to voice message. I really do not want to call Brian, as I have said in the past many times. I was hoping you would actually listen and care and make an effort just simply to have your phone on and charged so I can talk to you. Why? It's not like I'm asking you to grow a third arm or lasso the sun. Just answer your phone. I hope one of your resolutions, if you have any, is to be nicer and respectful to your mom and to understand my feelings. Yes, I have feelings, and how much you crush them by not caring enough to simply plug in your phone. Would you make sure it were on if Addison called, or Mary, or anyone other than me? If you are choosing not to talk to me, I wish you'd just man up. Jesus Christ. You're telling your teenage son that you just need to man up and tell me so I can stop looking like the fool you are making me out to be by calling just to be yelled at, called names, or hung up on. If you have nothing to say to me or care enough to include me and share your life, just be honest and say so. You are my son. I am your mom. Forever. No matter what, where, when, why. No matter anything. You can't delete, erase, blot out, omit, change, or remove. Stop being mean to me and not caring. I'm already going through so much, then to be disregarded and spat on by you is unspeakable, and for no reason. Do you delight in making me feel worse? Does it make your day knowing you make me cry and feel worthless to you? Who am I to you? Really ask yourself that. Punching bag? Daily joke? Unwanted friend? That's how you make me feel. Know that, son. I can't make you care. I can't make you love. It's your choice, yours only. New year, new start, new everything. Your choice. Don't forget about me. Love always. Who am I? Oh my gosh. To son, Sarah. Sunny day, Sunday, scripture. This is the day the Lord has made. Let us rejoice and be glad in it. Psalm 118:24. Be glad always. Every day is a precious and unrepeatable gift. You can't go back and change what you said or did or didn't do. Every day you have one chance to shine bright for Him, yourself, and others, including your mom. Be a rainbow. Be nice. Love more. Smile and believe in the good. Unrepeatable. Make all your days count. Love you. Oh, 14 minutes later. Plug in your phone. I've been trying to call you on your phone the last couple of days, and it just rang and rang, then voicemail. Now it just goes directly to voicemail. Please make the effort to plug in and charge your phone and make sure you have with you. It's not nice to me to not be able to talk to you because it's not on, especially with all the time off you've had for the holidays and the long weekend now. 2. I've explained many reasons for not wanting to call Brian's phone. Remember, if your decision is for me to not be a part of your life and keep trying to talk to you, just say. Just say. Your response last time I asked was that you wanted me to be. I wouldn't know from the lack of effort and intention to make possible from you. What else can I do? Honesty and effort. Not asking much, but missing out on talking to you. My one and only son. Love, your one and only mother. Please plug in and charge your phone. Keep with you so we can talk, please. To your son. Trying to call you. Your phone goes directly to voicemail. Still trying to call. Why can't you make sure it's charged and on and with? Please know it is not me not trying to talk to you. Effort and love? To son. Trying to call again. I just tried calling yet again. Why can't you? Rather, why won't you make sure your phone is charged and with you to talk to me? For how many times I have asked you and Brian, I keep using my credits that cost 50 cents each to remind you. Please plug in, charge, have with. Love and effort? Day, Sunday, scripture. Whatever things are true, whatever things are noble, whatever things are just, whatever things are pure, whatever things are lovely, Whatever things are of good report, if there is any virtue, and if there is anything praiseworthy, meditate on these things. Philippians 4:8. You have so many things that are praiseworthy and positive to think of joyfully, most of all, Him, and also including me. I meditate on the good things and people I have right now, no matter where I am, and always focusing on the positive. You can too. See the rainbows in the storm, no matter how heavy and hard they are. See them and know they are coming. Meditate on the good which is everywhere. Love and effort. To son. I love you. I hope you're enjoying your day, my lovely darling. I'm thinking about your sweet face and how much I love you. Love you, love you. I'll keep trying to call. Miss talking to you and knowing how your life is going. Please don't ever think I'm not a part of it. I am, no matter what or where. I'm never going to give up being in it. And for you, no matter what or where. I love you for everlasting to everlasting. Always know that. Talk to you later. Heart, heart, heart. To son, I try calling you every night with no answer. Don't you know by now the evening time is when I am able to call you so you have your phone with you? I call every night, every night. Tonight it rang and rang, then went to voicemail, then voicemail directly when I called back. You don't want to talk to me? It makes no difference when it is, as it's the same thing on the weekends. Anytime I call you, please don't think I'm not trying. It's you who are not. I hope you answer sometime. I love you. To son. Test. Test. Love you. Sunny day. Sunday. Scripture. Quote, I've learned that people will forget what you said, people will forget what you did, but people will never forget how you made them feel. Maya Angelou. Oh, your Sunday scripture is Maya Angelou, the patron saint, Maya Angelou. Oh, I love it. Make sure others remember how good you make them feel with all the softness, understanding, love, and positivity you can give to everyone, including me. I want to remember good things from you, which there is an overabundance of, now and future. Make a difference. Be the difference. Take the extra minute or extra effort to remember that I remember too how you make me feel, your mom, along with everyone you come in contact with. Remember, I love you. Thank you for your goodness. How many times are you going to try to guilt this boy into loving you? It's not going to work. Effort and love?
Gretchen, stop trying to make
Effort and love?
happen. It's not going to happen.
Who am I? Oh my gosh. And those messages came from just a couple of months. Handful of months. And she has been doing this same tactic to that boy for years. Well, over 4 years, for 5 years now. But for years, she has tried to guilt this boy into loving her the way she wants him to love her. And now that she's getting called out in open court, she wants to say, well, don't you know it's because you allow him to curse online or on the phone? And that... Exactly, Linda. She hears how you talk to him too, and there's absolutely no excuse ever for you to try to guilt him the way you have guilted him, especially after you, Sarah Catherine Boone Paulson,
The clown killer is
Eating my peach.
my son!
has murdered someone.
You're asking a specific question. Ask your question.
Yes, Your Honor. Do you understand the majority of him being in quotes upset is because you withhold him coming to see me? And he's had to wait over 9 months now that he has the opportunity to, and you continuously lie to him and me about, and the court, filling out the application.
Okay. Not at all what he tells me. You specifically, the way you talk to him is what upsets him. And honestly, before yesterday, after you got done talking to him, he told me that he would prefer him being able to make the decision of when he wants to talk to you.
Yes, we spoke about that yesterday, and what he said to you was,
Right. So
did
I'm
not
going
know
to
also.
object at this point that the child here
right.
is happening.
I'm going to sustain the objection. Move on to a different topic.
So, in regards to telephonic communication, which is regular and has been, I wanted to find out if you understood that I know about his girlfriends, about his laughing and joking.
Not gonna,
and break.
ma'am, we're going to stay on topic with regard to the issues here, which are the proposed parenting plan regarding the sole responsibility, the modification of child support, and the modification of alimony. Your question on those issues is?
Yes, Your Honor.
That's absolutely insane and unhinged. Why would you bring these things up? What do you think that does? What do you think the judge is supposed to take from that? Oh, wow, she knows about his girlfriend and other things and happy and jokes or whatever. That means obviously she's a better parent in jail than he is outside. And this is exactly why no one wants to tell you anything, because you air out everyone's business anytime you think it can benefit you. This isn't our business. We don't need to know about this. And I get it, we're watching a court trial, but the judge especially doesn't need to know about this. And that's why she instantly cut in, being like, we are not doing this. There's a reason the child is not here today, because this does not concern him at its core. This concerns her actions and whether the father should still have to keep paying her because of her actions. She is the one who wants to make the child an equal party in this, when the child should not and does not have say over the outcome of what happens today. But she completely deflects from the question again. The first time is, she didn't even need to bring this up, right? She could have glossed over this, but the fact that she is putting such a spotlight on it, and the judge sees how she answers and talks right now, we can only get a glimpse of how you actually speak to him. So you redirect and say, well, don't you know that he's upset because he hasn't seen me? I get it, he's upset every time he talks to me, or a lot of times after he talks to me, but that's only because you haven't let him see me. That makes no sense, and no one would believe that. But she lives in this delusional world where somehow that excuse is the one that's going to convince the judge that Brian is the unfit parent. Paulina wanted to parachute in and said that she agrees. Just answer the question if you're going to bring it up. He says it's because of the way you talk to him, and you try to redirect it twice now, and it's going to fall flat every time. Move on. The fact that the judge has already had to redirect her so many times, does she not get that she's losing?
Yes, Your Honor. The sole responsibility has not changed since day one of me being incarcerated. He's never asked me.
I'm not asking you for your position, Ms. Boone. I'm asking you, do you have any additional questions for Mr. Boone on those topics?
Have I ever purchased a gift or something for?
With your own money?
Have I purchased any items for our son?
Well, I purchased them.
Your Honor, I need.
Hold up, stop.
I need some scope of what time period she's talking about.
All right, I'm going to sustain the objection. Re-ask your question, and you need to put a specific time period in your question.
Within the last month, what have I purchased for our son?
You had somebody third party else, not you, buy him a record for his vinyl player.
Have I purchased previous items for him?
You have had a third party, not your money, not you, purchase some things for him. Yes.
What family members do I have helped pay?
Excuse me?
I'm sorry?
What'd you say?
My family members. Who is it that I can have help pay?
Philip's the only person.
Why is that?
Both my parents are deceased, my grandparents are deceased, my aunt and uncle are deceased. I got nobody. I have a brother that's in the Marines, and I've got another one that's in jail.
Because your other brother's not really capable of doing anything, and your mom and dad are dead, and you don't get along with any of your other relatives.
Are my grandmother and grandfather deceased?
Well, I mean, you're almost 50 years old. Most people, their grandparents are deceased at that point.
All right, Ms. Boone, what's the relevance of these questions?
There is none. There is absolutely no relevance to any of these questions. It is her yet again just trying to deflect blame and to say, I'm not a deadbeat parent because everything else in my life is ruined and that's why I can't fulfill my responsibilities, but my desire to fulfill them should outweigh anything that I have neglected to do. And she started this little section off going with, sole responsibility has never left. Correct. She was trying to say, meaning he doesn't include me, but the fact of the matter is he has had 100% custody of the child since you've been incarcerated. You have had zero responsibility. Even if he called you for every single decision he could possibly make for the child, you still would not have responsibility over the child. No matter what happens on the outside to your child, everyone is looking at him, holding him responsible. You are an afterthought at this point because you have been determined that you need to be taken away from society. And that's why Judge Jackson cuts that off and says, I'm not looking for your position. Again, this is still cross-examination. What questions are you going to ask him about what he testified to or any of the other subjects that we're talking about? She's just not paying attention at all. And she's wasting time and is going to get mad at everyone else because she's focusing on this. Have I ever purchased my son a gift? Even if you did, even if you purchased gifts for him every single day of his life, what does that mean? Nothing. You're that kind of parent who thinks I can buy my kids love if you had the money to do so.
Insufficient funds. You ain't got no money. Woo.
And that you providing gifts means they need to return to you boundless love, and everyone needs to recognize you as an amazing parent. That is like the bare minimum. And she's mad because in Brian's response to her motions, he called out that, like, yeah, she doesn't have money, but she hasn't asked any of her family members to help fulfill her obligation. Because to cancel out the money that she keeps claiming she's owed, they're saying that she had a child support obligation that she never paid, never tried to pay, and never asked anyone to pay. The only thing she asked and begged and berated her brother to get is this damn fish soap.
Thank you for the packages. I'm so upset. I won't get them until next Monday, so I'll let you know. For son, I would give you his address to have the soap shipped to him. Brian has no say in it or about it. Just order from the website and have it shipped to son. Please cancel the package or whatever so he can finally have this. Please, please let me know if you do and if there's an ETA for him to receive, please. I just don't know what to say about anything anymore. God help me. Thank you.
Wow. Yeah, she crashed the fuck out on this one. This is a 10 out of 10. Yeah, that's really going to make me want to give you my address now. So if you really wanted to support your child, you have the gall, the nerve, the gumption, and the audacity to hound your family members to get things you want to get him. But not to say, hey, can you float a 20 over there every week or so? I don't know. It's something. And it's not your responsibility, but here's me sending a message just trying to show any effort, any opportunity, any chance, any thought that extends past my own comfort, needs, wants, and desires, and shows that I would like you to take care of your nephew in any capacity. Don't worry about getting me Wings meal or this damn book for the millionth time. How about you support my child, your nephew? That way we all feel good about me harassing you, at least to do something nice for someone else. But no, she hides behind the same excuse she always has, and my family's dead. Everyone's dead. And that's why it's okay for her to act the way she acts and to hound Brian relentlessly. She even testified to that at some point of saying, Brian is my go-to because my family's dead and I have no one.
Brian was kind of my go-to person because of my family being deceased, and I don't have anyone else that I can call. And I just wanted to ensure that he would not bring my son over in the process.
Can you imagine anyone out there who has 2 other siblings, so 3 in total, and both of those siblings alive? Could you imagine constantly saying, I have no one. My whole family is dead. No one. And then in the same breath, thank you, Philip. You're my best friend. You're amazing. You're the only family I have. Thank you for sending me all of these things, but also I have no one. And you don't exist. That would infuriate me because it's like, what else can he do? He supports you as much as he can, and you still erase him from your existence and say you have no one. It's just as powerful to say, most of my family is gone and all I have are my brothers. They can't help me in the way that I need help consistently, but they're the only family members I have. Everyone else is gone. You can still get sympathy from that, but you erase your whole family, and then that's called out to be a lie almost instantly. So then we're like, okay, what is the truth? Why do we care? And I don't know if I've played the messages already because I've done this video's taken so long in chunks, but let's just look at the text messages that she sent her brother. This isn't all of them, but more of a condensed version, just to see what does she ask her family for. She says, I have no one except Philip, her younger brother, completely ignores her older brother. I understand why, but he's still alive, and you can't just ignore someone's existence. And just like Brian said, and you don't get along with everyone else. See, I knew it. I knew she had to have had more family than just her direct, intermediate, and slightly extended family. But Brian says they don't get along, and that tracks with everything else. She burns bridges left and right. Philip, the brother, introduce new character. Welcome to the stage, Philip Paulson. I am so sorry for what you're about to go through, but here we go. Hi. Yay, it finally worked. Unfortunately, it cost money to message, 50 cents. But you get, I think, 30,000 characters to write. Of course you do. And of course you found out it's 30,000 characters after sending 1,500 agains and agains and agains. And yes, what you are doing is and has been proven mental and emotional abuse. It's recorded again and again and again and again, again and 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 oh my God. Whoa. Oh my. Oh, she's proud of it. She's proud of figuring out that there's 30,000 characters. Right now, I only have 39 cents. I wonder why. I wonder why you only have 39 cents. And I've been waiting for Brian to add more for 3 days now. Sorry for the COD, but I'm just happy and excited we're connected. The tablets are for toddlers and painfully basic, but at least it's another form of communication. Just know I love you. Talk to you later. Smile. Book ordered. Hi again. Have you had a moment yet, please, to check the status of the rule book? I've got all the paperwork ordered. Thank you, but need this to put everything into play properly. Hope you're smiling and having a good day. Burr loves. Bonds, one of the first responses we get. Book ordered. It got sent back again. I just ordered it to come here and then I will mail it. I got you coloring books, so that may have been the issue. I don't know. Hope all is well. Keep your head up. Love you. Nice and supportive. Book ordered. What the fuck? Cancel the order you placed to have shipped to your house. I can only receive orders directly from the distributor and with a receipt. What was the reason? Are you positive it's soft cover, which is the only type I can receive? What date was it returned so I can see if an officer can call the mailroom and find out? Are you positive a gift receipt was included? Do you have my address correct? Sarah Boone, 205623 FDC, but I can't do anything without this, as you know. Thank you for the coloring books, but I really need the other the most and first. Please, if anything, if you want and can, please add to my commissary account since I'm in the negative and can finally get some coffee Brian keeps telling me he ordered for ongoing 3 months instead of the coloring books, please, if you can. Again, the book is the prize and I am grateful no matter what. Your sweet gesture of coloring books is a blessing. No, I am beyond grateful and I love you for your support and kindness. Let me know what you think and confirm you have received this message so you know everything and I know what to plan on. Thank you always, Philip. Hi again. Doing okay? Hope you're having a super day and feeling good. Got any updates? Hi. What's the status? Just waiting for this still, and the torment and withholding from Brian of everything is growing daily, weekly. This is the 3rd week he has decided to not provide me with anything, food, stamps, socks, etc. I've sent asking as he makes me do just to tell me maybe. Then nothing happens. I haven't even had a video visit with him to open Christmas presents Brian keeps telling me he ordered. I need to get him in court. I can't take much more of this. Truly. Thank you, Philip. I love you lots. I'm holding your book in my hand and I'm going to print out pics Monday and then mail it to you. Breathe and relax. I had to buy 5,000 credits to email you also. Stay strong and I will tell you once I mailed it out this week. Love you. To brother. Stop! I cannot receive the book from you. It has to come directly from the distributor. I sent you 2 messages telling you to cancel the order and place again to come from Amazon or wherever you're ordering. This is why I get so frustrated, and I know you are too. But there is criteria that has to be met or the entire order gets sent back. Soft cover only comes directly from distributor. A gift receipt or receipt must be included in the order. My info must be correct. Sarah Boone, don't waste money sending from you. Please, please, please reorder so I can finally get this book to get asshole Brian in court. He's withholding me money again for the 3rd week and I have nothing. Please, Philip, I cannot take much more from him. Let me know you got this. Thank you. You know I am grateful. Tired, sad, but grateful. She sends this within the half hour to her brother. And thank you for the pictures you're sending. Very excited to receive. The other girls too who have been asking. Thank you also for the credits. You have to transfer them to me from your account. I love you. Thank you. This isn't forever.
Court sentences you to life in the Department of Corrections.
Let me know about the book. My number is da-da-da-da-da-da-da. I forgot to add a 0 in my other message. Did you really put $50 on the tablet for messages? I could use that for my commissary. Brian is refusing ongoing a month now, and I need stamps. He won't give me because he knows the paperwork is about him to the judge. He's told me 4 months he's ordered effing coffee. He just called me a murderer.
Will the jury find the defendant guilty of murder in the 2nd degree?
On the phone this morning after messaging him, trying to get him to add funds. He keeps telling me he did or is. Just transfer some from the credits if you can do anything at all. I'm in the negative $49.25 anyway, so I'm probably too far gone at this point. Sad, tired, WTF'd. Let me know what's going on. One day I will have good news to tell you. WTF. See, it's never good enough, Philip. It's never good enough. To your brother, hi, what's happening? What's going on? Hope you're having a nice weekend and have lots to look forward to this week. Got any updates about this spectacular book? I haven't heard from you, so I don't know unless I ask. Going on a whole month with nothing from Brian except lies and bitterness and a hard time. Every time. Nothing. Can't do it much longer. Do you know how to transfer your credits you said you purchased? They're still not showing up. Smile. I am because of you. Thank you forever. Love you. To brother. Mail and letter. Hi again. So we are being forced to use these tablets from mail, now effective April 19th. This means we will no longer receive physical mail, and everything, letters, cards, pictures, will be scanned and uploaded for viewing only. I can't hold or really look at anything you send once they're uploaded. Then they shred them. What the fuck? Please send the pictures you've been telling me you're going to for over a year now. Please send the contempt letter for me to include with my paperwork for the judge you to get Brian in court. This is the last opportunity I will have to get a picture of mom, you, etc. And I do not want them on these stupid tablets. I want to put them in my Bible and be able to look at them when I want, not when they tell us we can. Use the tablets, and if I even get one, fighting 63 other girls to use. Thought it was 64. Please, Philip, I really want and need these. The contempt letter will only be on the tablet, and I will not be able to print and include. Before this starts, send anything, everything you can or want to my P.O. box. But after April 19th, everything will be sent. Smart Communications, Orange County Department of Corrections, attention. Sarah Boone, Seminole, Florida, After May 6th, anything sent to my old address will be returned to sender. You can also go online and set up a free account to check status of what you've mailed at www.mailguardtracker.com. This whole thing is so depressing and makes me mad. It's just another reason for OCCD to be even lazier, and they don't realize what it means for us inmates to even receive mail. It's a highlight in many ways for us and gives us something to look forward to. They do not care. I hope you do and will send. Remember, it's 5 pictures per envelope. It will be the last time I'm able to have anything. Please understand. Please respond so I know you received my message and what to plan on. It's just another major ugh. This isn't forever.
Life in the Department of Corrections.
Sigh. Love you. Thank you. To brother. Package, etc. Hi again. I forgot to tell you, when you want to send the Delicious Delights package, I can receive now. I waited a whole other week to make sure nothing was glitching or wrong with my account like last time. Which, just to cut in, there was nothing wrong with her account originally. It was she had reached her limit for the amount of gifts and packages she could receive in that given time. So she's like, I waited even a week longer. It's because you're receiving packages from people you aren't disclosing, and you maxed out your limit to where when your dry begging actually worked with your brother, he tried to order it for you, you couldn't. So you did wait an extra week to make sure that time could reset, and now he could buy you a new package. Just had to say that. I can't thank you enough. This also is the second week Brian has withheld.
Send me money, send me money, send me money.
Giving me money to buy commissary. I need thermals so bad for it being so effing freezing in here. I'm just sitting here literally shivering, doing my best to stay positive and keep going. The days are getting heavier and more arduous. Thank you beyond measure. Also, have you come to a conclusion for my bond to use your address so I can update my attorney? I had my status hearing on Friday, if you didn't already know by seeing me all over the news, with nothing new to report as usual. I told her I was waiting to hear from you. Do you want her phone number, or am I able to give her yours? Remember, she's a viper. Don't let her deter you, please. You're stronger than that, and know me when I tell you something. It's true and from experience. She's been doing this fucking job for 40 years. You're going to say, I know from experience. You think she hasn't dealt with countless murderers like you? Remember, too, I'm still trying to figure out who she really works for, as it doesn't seem to be for me. If you only knew. Please let me know. I'm trying to get whatever, quote, life I have in here together, and I'm waiting to hear from you. This is important to me. Actually, it all is. Please understand. See it from my perspective and what you would do and how you'd feel if in my slides. I'm grateful and I love you. Thank you always. All right, Philip, we have abandoned the no matter what. She's not saying help me no matter your decision. She's saying help me now. See it from my position. I'm poor. I'm this. All my family's dead. If your whole family's dead, that would mean his whole family's dead. But you want him to feel bad. No. Thank you, Philip. Please do your best to send out the letter, as once it's on the tablet, I cannot access without a court order and can't take the tablet with me to court. He just told you he's going to. What is wrong with you? I know you told me just to do it, but I'm going to remind you, please make sure you do it. Plus, I really want to physically have your pictures above everyone else's to put in my Bible. Just take 20 minutes, print some out, and reprint your letter to stick in the mailbox or run to the post office. If you can send expedited for a few dollars more, I'm excited to see you any way I can. So you want him to spend more money on top of giving you money, on top of getting you things, on top of buying you things, on top of photocopying and sending you more mail and things. After this, if you send me pictures, they can only be uploaded to these ridiculous tablets, and the cost is $1 each. So imagine how expensive that will be. And I do not want you or mom uploaded. Bible only. Remember, it's 5 pics per envelope. Why are you repeating the same message you've already sent? When I talk to my attorney next, which I don't know when it'll be, I'll give her your number and tell her you're waiting for her call. Do not let her deter you. She'll tell you 1,000,001 reasons why not. She doesn't want to do the work. Again, and do not tell her this, we both know I can't pay, nor am I going to try. It's a principle and right I very much want to take advantage of while I still can, so I can say I either tried or succeeded in something in this debacle of a case everything has turned into 4 years and counting. I've had no success in anything. And if this is something I have to do on my own like I do everything else, then God help me do it. One of her reasons not to do this, she's going to tell you, is because, quote, someone's going to say something negative. What the fuck? Are you serious? What hasn't been already said negative and false and hateful and ignorantly? What hasn't been released to the internet before I even see to properly defend myself against all the ignorance? Remember, Philip, help sharpen my sword. She's vicious and derogatory and seemingly not working for me. Just be prepared to overspeak her and just give her your address if that's the decision you've made. Simply just your address. If one of my many, quote, fans decides to set up a GoFundMe page, so be it. If I don't even get the bond to even hope someone makes an attempt or pay, so be it. Quote, you cannot buy the revolution. You cannot make the revolution. You can only be the revolution. It is in your spirit or it is nowhere. Ursula K. Minguin? Writer, I wish you would tell me in advance your decision rather than embarrassingly have to be told by Trish. You call her Trish? She's not going to promote. She's going to hinder, sharpen, not dull or hide. For the delicious delights, thank you. Let me know what it says, please, so I can make sure my account isn't still screwy. I'm just still here waiting for everything, everything, everything. God must truly believe in me as much as I do him. Many times I wonder what his point is in having me go through so much persecution, struggle, difficulty for everything, everything, everything. His will, not mine. Hard stop. It was your will to murder someone. Too, brother. Remember me? I pray you are all right and loving life with not hearing from you. Just trying to get some to-dos off my list, and I hate having to keep bothering you. So what's the scoop? Did you get your letter and pictures out? I've not gotten anything yet, but hopefully today. Did you decide what to do about my bond needing your address? I have not spoken to my attorney and am waiting so I can give her your number. I wish you would tell me in advance, Philip, what you're deciding, please. She's going to immensely delight in telling me bad news, and I'm not telling you anything she's not going to. I'm just looking at it as my right, which I believe in and should be able to take advantage of. If I can pay it or not, I, not you, or God, however he may decide. If you give me your address, that's it. I just need your address, please. Did you order the package yet? If it's possible and you haven't yet, Brian hasn't given me commissary funds for ongoing 3 weeks now, and I really need thermals and socks. He gloated about his 2K plane tickets he bought for their cruise to Alaska next month. That hurt. Are you able to
Send me money, send me money, send me money.
add to my commissary account instead? I'd rather be warm than full. I only eat maybe 1 time a day anyway. And any food I do get, I stretch for weeks. Coffee is a different story and is what keeps me going, working on everything. Motivation in a cup. I'll figure that out later. Just let me know what's going on when you can. You don't answer your phone, so I'm hoping to double my chances of finding out what I need to sooner than later. Love you in the meantime and always. This isn't forever.
Ms. Boone, court sentences you to life in the Department of Corrections.
Thank you, no matter. Again, another lie. Not thank you, no matter. She even says when/if you give me your address, but she means when, which is why she put it first. Wow, I cannot believe she told you that. I'm not upset with you, so don't get it twisted. You do not have to go to the courthouse and get your picture taken. For the phenomenal amount of people that have come and gone in the amount of time I've been here, no one has ever said they have to do all that. So what's the point of a bail bondsman? They're the one who tells you what you need to do, etc. And it makes no difference as the point of the bond is for me to use my effing rights. What the fuck, what the fuck, what the fuck, what the fuck? And her telling you about the news cruise? Really? How would they even know about anything to be there? And her telling you to encourage me to take a plea deal? Who the fuck is this woman? She's never said anything to me about any of this, but does you and threatens me through you with life in prison if I don't take whatever it is they're supposedly working on together and not with me. OMG, for every person I've known in here to have her as their attorney has either fired her or gone against what she tells them because she lies about everything, which I told you about already. Perfect example. My friend who was in here with me for 4.2 years and had her for her attorney hated her. The attorney kept trying to get her to sign for 10 years probation and going to program for 2 years. My friend said no over and over and kept holding out. She went home 2 weeks ago with all her charges dropped. This bitch kept threatening her with prison time too. And you see what happened? Please, God, tell me she hasn't brainwashed you. Please, God, you don't know anything about anything, only what she and all the other lying piece of shit lawyers tell you. I don't know what to say except I rebuke you, Satan. Not you. Another defeat and more lies. Thank you for the packages. I'm so upset. I won't get them until next Monday, so I'll let you know. For son, I would give you his address to have the soap shipped to him. Brian has no say in it or about it. Just order from the website and have it shipped to son. Please cancel the package or whatever so he can finally have this. Please let me know if you do and if there's an ETA for him to receive, please. I just don't know what to say about anything anymore. God help me. Thank you. Wow. Yeah, she crashed the fuck out on this one. This is a 10 out of 10. All of that to say, She has no issue asking her brother to do things she wants him to do, regardless of how shameful it is or regardless of how selfish it is. So the fact that she did not ask him to help her support her child was a choice.
Because they're trying to make me seem that myself and no one in my family is contributing to my son. And it's difficult when my family is deceased and my younger brother is in the military on his 9th deployment in Israel. So
All right, ask your
whatever
next
it is
question.
I do.
Ask your next question.
May I please put in an exhibit?
Any objection to her putting it?
I haven't, I'd like to see it, and what she's specifically talking about.
Which exhibit, Ms. Boone?
The exhibit, please, is number 37 on my exhibit list per the uniform order, the GPL communication current pricing.
Give us a minute.
May I approach
I'm
the
sorry,
clerk, Your Honor?
number 36.
Just a minute.
I have no objection.
All right, Ms. Boone, council has no objection to your exhibit, so I'm going to receive what was pre-marked as number 36 as respondent's exhibit number 1.
Yes, Your Honor, that is to show, please, that it's 13 cents per minute for me to speak to my son on the phone. And also the fact that we have
Hold up, stop. Slow down for just 1 minute. Do you want Mr. Boone to see that document? Are you going to ask him a question about the document?
Yes.
All right, just give us 1 minute. Mr. Boone has taken a look at the document. No, he's going to keep it.
No.
All right. Do you have a question for him about the document?
When you originally signed up for this account in order to utilize the phone option, were you aware of the 13 cents per minute?
Yes. I have to pay for all the phone calls.
So you accepted the fact that it was 13 cents per minute?
You don't have a choice. That's the only way to have phone calls in the jail.
Yes or no? For most of my questions, it's just a simple yes or no.
Oh, okay. Take it easy, Miss Thing. You have never given a simple yes or no to any question, so I don't want to hear it. Oh, she's trying to play lawyer now. She's spicy. But this questioning is stupid. What does this have to do with anything? Hi, let me enter into evidence this exhibit that says the calls cost 13 cents a minute. Okay, that's 13 cents a minute you aren't paying. And while that doesn't seem like a lot to you, with the amount of phone calls that you hit them with, that you berate them with, this is going to be a lot of money no matter how many calls you have. So you're going to be like, oh, this doesn't cost this much, this doesn't cost that much. But it piles up with how relentless you are in the communication expectation that you have for everyone. When even the judge is telling you that you have unrealistic expectations of communication with your lawyer,
I have concerns that your expectations of what any court-appointed counsel might do as far as spending time with you and the depth and degree of communication may be unrealistic expectations.
you can only imagine the unrealistic expectations she has with everyone else. Well, actually, we don't have to imagine. We know exactly what she does. We know she calls them 3 times, 4 times. Still trying to speak to my son. I am floored. You nor he answered the phone after calling 3 times on each. Let me guess, you're watching a movie. I've told you in the past what it is for me to get a phone call. Nonetheless, 3. Wow. 7, 8, 9, 10, 11 times in a row. 2, son. I tried calling 9 times today, 8 yesterday. Just for you to yell and not care as usual, and still explodes when they do not respond. That is like nightmare fuel type stuff. They wouldn't even do that in Scream. I don't think they called the the murder victims 11 times. You would not in any world or reality imaginable let him not accept that 13 cents a minute. You would throw a fit if he said it is too expensive because it is 13 cents a minute. You would have lost your damn mind. You already have, given what we have just witnessed and what we will continue to witness. But yeah, no, don't even act like you would even give him an opportunity to reject paying for those calls. And you weren't going to pay for them. And you still haven't to this day paid for any of them. But go off. Yes, ma'am. Linda said, not too much now. You're doing a little too much.
For most of my questions, it's just a simple yes or no.
All right, ma'am, what's the point of this questioning?
Because he's making it seem that it's a very expensive phone call for me to speak to my son, and it's just 13 cents a minute, and we don't utilize the full 30 minutes each time. So by him setting up this phone account for the 13 cents per minute and free phone calls.
All right, the court has taken notes that it costs 13 cents a minute.
That you were in the shower. While you were in the shower. Because you were in the shower? Well, you got in the shower?
I believe the witness has made it clear that she was in the shower.
Based on exhibit number 1, your next question.
Okay. This is in regard to the exercising of overnight, where he stated that it was 30% about for my average. Can you please explain to the court my conversations on more than one occasion of why I could not have 100% or 50% of my time?
So I'm going to object. That's self-serving hearsay, what she said to him.
All right. I am going to sustain the objection. Next question.
Did I ever explain to you the safety risk and danger of having my son come over on particular days that it was mine?
Not really. I mean, kind of, yeah, I guess. I don't know, most of the time when you had me come over there and pick him up and was supposed to stay over at like 10, 11 o'clock at night, there was nothing going wrong. It was just the two of you drinking and having fun, and I guess didn't want him there anymore.
Brian.
Ew, don't Brian him. Ugh. You're the one who asked this question yet again, spitting on George's grave, spitting on your murder victim's grave in order to benefit. As if no one sees right through this. This is so disgusting. You are now trying to blame George for the reason why you were an awful, neglectful parent. That's not how that works. You can't say, I couldn't have him over because I was with this dangerous, violent abuser that I actively brought into my life, introduced to my child, and made sure that they lived in the same roof when he was over here. And he was so bad, but allegedly you brought him to go pick up George. When you kicked him out, let him back in, kicked him out, let him back in. And the last time you drove to go pick him up with your son. And you made sure you brought that up in the interrogation to make it seem like, oh, his father's so violent because he was throwing his bags in the car. And I don't even think he knew my son was in the car.
Would like to see on my phone, or I think it's actually on a laptop. I actually, because, and you have to understand too, I have, like, prior to classes in PO, kicked him out. How many times? I had him arrested. How many times?
But you also went down and bailed him out.
I know.
The next day.
I know.
What's on your laptop?
What was I going to tell you? Oh, previously, I actually looked up how to file a restraining order.
Okay.
Because I would take him out, his parents, because of them constantly having to take him back in, his bags of clothes, all his stuff. The last time, the father came out and irate and just not even, I don't even know if he knew he was in the car. Just opened the back of my car and just started throwing all his crap in, just throwing it. Like the car would jostle, he was throwing all his stuff. At that point, because I continually did it, not continually, I think I maybe did it 3 times, and he has nowhere else to go, they got fed up and said, nope, either you're staying there or you're staying here. But if you're staying here at their place, it's permanent. You're not going back over there anymore. So what happens is, he pursues me.
If it were so dangerous for him to be over to where you can only have 30%, why did you take your son with you? Also, the fact that she's not contesting this at all is wild. Out of all the things to lie about, this is the one. You need to say, no, I did have my 50%. I may not have been able to do it here and there, whatever, but I could have. But no, she says, yup, I was neglectful. Yup, I did break all the rules. I didn't have him before even barely 30%. And why? Because the man I murdered was dangerous. Yet now that he's dead and can't defend his name memory, people online have to do so because people like you who show absolutely zero remorse for the horrific actions you have done. Zero. You haven't tried to respect his memory, his dignity, nothing, not once ever. You have continued to drag and drag and drag his name, thinking that makes you look better. And it never does. It reveals more about your actual nature, and it shows everyone who you really are. It kind of just confirms it. We all think that, but we all want to hold out that, maybe people aren't that vengeful, selfish, and adversarial in absolutely every way, shape, and form. This is gross. This is absolutely disgusting. And you're bringing it up in family trial again, as if this judge does not know about your criminal trial. And unfortunately, I'm just going to guess, I believe she's probably seen the videos. Mainly because Brian's attorney put judicial notice of her entire criminal court docket, meaning she has access and is supposed to review everything on that docket. Well, not everything, but she's supposed to skim through it at least to get the highlights. And something tells me when she's trying to decide the fate of this child, more or less, in terms of access and resources divided to and time court ordered to be spent with her, seeing that video and seeing how vengeful and evil she really is in that video and how remorseless she has been from moment one, why would you ever endanger the child again? If she were out, if she somehow were free and got away with it, she still would not have full custody, and he could still file for sole parental custody and would win for a variety of reasons. But also, you zip your child in a suitcase yourself. That's kind of relevant to how you would treat him on the outside. You make horrible decisions, just like Brian says. You do not make good decisions. You have had a track record of making the worst decisions in any possible situation ever, which is why you have a life sentence when you could have had 10 years for an unspeakable crime that will truly be your legacy due to the uniqueness and the reactions afterwards. And things like this is going to be the reason why his death will never leave you. You said George haunts you in that thing. This is why he haunts you, because you continue to shit on his name. There is no proof or evidence that he was ever a danger to that child. And by all accounts, everyone says both of y'all were trying to be on your best behavior when the son was around.
They actually used to do a whole lot of arts and crafts inside of the townhome. And they did a lot of it with her son. There wasn't a perfect relationship, but they tried, I guess, in their own way.
Right.
But now that he's dead, nope, it was awful. I was always in fear. It was so unsafe, this and that. If it was so dangerous, why did Brian allow him to go over there? Why did Brian buy them a baseball bat, the bat you used to kill him later? Why did he originally buy that bat for George and your son to play with?
Did you ever buy him any baseball bats or anything?
I bought one for over here that Sarah said for St. George to play with or something. That was like a year ago or something, maybe.
What kind of bat was it? Was it a wood bat?
Yeah, it was a wooden bat. I think it was like a junior size thingy. I don't know. It's something that I looked like kind of for his height or something, I think.
Why did Melissa, the property manager, say she only saw George playing with him, never saw Sarah playing with him?
George was the one I always seen driving the vehicle. George is the one I always seen playing with the child. Never saw Sarah outside playing with her kid, ever. As a matter of fact, most of the time, you would find him riding around the property on his bike, unattended. No parents outside, no nothing.
Because that wasn't a priority to her at that time. Her son was not a true priority until she lost absolutely everything she has.
Brian.
Next question, ma'am.
Did ever tell you that he liked being more at your house because of everything that you had and everything that I didn't have?
So I'm going to object, as that's a question based on hearsay.
Sustained. Next question.
Did you have more entertainment than I did?
Really, in all honesty, no. I mean, you had a computer, I had a computer, you have a TV, I have a TV. You've got open spaces to play in, I had open spaces to play in. You had a pool, I had a pool. I mean, yes, my house was a bit bigger than your apartment, but I mean, it's kind of the same things.
Do you understand what my criminal case was about?
Oh, yeah.
Do you understand the domestic violence part of it?
No. Well, yes, just not from the side you think.
Did you watch my trial?
Yes.
Did you see the pictures?
And I saw all the videos.
Yeah, double homicide. Bitch! No, she's sorry.
In regards to the children's rights,
Yup, that is exactly right. He gagged you there. Oh, he got you good there. Did you see my trial? Did you know the domestic violence? Girl, it was a murder trial for a murder you filmed yourself committing. Why would you keep bringing this up? Oh, wow. That was beautiful. Did you see the pictures? You mean that fake ass drawn on black eye that we talked about before? No. Does she have a black eye? We saw that black eye at trial and we have questions. A lot of people are saying it looks like she used Sharpie on it, and you're not wrong. It does. And the issue for me is it's because it's a harsh line. Bruises dissipate into the skin because the bruise is actually under the skin and not on top of it, like a harsh Sharpie line would be. There's not swelling in the areas there should be swelling. Her eye in the black eye should be redder, or if it's black, that means there's a lot of ruptured and bruised blood vessels. There would be swelling attached to it. You would not be able to open your right eye the same way you could open your left eye. That is not. And in the picture, you can see both of her eyes are open at the exact same point and the exact same clearness. If your eye has that much strain, that swollen, that damaged, odds are it's going to look more red than pure white, or just as white as the other eye. The picture she showed in trial, it looked like it had either been amped up or just completely drawn on in general, because it was pitch black as well on her very, very fair skin. Wow, that just looks so horrible for you. And I saw the videos. Crickets. Couldn't say a damn thing. Moving on. Wow, I would have loved to see her face in that moment. Face crack of the century. She had nothing she could say for it. Because it's not even just the video of the person that she murdered. It's the video of her berating the person that she murdered. Never ending. And just the fact that she told the interrogation and everyone, all the police officers, everyone involved, go look on my phone. Look at my phone. Look at the pictures.
Can I show you all the other pictures that I have that I have documented?
He's going to jail for this, so the rest of that can't leave anything up. But if anything else shows up, you can go take that paper down to headquarters.
It's not gonna do anything else because you're taking him down. Put him under the jail.
He's going
Under the jail. I don't know if you all have looked through my phone yet and seen any of the pictures and the videos that I have taken. So you all will see in my pictures. So when you all see my phone, you can see that too on the pictures.
In general.
You guys are documenting at one point, but I don't know if you would like to see on my phone. That's on my cell phone too, so you can see it. Sarah, can I borrow your phone? Yeah, it's right there on the kitchen counter. So, am I getting my phone back? No. What does that mean? See, and that backfires on me now too. Backfires on me.
It's so ingrained in her, she's doing it right now. But she forgot that the last time she did it, they found the video of her committing the murder. Now, she forgot that me bringing up the pictures means he can bring up the videos. Ooh, he got you there.
In regards to the children's rights, I would like to ask, please, number 6, where it says not to hear parents speak ill of each other, nor to hear about the difficulties of the other parent. Have you ever called me murderer?
No.
In front of our son?
No.
Have you ever called me killer in front of our son?
No.
You do realize you are under oath.
Yes, there is a difference between calling me a murderer and saying you're being tried for murdering someone. Those are not the same thing.
Have you ever called me a murderer in front of our son?
Asked and answered. Move on. Next question.
Have you ever made an attempt to find out contact information for me while I am located here?
Say that again?
Have you ever attempted to find out contact information from me while I am located at BOC?
What contact information?
Should there be an emergency, have you ever tried to find out how to contact me?
I would call the jail and ask them. Or the prison,
So you do
whichever
have
one.
an option contacting me.
What's that?
So you do have a way of contacting me.
I have no idea. I don't know what the rules are. I don't know if I could get in contact with you. Maybe they could let you know. I don't know.
Have you ever made an attempt? Have you ever asked me? Have you ever
And what's
responded?
the relevance to the issues that we're here on today?
Yet again, there is no relevance whatsoever. It's just more petty grievances. Have you ever called me a murderer in front of our son? Now, this I will push back on Brian a little bit. I do believe he may have said something similar.
You're a killer. That's why I'm not doing anything. Former husband said in front of son on phone, you're not important to anyone. Former husband, numerous dates. You are not priority. Former husband, numerous dates. Dad says you're annoying and beg all the time. Son told me after asking him to ask former husband if he finally ordered a book and hot meal after being made to call daily to check for 13 weeks. I lie to you because I can. Dad does all the time. Son, you make no difference in our lives. Former husband, numerous dates. That's okay with you and acceptable, Judge Dean? Is that what you are giving him permission for and to keep doing and in front of my son?
But there's no proof he said it in front of their child. She has always just assumed that and has made that assumption. But I'm like, you're over the phone. So if the son overhears something, it doesn't mean he was necessarily in the room to hear it. But you assume because Brian will call you a murderer or say that you are on trial for murder in your face, that obviously he's doing it in front of the son, or else the son wouldn't know anything. How on earth would the son know that one of the most notorious murderers in all of Florida was actually a murderer? It had to be Brian, but absolutely irrelevant. And then here's some more deflection. Have you, Brian, ever tried to figure out contact information for me? That is a you issue. If you have new contact information because you have gone to prison from going to jail.
Hey, Ziva, listen, you're going to jail. There's no other way to put it. Yeah. Have a good night, though.
You're not going to jail. You're going to prison. That way.
You need to provide that contact info in case of an emergency if you actually care that much about it. Wow, that's wild. In what universe is that going to fly? Obviously, Mr. Boone, since you didn't go out of your way to find her contact information, of course she was going to be negligent parent and not respond or do anything this and that. Because the lawyer brought up, like, if you were to have sole responsibility or like split responsibility and she have equal weight as you have, how would you get in contact with her? There is no way. And then he goes, I guess I can contact the jail. Oh, so you do have a way to contact me? No. That's like saying if I call a university, they can find my child on campus. They may be able to relay a message to this individual, but that is not the same as direct contact, nor a consistent line of communication. If you called asking for Sarah, they would laugh in his face and hang up. Like, are you kidding me right now? Her argument is literally, if he would bend over backwards and do absolutely everything, I could be an equal co-parent. And because he won't give me $67,000, give me all the time in the world with my son and do all of these things, literally backflip in a circle in order to get me the things I want and to keep me as involved as humanly possible, it's his fault, not mine. I'm a great parent because I'm ordering him to do that. And she loves to do this circular argument thing where if you give her even a little modicum of an answer she can run with, she will turn the tables and then blame you again. It reminds me of in that one video, one of the hostage videos where he's curled on the floor and he says, "You overwhelm me, George." George tells her that you overwhelm me. And then she turns that into say, "Oh, so you do admit that you blew me off and that you don't give an F and you don't do this."
I always bother you. I always bore you. You don't listen to me. Yesterday was my first day at work, remember? And I ended up 90% hearing about your day and 10% about mine.
You don't bother me or anything with that talk. I mean, sometimes you just you overwhelm me. That's the problem. You overwhelm me.
I telling you about my first day at work?
No, dude, you just overwhelm me about every other thing too. It's not just, first day at work.
So I'm overwhelming you by telling you about the fourth highest paid baseball player. That's a client of ours.
I'm not starstruck.
I don't even know who the guy is.
I don't need.
So the reason why, so you fully admit now that you didn't care and you did brush me off in the car. Midway sentence. Because you're not into baseball.
Even though that was not anything he remotely said or communicated in any way. The same exact argumentation here, and the judge is not having it. And Linda is not having it either. Thank you. You reminded me of this. Talking about the child's not supposed to hear the other parent and them talk poorly about the other parent's situation. Out of the messages we just went through, how many times did you say disparaging things about Brian to your son? I keep trying to call you on your phone, and still it goes directly to voice message. I really do not want to call Brian, as I have said in the past many times. I was hoping you would actually listen and care and make an effort just simply to have your phone on and charged so I can talk to you. I tried calling 9 times today, 8 yesterday, just for you to yell and not care as usual while typing on your computer. Blank stupid, uncaring response your father gives me, then hangs up on. Thanks for the Valentine's Day, blank. Have decided to make them for me after telling me you'd think about it, blank, year with you lying to me with your adult father that you made me a blank, then mailed to me. If I wasn't incarcerated, would you treat me the same blank? Temporary, right?
To life in the Department of Corrections.
The difference with that is that I will always care. Blank, way you treat me, your mother nonetheless. Do not ever blank. That is doing I don't get it. She always brings up these things and says Brian's going against them or doing something unlawful when she is also breaking those same rules she brings up. But the fact that she's in jail, that means it's not her fault. The fact that she chose to be with George means it wasn't her fault. The fact that she chose to be jobless means her having no money now is not her fault. It never ends.
Have you
And
ever
what's the relevance to the issues that we're here on today, which is the relocation proposed parenting plan and the request to modify either child support's not an issue, but to modify alimony?
This is where I'm unclear, Your Honor. I'm not sure what exactly I'm supposed to be doing. Is this in regard to the parenting plan for the relocation?
I've explained to you more than one time the issues that the court is considering today. You need to be asking questions regarding those issues. I will say them one final time. The issues are the petitioner's proposed parenting plan that was filed in relation to the petition for relocation, and then the request to stop alimony. And there's also a request for attorney fees. Those are the issues the court is considering. Those are the issues that you should be asking questions about.
I had no idea that the relocation parenting plan was even an issue, considering the fact it's been agreed upon.
I'm not sure why you have no idea when I've said it. I think this is the 5th time.
Yeah, double homicide, homicide.
Bitch.
No, I'm sorry.
5th time that I've said it.
Forgive me, Your Honor.
Sorry, Miss Jackson.
For page 2 of the relocation with the parenting plan, it says that it will dramatically improve the economic circumstances of the petitioner and the minor child.
So I'm going to object as to relevance, because I'll let her finish her question. I'm sorry. Finish your question. I'm sorry.
It's part of
Sorry, Ms. Boone. Go ahead.
How has it improved your economic circumstances, considering the fact that you are unemployed?
So now I'm going to object, Your Honor, as the relocation was already stipulated to, so now irrelevant. Irrelevance.
All right, I'm going to sustain the objection. Again, ask questions regarding the issues that I just gave you. We've already stipulated, you've already agreed to the relocation to. Okay, so the only issue with regard to relocation is the proposed parenting plan.
And that is what she is not getting. First of all, she's not getting, this is cross-examination. You are only supposed to be asking Brian questions about what he just testified to, as well as the judge wants to skip you from calling him during your case in chief. Ask him any questions that you would ask him later on, as long as they deal with the issues at hand. And the proposed parenting plan in regards to the relocation is what's throwing her off. She keeps hearing in her mind, relocation, relocation, relocation. And we've already agreed he should be relocated. But they are talking about the petitioner's proposed parenting plan that was proposed with the relocation. You have finally agreed with the relocation. Great. They are only talking about the parenting plan that was attached to it. But every time they say relocation, her eyes go red and she just can't get past, we already agreed on it. No, we didn't. He tried to get you to agree on it, to say, wow, this is unexpected. You are agreeing with the relocation. Well, do you agree with the parenting plan attached?
Your Honor, if I may just have one question about the relocation petition.
Okay.
Does Ms. Boone also agree to adopt the proposed amended parenting plan that we submitted in regards to the relocation? Because that is still...
No. And now this is where we've gone. This is why they're showing evidence. This is why they're calling Brian, all to prove this, because you are against this specific parenting plan and will not agree to it. You already agreed not to take child support. You already agreed that he should be relocated. If you had also agreed with this parenting plan, which is still very generous in terms of weekly phone calls, monthly visits to an inmate in prison,
to life in the Department of Corrections
for murder. Context matters. And if you had agreed to that, y'all would just be arguing over attorney's fees. But no, you objected, and that's why this is happening. You said you had questions for Brian. Ask questions to Brian about the issues at hand. Your Honorable Judge Jackson is over it. If this is not a sign that you are losing this, and that you need to lock in and get it together, then I don't know what will get her to change. It won't, but it is very entertaining to watch her flounder or listen to her. And technically, this is how it was when she was filming George in the suitcase. She does her best work behind the camera. So this should be right at home for her. She should feel real comfortable talking about whatever she wants. And actually she is, because yet again, this is just becoming a list of grievances. She had all these questions that he had been avoiding.
I ask as many times as needed to finally get an answer. If not this way, which would be more simplistic and less time consuming than in court, where you can answer everything when the judge asks you or orders you to answer? Don't you think? The reason for a very needed court date is simply over you not cooperating. You understand that, right?
Now she's in court and she can force him to respond. She's losing the plot. Has completely forgotten why they are there, and now in her mind she thinks that this final family trial is the time where she is allowed to grill Brian over why he hasn't been nicer to her and done more for her, when she is there to argue why she deserves to still get paid $1,000 a month and to have unlimited time with her son, despite the change in circumstances that she caused in everyone's life after she took someone else's life. And instead of arguing or providing even any kind of explanation as to why you still deserve these things, it's pointing the fingers, asking for punishment, yell, 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 and every time they try to recenter you, you are lost. She truly never learns. And even now, how many times has the judge explained this? She still is not putting it together. Truly, they need to just say the petitioner's parenting plan and stop saying the word relocation altogether, but they can't because that's not how that works. But that's what's throwing her off.
So the overall plan starts off with every other weekend from Friday evening until Sunday evening between the respondent and the minor child. How is any of this even applicable considering the fact on that DOC?
I think that's the whole point of this, ma'am.
Bon appetit.
Damn. Can they hold a sign bigger that says, "Do you get it now?"
Bring in the dancing lobsters.
Oh gosh, has it taken you 5 years to finally put that together? How is any of this relevant when I'm in prison. Correct. Why are you fighting this so hard when none of this is even applicable to you? You keep trying to hold his feet to the fire about this original parenting plan, the one that you have broken in almost every way imaginable, that everyone agrees you can't fulfill because you're in prison. They have another proposed one that you still can't fulfill because you're in prison, meaning everyone needs to come to an understanding of reality and realize you have had most of your rights stripped away from you, and you have been taken away from society as a whole. So obviously, you do not deserve the same equal say in your child's upbringing that you had when you were in his life. Since you can no longer do these things, obviously things have to change. It's almost like this is a substantial change in circumstances. Mind blown. Wow. Miss Jackson, I love it.
I'm sorry, Miss Jackson. Ooh, I am for real.
I think that's the whole point of this, ma'am.
I'm not sure what I'm supposed to do. And am I supposed to object to it? Because I object to it. It
We're
doesn't
here
make
for
sense.
a final hearing. Whether or not you object to it is not relevant at this time. The court is going to make a decision based on the evidence that is presented today. The court's question for you: do you have any additional questions for Mr. Boone regarding the proposed parenting plan, the request that the alimony be discontinued, or the request that the child support be discontinued, or the request for attorney fees?
If you could just give me a moment, please.
Okay.
Forgive me, I don't know what I'm supposed to be doing with this relocation. For the relocation parenting plan, which I was not aware of, this was on our to-do list today. I thought it was the original parenting plan. I don't know what I'm supposed to do or how I'm supposed to answer this. Brian, how can I exercise every other weekend from Friday evening until Sunday evening between the respondent and the minor child?
You can't.
How can a petitioner and respondent alternate winter break and Thanksgiving time sharing?
You can't?
Why has this been proposed in regards to relocation when I am here?
Correct. That's exactly the point. And I always thought that his parenting plan was too nice to begin with. But you're the one over here saying my pending release, I'm gonna get out of here. I'm gonna prove my innocence. Why is everyone treating me like I'm stuck in here? This is only temporary. So they provide a parenting plan that factors in for that. And you're like, what? I just don't get how she doesn't get it. If you were this confused, this needed to be your first question, not have you ever included me in any decisions? That's not what we're here to talk about, whether you've been included on decisions or not. I have no idea what I'm supposed to do with this parenting plan. I thought we were talking about the original one. Why would we still be talking about the original one? You both were given an opportunity to submit a proposed parenting plan. You didn't do that. You were too busy writing letters complaining about your personal property that has nothing to do with this matter either. But you wasted all your time on the things you wanted to focus on. But also, it still doesn't make sense to me. Even if they went with the original parenting plan, she's still breaking the time-sharing obligations that was in the original parenting plan, which is pretty much the same because he just submitted an amended parenting plan, amending the original one. So he didn't go in and change all of your requirements. It's still the same, just other little things were changed so that he gets sole responsibility and they can just ignore the other stuff. But regardless, either way, you should have had these arguments prepared as to why you can't fulfill your time sharing and why you shouldn't have to. She's breaking the provision on both plans, so I don't see how this is so confusing. You could have written up a parenting plan that says, I want him to visit me on blank, blank, blank holidays and on this birthday and on this or whatever. You could have proposed your own terms. I want 2 to 3 calls a week and not just 1 call a week. I mean, you're not reasonable, so you would never actually propose that. You would say, I deserve at least 7 calls a week. Is that okay? Fine. What if I just called daily instead of 5, 6, 7, 8 times a day? Will that make you happy? But she chooses what to spend her time on, and it's the things that mean the most to her, and rarely does that actually do with her son, and solely or majority what her son can provide for her, whether individual love or whether access to other resources and funds.
You ain't got no money. Woo.
And Linda agrees. Move on. We haven't even gotten to your case yet. This is still Brian's. Oh my gosh.
I'm confused.
All right, next question.
So the amended parenting plan, with my understanding that it is up to the child to have contact with the phone as regular as he would like to have.
I don't think so. I don't think that's what we're proposing.
It says the parties will coordinate a weekly phone call between the child and the mother. After all regular, consistent phone calls that he and I have been having,
I tried calling 9 times today, 8 yesterday.
now it's going to go down to 1 phone call.
Yes.
Do you think that would be detrimental to him, or do you think that would be helpful?
No, I think every weekend you can call him and catch up on how his school week went and everything like that.
Why are you doing that?
Why is this happening?
Because George is dead.
Because I think that's all that's really necessary. And these phone calls start to add up.
So in the past, we have been speaking to one another on a regular basis about everything.
I try calling you every night with no answer. I call every night. Every night.
I have been included in his life because he has decided to answer the phone call and you pay for the call.
Tonight it rang and rang, then went to voicemail. Then voicemail directly when I called back. You don't want to talk to me? It makes no difference when it is, as it's the same thing on the weekends. Anytime I call you.
Now, because of this, you're going to allow us 1 30-minute phone call per an entire week.
No, you can have 2 phone calls. You can have 2 back-to-back and talk to him for an hour. That's fine. And I mean, if it's a birthday or a Mother's Day or a holiday, I mean, yes, there will be other things worked in, but I don't think you need 7, 8 phone calls a week.
I tried calling 9 times today, 8 yesterday.
It's ridiculous.
Is that due to payment or because it's harmful to speak to him that many times?
Both.
Oh, damn. You walked right into that one yet again. What on earth did you think he was going to say? Did you think it was going to be like, no, it's not damaging to talk to him. It's just because I don't want to pay the 13 cents a minute. He wouldn't care about the 13 cents a minute if you were an actual positive influence in his child's life. If the son came back every time after talking to you and was just in a better mood and just felt good and light, I bet he would want you to talk to him more often. If they get into a fight being like, well, do you want to go call your mom, or do you want to talk to your mom when she calls you, and let that be your place of decompress and to find whatever, but you're not. Every time he gets off the phone, I bet he's rarely just elated and overjoyed. It's probably either neutral, maybe content, or absolutely depressed because why? Or annoyed. Getting called by anyone that many times is going to wear down someone and make them not want to talk to you. What she's not getting is they're saying one phone call a week as a mandate and requirement. They don't want to be chained and court ordered to give you daily phone calls, which is what she asked for. And she tries to say, and any other time the minor child wants to include me. Again, making it sound like there's all these times the child has been begging to contact her, and the father is so mean against his mother, the woman who gave birth to his child, so mean, and she just wants daily phone calls and whenever the son wants to include her. Then all the text messages, why don't you ever want to include me, son? Love and effort? Please don't think I'm not trying. It's you who are not. I hope you answer sometime. I love you. Why? It's not like I'm asking you to grow a third arm or lasso the sun. Just answer your phone. I hope one of your resolutions, if you have any, is to be nicer and respectful to your mom and to understand my feelings. Yes, I have feelings, and how much you crush them by not caring enough to simply plug in your phone. Stop being mean to me and not caring. I'm already going through so much, then to be disregarded and spat on by you is unspeakable, and for no reason. Do you delight in making me feel worse? Does it make your day knowing you make me cry and feel worthless to you? Who am I to you? Really ask yourself that. Punching bag? Daily joke? Unwanted friend? That's how you make me feel. Know that, son. I can't make you care. I can't make you love. It's your choice, yours only. New year, new start, new everything. Your choice. Don't forget about me. Love always. Who am I? So the evidence and her words, yet again, always conflict. They rarely, if ever, just line up. And that's almost a skill, to be so contrarian to everything. That's why she's like, I don't know what I'm supposed to do with this relocation. You don't have to do anything. You are dead set on being opposed to it without any arguments. And like the lawyer said earlier, without any articulable reason to object to the relocation originally. And it's the same thing here with the parenting plan and with every other thing. She has no true articulable reason to object or oppose these, or she has no valid counter to it, as in, I don't want to agree to this, but I'll agree to blank. Understanding the logic behind the decisions, but still asking for something anyway. Meanwhile, you're just saying, I'm not going to propose any ideas. I'm just going to object and tell everyone to do more for me. And it has never worked. It's fallen flat every time. Well, it's never worked in the way she thinks, quote, working is. People give up so many times with her and just gives her what she's asking for. So she thinks she's getting these little wins, but they're not actually wins in the grand scheme of everything. When it comes to the hard copy discovery versus the digital versus the laptop versus the classroom versus the this and the that, she got a lot of small little victories because it didn't matter in the grand scheme of all of this. And so she's used to getting small little victories, thinking that wins the whole battle. So she only focuses on the smallest victory, completely missing the plot of why we are here. Well, I need you to admit that you willingly accepted the phone calls for 13 cents a minute. You willingly chose not to respond, so I have to use my son pawn. You willingly chose not to give me $1,000 a month when I should have been getting my money. Instead of realizing you were supposed to argue why you should be getting your money. Just saying you deserve it because the court said so is not a good enough reason, especially when you're talking to a new court who is asking you, why do you deserve this? But it's this kind of answering. She steps in it every time. It's just like in pre-trial for a criminal court case where she was trying to get unshackled and they brought the guy in who said, I reviewed your case. You were arrested in 2018 for third-degree domestic assault by strangulation, and said, I don't think you should be unchained. And what does Sarah do? She has the audacity to ask him, do you think I'd be a danger?
Am I, in your opinion, a flight risk or detrimental to the courtroom and am a threat of any type of harm?
Based on what I've researched, I don't know you personally, but based on my research, I don't think it would be appropriate for you not to be in restraint.
Damn, you walked right into that. Why would you ask that question? He was a witness specifically brought in to explain why you should not be let out of cuffs and unshackled. And then you're going to ask him, do you think I should? As though he was going to say the opposite. Wild work.
And then what was the year, please, for the charge that was dropped with the domestic violence?
It was 2018.
2018?
Correct.
And it is now 2024.
Yeah. And 2 years later, you killed that same man. What are you talking about?
The same thing here. Why would you ask Brian, do you think it's detrimental to talk to my son that many times? Of course he thinks that.
How is that harmful?
Once again, I see him very upset at the way you talk to him all the time after phone calls.
When was the last time he was upset?
Probably about a week ago, because you didn't call all last week.
Do you know my schedule of work while I'm located at DOC?
No, of course I don't.
What?
Why haven't you asked about it? To know that.
Because I don't care.
What?
Is it true that you just spoke to our son and told him that he has the authority to choose when to speak to me and how often?
No.
It's his decision.
He told me he would like for it to work that way, but it can't work that way. He's a minor.
Why do you not care?
Because George is dead.
Not intentionally.
About you.
Question, ma'am.
I'm sorry, Your Honor.
Sorry, Miss Jackson.
We're way off target here. Let's move on to something else. If you're done, you're done.
Yeah. Double homicide.
Your Honor, thank you. Forgive me. Have you at all upheld any of the other items in the active parenting plan to date since of my incarceration?
For instance?
I'm going to object as to overbroad and
Sustained. Ma'am, you have to ask a different question.
Communication. Between parents, all communications regarding a child shall be between the parents.
Okay.
Have I tried all possible forms of communication in regards to phone calls, tablet messages, handwritten letters, texts from outside resources, etc., to try to communicate with you in regards to communicating with you about our son?
Yes.
Have you responded?
You've already been over this. Next question.
There is no next question. She doesn't have a next question because this is the only way she knows how to argue. Cyclical arguments that never end. You didn't agree with me on this argument, so we're going to circle back and do it again. I already admitted that I myself have broken the parenting plan, that rule that I specifically read out, that the communication is supposed to be between the parents.
In the parenting plan, it says that you are not to use the child as a ploy or a mode of communication. How else am I supposed to communicate with you if not through our son?
Well, haven't I tried everything else and third parties? Stop sending strangers who care so much about an inmate on trial and now convicted of murder.
we, the jury, find the defendant guilty of murder in the second degree.
That they will harass the ex-husband on her behalf to go harass your former husband on your behalf. See, Gary the garbage truck has had it, and it fell flat the first time when you try to bring it up, thinking that revealing you've tried every other method justifies breaking the rule and using your son as a mediary, to where the judge has to flat out tell you you've already been over it, move on. But then that goes back to the start of this little chunk of the, when was the last time he was upset at me? Last week when you didn't call him. And that's what we noticed in volume 4 of covering the jail messages, is that as soon as she found Lana, and Lana was giving her all this money, all this attention, doing all the things that she wanted in terms of getting a lawyer, making all these social media posts, doing all this and doing all that, she didn't message Brian hardly at all, except a few times to literally only add commissary funds. And I don't think we saw any messages to the son.
No matter what, Lana, ever, I love you so much and am so grateful you are my friend. I actually consider you a best friend and big sister. Really, I've never really had either, so you must know I trust you to divulge and confide in so quickly. Most importantly to me, actually, Lana, you are such a comfort no matter what you tell me or say. That's the big sister part, the love also. I welcome anything, everything you say. It motivates the fire out of me and drives harder. I am reassured I know just something in the real world and what's being said. Regardless of good or bad, it's still comforting to know, to deflect or embrace. I love you forever and will never have anyone in my life like you. You're a traitor. So sad you're a liar too. Just like the rest of them. Conformist. Are you that desperate? You're rotten, Lana. Shame on you. Ever. Lana, it touches my heart and soul about your fight also. It scares me and makes me pray harder for you because of how much I do love and care for you. I feel helpless in not being able to help you and selfish for asking you to help me. We're both in need desperately, which confuses me what I'm supposed to do to make you better, not to stress you out or make you sweat or stay up late. Tell me if ever I do. I apologize profusely if I have or am. Profusely. I really want to hug you. One day. I trust you with every fiber of my being, and if God didn't mean for you and me to be friends, he wouldn't have put us in each other's path, right? You are his disciple and diligent and honorable in innumerable ways. And clout is such a good word, smarty. Piss me off, push me, lift me up, hug me hard. Gonna love you lots always. Constructive criticism all day. You underestimate your worth to me. Thank you does not suffice. In the meantime, I will use you like God meant for me to. I will use you like God meant for me to. Because her needs were being fulfilled, which means her needs were not her son. It was the funds that she could get by talking about the son. I can guarantee you all those third parties you had did not go there to talk about his son. And if they did, he should have called the police on their ass, because who are you to try to hound me about my child? So, who else could you be hounding him about? Oh, you and your needs. And then tries another reframe of, well, didn't he tell you, or no, didn't you just say that he has the option of when he can talk to me? And we know what you do when he doesn't want to talk to you. So that just means if they did side with that and say, yes, you're right, the minor child gets complete control over when he gets to talk to you, then you would hound and belittle and tell him to man up and be honest. And do you want me in your life and this and that? Until he would say by your order and command and manipulation, I want to talk to mom every night, please. That's the only way I will show her that I love her too, almost a fraction as much as she loves me, please. And that's not going to happen. She is wasting so much time on this. And she hasn't said anything.
She hasn't made any ground in any of this.
For the active parenting plan, it says it may be modified or varied on a temporary basis when both parents agree and sign it in writing. Have you signed or written anything, or have I?
What, to modify? That's what I'm trying to do.
When the
I'm gonna object
parents
as
do
to
not
relevance.
agree, the plan remains in effect until further order of the court. Has
All right,
this
ma'am.
been?
Ma'am, you're beyond the issues we're here on today, okay? Next question on those issues that I've gone over with you over and over again.
Forgive me, I'm trying to do my best without knowing what I'm doing. For the objection to relocate, how soon before the actual relocation did you tell me?
All right, again, that's not relevant to the issues we're here on today. The relocation to has already been determined, okay? Specific questions regarding the proposed parenting plan that was admitted into evidence as Exhibit 1, the request to stop the child support, the request to stop the alimony, and the request for attorney fees. Do you have any questions, any additional questions on any of those issues?
Yes, Your Honor.
No, God! No, God, please, no! 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 No!
I don't know if you can answer this or not. I just don't know without asking you. Are my questions after this? Is that the end of it? I mean, I don't know how much further this goes for me to be able to utilize my pretrial statement information.
Why do you need to use your pretrial statement information? So many issues. One, this is still cross-examination. She should know this if she's paying attention, but she isn't. She is running on pure emotion. No facts are involved whatsoever. She wants to start this part with, all temporary changes are supposed to be in writing and signed by both parties. Has that happened? Because that's been her talking point for years. The fact that Brian should not be allowed to do anything because both parties didn't sign on some paper and agree. But she even says temporary changes. We are in court right now for literal changes, not temporary, hard fact, permanent changes. And what is happening right now in this courtroom would overdo any temporary change if that were to occur. So the fact that that didn't occur doesn't really matter right now. Brian's lawyer squeaks in a relevance objection and the judge asks her to move on. Doesn't really formally address it, but still saying, get on topic. This doesn't have anything to do with anything. And how does she internalize it? She says, ... Well, doesn't the original order still remain in effect until there's a new order from the court? That's why you are in court. Brian's like, that's what I'm trying to do. Oh, how do you think this is a winning argument? How do you think arguing in front of a court who is there to decide these new issues at hand, saying, you haven't gotten a court to decide these new issues at hand, so that means I win? So then she gets course corrected again because she didn't actually move on from what she said. She said, we needed to sign something temporarily and go to a new question. Okay, fine. Well, isn't the old one still in effect? Okay, move on. And then she goes, I'm trying to do my best without knowing what I'm doing. You're trying to do your best at arguing and just being against things that you don't even know what you're against. You know you're against it because it's Brian's side, but not have any articulable arguments to combat any of this. If you want to get to your pretrial statement information, then you need to let this man go so we can move on, finish up his case, and officially get to yours, where you get to use all the pretrial statement information you want, which I don't know why you would. You're just repeating what you've already submitted. The judge has or will look at the pretrial statement. You don't need to read it out as though she's not going to know what it says later on if you don't tell her. Oh, and then her knockout question after, I'm trying my best, let me resettle in. Okay, I'm good. Now I'm coming back. Well, in the objection to relocate, how soon did you tell me? What does that have to do with anything? The relocation is the only thing that you have actually agreed upon. You are only objecting to the parenting plan, but it seems like you forgot what you've objected to as well. Oh, why are we here? This is bad.
Right. As I explained to you at the beginning of this process, I will do it again. The petitioner has the burden in this case. They get to call the witnesses, they get to introduce evidence. Okay? Once they are done, then I turn it over to you so that you can call any witnesses or you can provide any documents that you want the court to consider. I also want to say to you, it is now 3:06 p.m. We will not be going past 5 o'clock. So the more you continue to ask questions that are not on the issue that we've talked about today, the less time you will have to present your case.
Okay. In regards to attorney fees, is having an attorney a choice?
Yes?
Were the dollar amounts that you put in my commissary account considered voluntary?
They were partial payments to you, as we had discussed when you first got in there.
On your pretrial memorandum, they're stated as voluntary.
Objection, there's no question.
Why? How many times that you can recall did I try to inquire about a guardian ad litem with you?
Objection, relevance.
All right, ma'am, can you repeat your question for me?
How many times did I attempt to obtain a guardian ad litem with him?
I'm going to sustain the objection. Next question.
So she gets the warning that the more time you waste, the less time you will have for your own case. So are you done, or do you still have questions? Yes, Your Honor, I still have more questions for him. Fine, what's your big question next? Why are we still here? Is having an attorney a choice? What are you supposed to win with this argument? What is the judge supposed to do? You're right. He is, yup, in the entire history of law, attorney's fees are all self-inflicted, and we should never even consider the idea of the other side paying attorney's fees when they lose. But what's her 4D chess level move argument? Getting a lawyer was a choice. Half so. It's normally not really a choice. You need one because you pretty much have to get one if you can afford one, so that you don't end up sounding like you when you get into trial. No court is ever going to rule out attorney's fees just because an attorney was a choice. So then she thinks she has her gotcha moment. Well, were all of the payments that you gave me for years, all the money that I begged and hounded you for, were those all voluntary payments? And he said, no, they're partial payments like we agreed upon. Well, your pretrial memorandum says they're voluntary. Yes. And I remember I lost my mind in the pretrial statement when she tried to call them all voluntary donations. And it's because they called them voluntary in the sense that he was not required to make the payments that he made in the way that he made them. But that's what she truly thought her 4D level chess move was. Well, if you're going to say the word voluntary, then they were all voluntary, meaning I deserve all of my money. You didn't pay me anything, right? See, you said it, so that means it's right. Did you see that, Judge? Did you see that? So now I win, right? Wait, that doesn't matter? Wait, you could literally care less about that? Okay, I'll move on. Well, didn't I ask about a guardian ad litem? Why are we back to a guardian ad litem? Oh my gosh. She brought that up in the pretrial statement too a lot. I do not understand. The overarching, if you don't know what a guardian ad litem is, in Florida, a good quote they use to compare is, quote, a friend of the child. This is supposed to be a neutral party that is supposed to represent the best interests of the child. That's it. Because these family trials can get nasty and ugly, and there needs to be sometimes, and depending on the case and actual custody issues, there aren't actual custody issues here because she will never have any overnight time with her child again. So this is not that important to need a guardian ad litem. And what that guardian does is they do their own independent investigation into both parents, as in their relationship with the child and the settings that they lived under when they were with the child. They are supposed to be an objective fact finder, and then they make those reports to the court with no bias to either side. She keeps bringing it up as though that would have helped her. It would not have. But let's see how many times she brings it up here.
Do you drink?
Yeah.
How often?
Objection relevance.
What's the relevance of how often Mr. Boone drinks?
Because he's making my, in quotes, drinking problem and blaming a lot of things on what happened to me. And I wanted to find out if he did or did not currently while he had our child.
You want to know whether or not he drank while he had the child?
Yes, if he drinks while he is in the presence of our child.
All right, I'm going to overrule, and I'm not letting this go too far astray. You can answer the question, sir.
I have had a drink in front of our child before.
Okay.
Okay. Why are you sounding so exacerbated there? This was your own question. You wanted to go in and try to get another gotcha of, do you drink? Well, you want to bring up my drinking. How about, do you drink about my... Yes, I've had a drink in front of our son. Oh, okay. What did she expect from that questioning? I guess she expected him to still keep fighting back so she can keep going because she's just in fight mode. And say, well, didn't you tell my son you like to drink rum and this and that, and you do this and you do that? And he's like, yeah, sure, okay. Standard drinking is not what is detrimental to the child's upbringing. Your alcoholic ass is what was detrimental. And the reason why it's such a big deal, and they're trying to say it's because of what happened to me, because that's what you said would happen to you. You said that all of this happened. You were only able to kill someone because of the alcohol, because of how drunk you always are, were, and wanted to be. Despite the fact of saying, I don't want to drink, try to mask your intentions or to cover up the issue that you've been trying not to address for years, actually probably decades at that point. So then you try to avoid the alcohol, you said it wasn't that, and then it was, and then it was.
I can't get drunk. Number one, I do not want to get drunk. Or I don't want to drink. The occasional wine, whatever, or if it's a weekend, that's when you have a good time. You don't have to wake up the next day.
A little defensive, like, no, we're not alcoholics. We are not, you know. What is it? Were you guys drinking and it got out of hand and it got physical?
No.
Or is it, you told us you weren't drunk.
No, I was not drunk.
Right.
I was not drunk.
Why don't you remember making the video?
Probably because we had been drinking.
But you weren't drunk.
No. Just because I went upstairs and... Just because you're drunk doesn't mean that you...
times that you were not drunk.
That's like an assumption. Like, that's what you all are thinking. Just...
We're asking.
It's the whole...
You tell us.
It's the drinking. That's what it is. It's the drinking.
He essentially would have been able to get out.
Alcohol...
Based off what you're telling us, he should have been able to get out.
Okay.
But what do you think someone that knows nothing about this, or hears just a little bit, like, oh, they were playing around in a suitcase,
She's been
and
drinking,
then watches
probably
that
went
video.
to sleep. That's what happened.
You go to
But
bed to
obviously,
do
you
what?
can tell too that, like, I've
You
been
go to
drinking
bed to
also.
do what? Okay.
Being drunk and intoxicated, which, yes, you can tell that I had been drinking, but
Okay.
if I hadn't been drinking, you still think it would be the same thing? Or is that what you all are trying to do? To portray me
We're not trying
as?
to do anything.
You're asking to be let out of a suitcase. Should they not let you out?
Eventually. I'm guessing. I mean, I'm blaming it on the wine.
Blaming it on the wine. There's two empty bottles of wine.
No, but we didn't drink both of them.
I think you did.
We didn't.
There's receipts for the
They were
statement
both
back there.
purchased yesterday, so I don't know how you didn't. So we have each bottle of wine that was empty in your garbage can that you purchased yesterday, or he purchased, but you two would have consumed together.
Okay, well,
I mean, there's receipts, so it's not even worth the. You're lying, and like you're now changing
Who's
your story.
lying about what?
You're now you were drunk.
Oh, I never said that I was drunk.
Exactly, but you did here today. That's okay.
You said earlier.
Everything recorded.
Alcohol.
You blamed it on the alcohol.
You blamed it on the alcohol. Alcohol does a lot to people.
Yes, but I never said I was drunk.
Okay.
You did.
So you did this. You did this sober. You knowingly left them down there sober.
I have already told both of you also that we were both drinking.
Right.
Okay.
But you want to admit that you were drunk? Is that?
I'm telling you all both. This has changed my life. I will take this.
It's about them when.
See, that's the
they
thing
have all
too.
this stuff.
But you can clearly tell. You can clearly tell that I had been drinking some. You can clearly tell.
I had several people that came up to me in that apartment complex said that you were drunk on a daily basis. And
Oh
you were
my
screaming at
gosh.
him
Right.
regularly.
Right. See, and then it's all backfired on me. Like, it's all backfired on me. And I understand the severity of this.
You did.
It's awful, I know.
Okay.
It's awful. And I will tell you both this right now, too. I will never drink alcohol again.
Okay.
Like, I will never drink alcohol again. I don't care what it is in any way, shape, or form.
You got up and you went up to bed.
Alcohol is a shitty thing. It's alcohol. Not, again,
the reason that you killed him?
you all,
Please sit down.
listen to me.
Please sit down.
You all, listen. I'm through with alcohol. And it's unfortunate that stupid things like this happen.
Absolutely.
So that's why it was relevant for them to mention your drinking, because you have a sustained history of being terribly drunk all the time.
Her main problem is she can't stop.
Okay.
I mean, she can't go out and have a glass of wine with dinner.
Right.
That's not a thing she can do, because once she starts drinking, she will continue drinking basically until she out.
Did they both drink a lot?
Yes,
Yes. Okay.
in excess.
What?
In excess. They didn't drink to drink. They drank to sunrise to sunset, all the time in between.
Okay.
They almost always seem either like tired or like tweaked out.
Tweaked out?
Yeah.
Okay.
I do know that I have seen both of them intoxicated as early as 9 o'clock in the morning, and I mean staggering, falling down intoxicated. Both of them. Sarah was actually wandering around the property very drunk, barefoot, not properly dressed. I'll say it like that.
How did she sound?
She sounded like crazy, like she always did. Like
the way they presented themselves, they were always drunk, like I was saying before, like always, like sun up to sun down type, like all the time. And it was like, I guess people just didn't really want to interact. Yeah, because it's like.
Okay. Did you have a conversation for a split moment with our son the other day? So you had the understanding when he was asking about the application that you do not live an hour and 20 or 30 minutes away, you came to the understanding correct that it's only 50 minutes away, 50.
I think it's further than that when I did it on Google Map.
Your Honor, I'm not sure what else I'm supposed to do, so I guess I'm ending whatever part I'm supposed to be doing.
All right. Any redirect? Let me just ask you that.
No.
All right. No redirect. We're going to stand in recess for 10 minutes. We'll come back at 3:20 p.m.
Thank you.
Deputy, do you need a break?
I know I need a break after all that mess. Good grief.
It's not easy for me to admit that I've been standing in the same place for 18 years.
Well, I've been standing with you. I've been right here with you, Troy. I got a life too. I gave 18 years of my life.
Sit in this courtroom and wait for her to finish cross-examination. That took forever. That never needed to take that long. Absolutely ridiculous that she drew it out that long too. And for what reason? She just kept going with useless question after useless question, trying to berate and get Brian by trying to catch him in lies. But when you try to catch someone in lies about irrelevant information, it doesn't actually help you win. It just shows what your true priorities are. And it's not the issues at hand. So how does she round this off? How does she say, I've been saving this question. This is the question I'm going to mic drop on. Didn't you have the conversation for a split second the other day where you came to the understanding where you actually live 50 minutes away instead of an hour and a half away? That's still nearly an hour. Plus, traffic fluctuates all over the place, especially Florida traffic. Florida traffic is wild. It's like a race to see who could be the most inefficient driver. And the woman who has no access to a GPS wants to demand that he understand. You came to the understanding correct. Okay, lawyer-loaded question. Loaded leading questions are all she knows how to ask. So it's only 50 minutes, so that should be fine. That's still a whole day. They're saying an hour and a half. Meaning 3 hours going to and fro. Even if it was 50 minutes, that's still an hour and 40 minutes. That's not just some easy breezy drive of, oh, let's just go take a Sunday afternoon to go visit mom, because she's also demanding for the full maximum time allowed by the facility. I was curious, so I looked it up, and the visiting hours are from 9 to 3 p.m. and on average they're around 30 minutes to around 2 hours max. And you know she's going to want the 2 hours every single time. And it said you want to arrive early because processing can take anywhere from 30 minutes to an hour. So you're asking them to drive 50 minutes there, be in processing from 30 minutes to an hour, then spend 2 full hours with you, then drive back another 50 minutes. Maybe they eat at some point during the day, and then they're home. And she wants them to do that multiple times a month. And if you were a nice positive influence in their lives, they probably wouldn't mind that much. But it's literally like them doing their own jail sentence, having to go see you every couple weeks. What she still doesn't get is that her behavior rules all the consequences and actions in her life. She won't ever acknowledge it, but it just seems to be a pattern that when she actually decides to act proper and respectful to people, good things happen to her. This is just the mandatory requirement of 1 visit a month. If you actually changed your ways and became a good and better person, you probably in a few months or so of just respecting their boundaries and need for space could ask for another visit, and they might actually be okay with that. But when you drag people through the mud, when you demand, when you yell, when you act so entitled to everything as though you didn't kill someone and are living on the outside, then people want to do less for you. Because then it's insulting to everyone. It's insulting to George and his death. It's insulting to everyone else and how they might feel about George. And while I'm sure George wasn't Brian's favorite person, at no point did it come off that he had hatred or true animosity towards him. It seemed like he just wanted to be away from him and that it was just a weird situation. Which is why straight out the gate he says he's been arrested multiple times for domestic violence, but for all I know, she could have started all of it. I wasn't there.
I think she had him arrested like 5 or 6 times for domestic violence.
Has he always been the one that gets arrested, or has she ever?
She was also one of the times. One of the times, both of them were arrested. But all the others have been him. But the very next day, she's in there trying to get him bailed out. So
Right.
I don't know. Basically, they get drunk, they get in a fight, she gets upset, she calls the cops. I never got that drunk, and I had restraint. I never touched her back. I think George didn't have that restraint, and at times he would hurt her back. So I mean, for all I know, all the times he got arrested, she started it. I don't know. I wasn't there, so. But I know she could get violent at times.
Okay.
Normally, if you hate someone, you're not going to phrase things like that. I got overwhelming indifference towards him, but at no point do I think he was happy this happened, approved that this happened, or think anyone deserves to go through what she put him through, which is why she's like, do you understand the domestic violence? And he goes, no, and then goes, well, yes, just not from the side you think.
Do you understand the domestic violence part of it?
No. Well, yes, just not from the side you think.
Did you watch my trial?
Yes.
Did you see the pictures?
And I saw all the videos.
So that's indicating to me that Brian realizes George was the one being abused in that relationship. And as more information came out, he probably was empathizing more and more because he saw the same patterns that he went through. The yelling, the clawing, the drinking, repeat.
And you said when she drinks that she can get physically aggressive.
She can. I mean, she did it to me a lot, where she'd hit me and stuff like that. I mean, she's tiny. I mean,
What do you mean hit though? Like open hand smack you, or like try and punch you?
Yeah, she'd punch me. I mean, more arms. She many times would use her claws. I mean, I had scratches on my neck at times, on my arms. I mean, things like that where she'd dig with her claws.
I'm sure your son had his own relationship with George. Positive or negative, it doesn't look like, sound like from any respect that it was a overwhelmingly negative interaction. I don't think anyone has testified or revealed that they got into fights, George and the son, and that George didn't want the son around. Sarah brought that up multiple times during her sentencing manifesto of, oh, he made me do this. He was so evil. Like, he broke my phone when my son tried to call, or he put a knife in the table and wouldn't allow me to talk to my son, or he beat me in the sacred space of my son's bedroom. He's just this monster that no one cooperates. As we saw earlier, he told Brian that he has witnessed verbal arguments between Sarah and George, but not that he was violent around her or aggressive towards the son themselves. All this to say, she acts like everyone should just forget about him, that they have no right to feel any kind of way they feel, and that there is absolutely no reason for them to treat her any differently, even though she continues to shit on his grave. No one wants to talk to someone like that. So it's never that she's asking for anything reasonable. It's always she wants the absolute most of what she can squeeze and get out of people. And when she squeezes too hard and people retaliate by taking away those options that she had, then she's floored. And so then after Brian answers, well, I think it's longer than that after looking it up on the GPS, you know, the thing he has and the car he actually drives and the traffic he actually has to deal with in the real world that you haven't been a part of for 5 years. Okay. And then that, well, I don't know what I'm supposed to be doing, so I guess I'm ending here. No one was going to tell you to stop. Did you think someone was going to say, I think you did a great job, you can wrap it up here? No. You chose to keep going. And that's why she really wanted to be in person, because she can't gauge people's reactions. And the way that she operates is she likes to take it to the edge and toe that line of acceptability and unacceptability. And she uses the side glances, the eye rollings, the sighs, and the avoided eye glances to realize, oh, maybe I should wrap it up. And now that she doesn't have that, she's just going and going and going and going, thinking that, well, as soon as I get him in a few gotcha answers and beat him down a little bit in front of the judge, then I'll be done. And when that didn't happen and he served you your ass yet again, we get the display that we just got. But finally, I'm so glad we are finally done with that never-ending cross-examination. Congratulations, Brian, you are done. You just need to sit back, chill, and relax. That was the last time you will ever be forced to respond to every one of her useless questions. And she knew that, and that's why I think she took a prolonged amount of time of she's going through her Rolodex of, did I hit everything? Did I go through absolutely everything I need to go to? Let me make sure I get absolutely every grievance out there so I can get an answer on the record that I will then exploit for the rest of time. Can guarantee she will bring this up in messages, in phone calls, and letters to infinitum. But now we can finally move on and see what is next.
Miss Boone, are you there?
I'm here, Your Honor.
Okay. All right. I don't know if I may have accidentally hit mute again. We just located your exhibit that was entered into evidence as Exhibit 1. The clerk now has that. Before we took a break, Petitioner's counsel indicated he did not have any additional questions for Mr. Boone. So now I turn back to Petitioner's side and ask, do you have any additional witnesses or evidence you would like the court to consider?
I would call Miss Boone very briefly.
Oh, here we go. Now we're moving on from her asking the questions to now she is the witness being asked questions. This is going to be a mess, but I want her to keep her own words in mind during this questioning. Remember, most of my questions, it's just a simple yes or no.
In the jail.
Yes or no. For most of my questions, it's just a simple yes or no.
I can guarantee most of these questions will be simple in what they're asking, and she's going to make them the most complicated things imaginable. Please do not let this go on for too long. Linda is also begging that you just answer the question so we can move on and to not go around in circles as we know you're about to do.
All right, Mrs. Boone, counsel has some questions for you. And once he is done, what I'll probably do is I'll ask you, do you have anything that you want the court to know right away based on the questions that he has? And then we'll get and see if he has any additional witnesses and evidence, and then I'll turn it over to you for your presentation, okay?
Yes, Your Honor.
All right, you may inquire.
Thank you, Your Honor. Ms. Boone, you filed a financial affidavit in this case on May 30th, 2025. Is that correct?
One moment, please, and I'll pull it.
I'm just imagining she's sitting at a table and there's just a mess of papers spread out all over the place, and she's frantically looking because there's no organization.
Go ahead with your question while I'm looking for it.
Well, I want you to locate it first because I want to ask specific questions about specific pages. So I'll wait for you to locate it. Did you receive the exhibits that we sent you? Because it also would be in that packet as well.
I have it located.
Okay. And that financial affidavit that you've located, that has a stamp on the top of it that says that it was filed at 1:08 p.m. on May 30th, 2025. Is that correct?
Yes.
Okay. At this time, Your Honor, I'd like to submit what has been previously marked as Petitioner's Exhibit E, which is the Respondent's financial affidavit filed on May 30th, 2025, into evidence.
Any objections to the court considering your financial affidavit that was filed May 30th, 2025, Ms. Boone?
No, Your Honor.
All right, hearing no objection, I'll receive into evidence what was pre-marked as E as petitioner's number 3.
Okay, ma'am, I just wanted to ask you a few questions about your affidavit. And I'm going to just laser focus right in on your expenses section, which starts on your page 6 of the document, and for the court's following of my exhibit, bait stamp page 46. Let me know when you're there, Miss Boone.
I'm there.
Okay. So this section here is going through what you estimate to be your expenses. The first question I had for you is, have these expenses changed dramatically since you started your incarceration in February of 2020?
They haven't changed because they've never started.
Hold on, pause this shit. What the fuck is going on in here on this day?
It's just an estimate from going off of the canteen list.
Oh, absolutely not. What? You put estimates on your sworn financial affidavit. What did you think that was? This is supposed to be your literal payments, what you've actually paid out of your pocket for these expenses, trying to justify your need for alimony. And you're just saying, I'm putting estimates based off of what's in the canteen. Well, what have you gotten from there? This isn't a what ifs possibility financial affidavit. This is you saying, these are my monthly expenses that just so coincidentally add up to be $1,000 while I'm still in prison and have all of my things provided for me. Wow. Straight out the gate. What's your first response? Well, I lied about this because I don't actually pay all of these things. And you can have some estimation, but it needs to be relevant and your actual monthly needs. Saying I need 6 blocks of cheese and some cookies for my blood sugar and cancer. First, I would like to make it known I have been diagnosed with cancer and am awaiting outside professional medical consult and treatment options. I do not know the level of severity, duration of time, or outcome for any of this. Judge Dean, after coming back from an outside medical appointment for my cancer and surgery, I really wanted to call my son to hear his voice and brighten my long, arduous day. In doing so, he was checking the mail, telling me I had a letter from you and wanted to be helpful and read it for me. The document was an order to dispense mediation. Has me call every week to ask for commissary funds so I can purchase necessities and sugar for my glucose concerns. Glucose? I thought you had cancer. Do we have diabetes or do we have cancer? Actually, those two are really common. Damn.
Yeah, double homicide.
Bitch. If you got both. Do I feel bad if she has both cancer and diabetes?
No.
Then says no. Refuses the occasional hot meal on a Sunday. I was made to cry over a cheeseburger when explaining to him the amount of weight I am continuously losing weekly due to being sick. And thought this would help me gain by eating. I was still told no. Is one thing if you're estimating based off of the prices. Normally I get this every month and that costs blank. Not, I would like to have all of these things, and if I got what I wanted in my dream imagination, then it would cost this much. So that's why I need this much money. Wow, not a great start.
Okay. So from February of 2020 until today, you have not actually incurred any of these expenses that you've listed on your financial affidavit. Is that correct?
You're asking me from when I was at Orange County?
Yes.
To the present day.
Yeah, I asked you the question about these expenses, and you said you mentioned something that you haven't actually incurred these expenses yet. So that's what I asked a follow-up question to that of, are you telling me that since you started your incarceration in Orange County in February of 2020 until today, have you actually not incurred any of these expenses that you've listed here on your financial affidavit?
What do you mean by incurred, please?
Really, Miss Walking Thesaurus? The woman who tries to use every single word in the dictionary, very haphazardly, and it barely fits the context. Over here, talking about arrearages, talking about in the text messages how you felt ensanguinated, or the literal bleeding out after being made to go pro se. And you even told Lana in one message, like, you're so smart because you use big words and I can relate to that. But you don't know what incurred means? But you know what? I won't hold you to it. Sometimes we just don't know some words, but context clues should easily tell you what he means. But you know what? I'll have Camille Vasquez step in real quick and let her explain it.
As of today, you have not paid
$1,000
of your own money to the
Lowell Correctional Facility.
yes or no. So as of today, you have not paid,
$1,000.
right?
Have you had to pay them?
Have I had to pay for food? Yes, I have.
Okay. So, has it stayed though? My first question to you though, in which you answered it in a different way, so I want to answer it again. Ask you again is, for example, you have here on your financial affidavit that you filed in 2025 that your food expense is $250. My question is, has that number gone dramatically up or gone dramatically down, or has it stayed relatively the same since you started your incarceration in February of 2020?
He's asking because that number is ridiculous. So he needs to know, did something big happen, as in, I don't know, all the prices increased and that's how we got to this high a number? Or any fluctuation whatsoever? Did $250 back 5 years ago give you the exact same things that you have now? Where are you pulling these prices from? It's mainly to gauge it, but also it's going to call it the BS. The best way she could answer this is, to my understanding, the prices have increased, but I am not aware of what I paid in jail 5 years ago. Simple, clean, can move right on. It's not what we're going to get.
I don't know or remember in regards to my incarceration 5 years ago, but I know for the current time, this is just an estimate because the prices fluctuate. So as of right now, it's about the same.
Now, does the facility that you're incarcerated in, does it provide you meals for free?
It does.
Okay. Does it provide you breakfast, lunch, and dinner for free?
Yes.
Does it provide you any other meal times other than those 3 times for free? Snack times or anything like that?
No.
Okay. Does it provide you things to drink for free?
Water, yes.
Okay. So when you indicate here that you have an estimated food expense as of May of 2025 of $250, what is that for?
That is for my low blood sugar, which the petitioner is aware that I have ongoing, and need to maintain my blood sugar. My grandfather died of diabetes, and I have to maintain that with snacks,
Security.
and in between meals.
Heavy.
Some of the meals are, of course, unappetizing, and my stomach is not able to handle them properly, so I either do without or would fall back on something that I could order or purchase from canteen.
Oh, girl, goodbye. Get out of here with all of that. You put $250 a month for your blood sugar. Just say you don't want it. Just say, I want to have my big activities so I can not eat this nasty prison food.
Hey.
Security heavy.
Let me enjoy some stuff. At least that would sound more honest than it's for my blood sugar. Even though I have no formal diabetes, diagnosis, we do have nurses and medical care facilities there, access to medical care. This is all preference. She let it slip in the middle. She let it slip and she tried to cover it up. She said, well, obviously.
Some of the meals are, of course, unappetizing, and my stomach is not able to handle them properly.
Security heavy. Some of the meals are obviously unappetizing and my stomach is unable to handle them properly. What does that mean? This is all speculation. This is not like actual need. Courts look at the actual facts of the situation, not your preferences. If you did have diabetes because a health professional was tracking your blood sugar with you and you had plans and you had needs and necessities, then that is something the court can consider. You saying this shit is nasty, so I want something from the commissary is not going to cut it. I don't know if she knows how bad this is.
And are you actually incurring this expense in purchasing additional food above and beyond what the prison is offering you for free?
I have from contributions, yes, but on a regular basis, no.
Okay. Explain to me these contributions. What are you talking about when you say from contributions?
I have a friend that will deposit money in my account on a rare instance when she has an extra or something spare.
Do you have any other contributors?
My brother, when he's able to.
Then why did you leave that out? He just asked about these contributions and you just said there's one individual. So sorry to everyone who's been donating her things. I know there's a long list of people who have sent donations, hundreds if not thousands of dollars of donations to her over the years. But that got diluted down to one individual. Is that Christina?
Christina?
Christina! Christina's gone. Your little tramp didn't leave any money to pay her, so she left. Just like your little slut.
Congratulations, Christina.
Christina!
You got yourself a shout out. And sometimes if she's able, when she has excess, who just sits there and has excess money? Actually, don't answer that. I'll feel poor. Also, I guess this doesn't include Lana, even though at this point she has since passed, but beforehand we know that she gave you more money than even Brian did at one point, and you probably could have gotten more sympathy points saying I had a friend who has now since passed who provided me a lot of contributions that I no longer have, just really amping up the pity card. So I'm glad you didn't do that, but probably because your final words to her were horrible. But we live with the choices we make. You live more than most. And then he asks, well, are there any other contributors? Yeah, my brother. Well, does he need to keep asking for you to tell the rest? Your brother, you mean your family member, part of the family that's dead? So you do have familial contributions that help you, but not your son? Got it.
So if I understand you correctly, this food expense is not for breakfast, lunch, or dinner. It is for supplemental food that you believe is appropriate due to your blood sugar. Is that accurate?
Yes, and also in regards to the meals not being able to be digested properly.
Security heavy.
Okay.
Yes, Mr. Martell, that MK was loud because it's ridiculous. She keeps trying to double and triple down to make this sound like this big blown up issue.
Security heavy. Like she could protect the building. Type big.
The more she tries to clean it up, the worse it looks.
Okay.
Primarily for medical reasons.
Okay. And then you have on here another charge of $100, or another expense of $100 for gifts for holidays. Is this for gifts for your son?
Yes, that's under child expenses.
And is this $100, are you asking that Mr. Boone pay you this so that you can give gifts to your son?
Would he be paying the alimony arrearages or a dollar amount? Yes, I would like to have that deducted from that dollar amount because I don't have income on a regular basis.
Okay. So you want your husband to give you alimony so that
My
you can...
ex-husband.
Your ex, excuse, you're right, excuse me. You want your ex-husband to continue to give you alimony so that you can then turn around and purchase gifts for your son on your behalf because you cannot purchase those gifts because you're incarcerated. Is that correct?
My alimony payment can be spent however I make or decide how to do so. And yes, I would like to include my son for gifts on holidays or just because I love him. Yes, that would be a part of my disbursement of my alimony.
Another terrible answer. The mask is slipping, Sarah. I don't know if you know this. The mask is slipping. I mean, it's already slipped off, but this is who you truly are. You're not trying to get this money for any other reason than you think you're entitled to it. The question was, you put down stuff for child expenses you do not cover regularly, if at all, ever. But you just put that down because you need the dollar amount to be higher. And so he asks, would that be coming out of the alimony that you would then go around and ask him to use that money to pay for these gifts to give to your son? Like I've said plenty of times, his money goes in a circle and it makes no sense. And then she reveals, would that be my alimony? Yes, I want my alimony, and then I also want to include my son, for gifts and holidays and when I want to. Okay, but you put down child expenses. Brian has actual child expenses: food, water, clothing, shelter, general happiness, all of it. Those are actual expenses, not hypothetical, well, if I had the money, I might buy my son gifts for no reason just because I love him. Doesn't that make me such a good parent? No, it doesn't. And it reveals exactly who you are. That would be up to me, my alimony. You realize you are talking to a judge who is going to decide if you deserve any alimony whatsoever, ever since you were incarcerated. And every time you are so combative and you double and triple down and you act so entitled, you show everyone exactly why you deserve to be where you are.
Do you think it's fair for Mr. Boone to give you money to purchase gifts for your son that you can't afford to purchase because you're in jail? You think that's fair to him?
Alimony is court order, which is unfair that I have to not be paid what I could have been paid.
Yet again, deflecting from the actual question, the question is it fair for the father of your child who has sole custody and is responsible for paying for everything in his life, is it fair for him to give you more money so that you can then go around and buy gifts that you can't do on your own because you murdered someone and put yourself behind bars for life?
To life in the Department of Corrections.
And how does she answer that? She says, alimony is court ordered, and it's unfair to me.
Okay, well, it's not fair. It's not fair. It's not fair that you guys, just because he has those, automatically blame it on me. And it's not fair. That's not really fair.
How many, you had two neighbors you went to and asked to go to the
See, that is
restroom,
just
and
not
you said,
fair.
"No, hold on."
It's wrong and it's unfair.
You certainly entitled to that opinion.
That I should have been paid, and I could have been paid, and I wasn't. And where's my money? Me. These are amazing answers for Brian's lawyers. Just incredible. You couldn't ask for more. You couldn't ask for a deadbeat parent to show just how deadbeat they are than this.
Okay. You also have on here that you have a $200 communication charge. Is that for the phone calls that we've been talking about?
That's for all of the communication opportunities that have not been taken advantage of by the petitioner. It's not just phone calls. It's video visits, videograms, it's cards, it's a multitudinous amount of technology that is available to be utilized if decided to.
Okay, if decided to, who cares? Again, this is on your sworn financial affidavit as costs you have incurred. You are saying monthly, I spend $200 on communication, even though I just spent a whole hour arguing that it's only 13 cents a minute and that it's so cheap and that how on earth could you not give me all this if it costs almost nothing? How are you spending $200 worth of communication expenses? $200, you have 13 cents a call. Let's just say round to, Brian said it's around $5 each half-hour call. That's around, what, 20 hours? 40 phone calls talking on the phone to equal $200? Or if you're doing text messages at 50 cents, that'd be 400 text messages. No one ever needs that much communication. And sure, you might have the videogram and the whatever card and the video visit. I'm sure they do not cost maybe like $10, $15 max. I don't know what this videogram is she's talking about, but this is just absurd. Your whole financial affidavit is a joke, yet you're trying to hold Brian as though he were under oath lying to the court saying, oh my goodness, how could he not be telling the truth? Meanwhile, you have not spoken a single truth this entire hearing. And then it's the contradiction because she claimed like $0 on everything. She makes nothing all year. That's why she needs the alimony, but also she pays this much every single month. How does that make sense? It doesn't.
Every effort, every expense that's been incurred. Oh, I'm sorry. You want to finish your point?
No, I was just stating that it is located in my exhibit, so you all are aware of the opportunities
Okay. All right.
in the cost.
Okay. I want to be clear, though. Every expense related to you communicating with your son since you've been incarcerated, Mr. Boone has paid for that. Is that correct?
It's my only form of ability
Ma'am,
right now.
answer
Yes.
the question. Has what the communications with the child been paid for by Mr. Boone since you've been incarcerated?
Yes.
See, now was that so hard? I want to remind you of your own words real quick.
For most of my questions, it's just a simple yes or no.
It's just a simple yes or no. It's so funny because it's the literal exact question that she gave that answer, because she was trying to say, well, didn't you accept the 13 cents a minute?
When you originally signed up for this account in order to utilize the phone option, were you aware of the 13 cents per minute?
Yes. I have to pay for all the phone calls.
So you accepted the fact that it was 13 cents per minute.
You don't have a choice. That's the only way to have phone calls in the jail.
Yes or no. For most of my questions, it's just a simple yes or no.
Didn't you know that? And he tried to explain, well, it's the only way you can have a call. And you say, it's just a simple yes or no. It's just a simple yes or no. And then he goes, have you paid for any of those calls or any communications whatsoever? Well, it's just a simple yes or no.
I want to be clear, though. Every expense related to you communicating with your son since you've been incarcerated, Mr. Boone has paid for that. Is that correct?
It's my only form of ability. For most of my questions, it's just a simple yes or no.
Ma'am,
Right now,
answer
yes.
the question.
Oh, her life mirrors herself in the most beautiful irony there is. And by beautiful, I mean appropriate and deserved.
Okay.
Next question.
You have a $50 charge here for clothing. Does your prison provide you with clothing?
Yes, the prison
Okay.
provides uniform.
then why did you put a $50 charge per month on your financial affidavit? As though you're telling the court you spend $50 a month on clothing. When they provide uniforms and you have no other options. Unless you're buying thermals and socks, underwear, whatever, this and that, you do not need $50 a month just for that. And if that is what you're spending it on, you needed to articulate that. But just another hole poked in this financial affidavit. She has zero clue how truly damaging this is to her whole case.
Okay. And then you have $15 here for medical and dental. Does the prison offer you any medical services?
You have to have a lien against your account. To make a sick call, you have to pay for that. For dental, you have to pay for that. Regardless if you have an insurance plan or not, you still have a lien placed against your account.
Okay. And you are estimating that your cost for that is $15 a month on your financial affidavit. Is that correct?
Yes.
Okay. And then you have here other hygiene and writing items. Does the prison provide you with basic hygiene items?
No. The prison only supplies I believe, 1.5 ounce all-in-one shampoo and body wash, toothbrush, and toothpaste.
Okay. Those would be considered hygiene items, correct?
Yes.
Okay. And you have here a $50 charge for creditor Department of Corrections. Are you indicating that you owe the Department of Corrections money?
These are all estimates. And you need to please remember that I am new to DOC and don't understand, but I do know that weekly draws from everyone's account every week. So depending on how much money you have in your account is how much they deduct from your account. This was just an estimate. I'm not even sure how they go by what they do, but this was what I was told to do from one of the classifications officers.
Okay. I see. It's the classification officer's fault that you lied up and down this whole financial affidavit, and none of it makes sense. Got it. Always have to pass the blame to someone else because it just doesn't make sense. You should have just put 0 for half these things and then argued I still need to because there's all these other whatever. I don't know. You should have just been nice and tried to mediate to begin with and not be so difficult and try to control everything, because then you would still get something, and now you are 100% going to have everything taken away from you because lie after lie after lie just unravels. And then you get backed into a corner. And you all need to understand that I'm still new here at DOC. We're in August, 8 months. And you were convicted in December, so 8-9 months. That's still new? You don't know your monthly expenses after 9 months? These are just estimates. They're very high estimates at that. And then the only reasonable estimate you put down was for health care, and you put down $15. Well, I'm sorry, if you have all these diabetes, glucose, blood sugar, cancer diagnosis, all of these issues, you would think that would be the one that's more than $15 and why you need all this extra because I have to pay for all blood sugar cookies. She was really not prepared for any of this.
And a lot of these that you see at the bottom, it states estimates for all. The clothing is charged quarterly. It's not every month. And there's limited quantities, and also the prices fluctuate, which is why I included those as my exhibit so you all would understand the most current pricing.
Other than receiving contributions from third parties and receiving money from Mr. Boone since you've been incarcerated, have you had to pay any money out of your own pocket to meet your day-to-day needs while you have been incarcerated?
Sir, I have no money.
I'm sorry, I didn't understand your answer. What did you say?
Insufficient funds. You ain't got no money. Woo.
Sir, I have no money.
You ain't got no money. Woo.
Okay. So the answer would be no, correct?
I have no way of doing so. No, I do not have any way of paying.
I have no further questions. Sir.
And that is how you clear someone. After all of that, just culminating in how much of your own money have you paid out of all of this? All of these motions where you say you were owed this, that you've had this expense, you just admit, sir, I have no money. Meaning you were solely living off of Brian's alimony. This is just a money grab. Linda knows a money grab when she sees it too, and it's ridiculous. And you had no good reason, aside from the fact that you are poor, to fight this hard to get all of these resources from him, while still blaming him and trying to say that he is breaking all these rules. Wild. I'm just so glad we're done with this. Well, I want to be glad, but now we're about to move over to Sarah's case in chief, where she will finally be given a chance to present her case. She's been trying to do it this whole time. She has no idea what's happening, so she keeps trying to throw out every single argument she can in the inopportune and incorrect moments, in spots, in places, and times. But now is that time. This is the time where she needs to make all of her arguments and state very clearly why she deserves to still get paid, and it's court ordered is not going to cut it. So let's see if she can do it.
Get used to disappointment.
Ms. Boone, I will give you an opportunity to talk about the financial affidavit in just a minute, but I'm going to ask counsel any additional witnesses.
No, Your Honor, I just have some reserve a little bit of time for closing argument.
All right, any additional evidence?
No, Your Honor, just some demonstrative aids that I'll be arguing closing.
All right, Mrs. Boone, counsel has indicated that he has no additional witnesses or exhibits for this court to consider. I am now turning it over to you to present any evidence that you want this court to consider and any testimony you want this court to consider. And that includes any testimony or any explanation or additional testimony you want to provide to the court regarding your financial affidavit. Once you are done, counsel for petitioner will be able to ask you some cross-examination questions as well, okay?
Yes, Your Honor.
All right. And again, I'm going to say to you again, the topics we're here on today is the proposed parenting plan that was admitted into evidence as petitioner's exhibit number 1 that was pre-marked as G in the packet of materials that you received, as well as the request to have the alimony of $1,000 per month discontinued and the issue of child support of $100 per month discontinued and the request for attorney fees. Those are the only issues the court is considering today. Those are the only issues that you will be permitted to provide evidence on at this time. Okay?
Forgive me, it's Exhibit D, the proposed amended parenting plan, the attorney fees, and what was the last?
The request to discontinue alimony and the request to discontinue child support, which I think you said you agree that he should not be paying child support as of February of 2020.
Okay. So parenting plan, attorney's fees, and alimony.
Correct.
Okay. So for the parenting plan, I would like please to put into evidence my number 2 and 3. I'm sorry. The parenting plan, the original one. My number 2.
All right, give me just a minute.
Where it's signed by those parties.
Counsel, do you have any objection to what Ms. Boone had pre-marked as Exhibit 2, which is the parenting plan that was filed with the court back on May 9th of 2018 coming into evidence?
No, Your Honor.
All right, hearing no objection, I'll receive us into evidence what was pre-marked as Respondent's Exhibit number 2 as Respondent's Exhibit number 2. All right, what was the second document?
The second document is the certificate of completion for the parenting and divorce class, my number 3 and 4.
For the record, I have here what Respondent marked as 3. It is a parenting class certificate that was filed back on April 24th of 2018, and which is pre-marked as 4, is the parenting plan certificate filed back on May 15th of 2018. Any objection to Exhibits 3 and 4?
No.
All right, I'll receive into evidence what was pre-marked as 3 as Respondent's Exhibit number 3, and what was pre-marked as 4 as Respondent's Exhibit number 4. All right, what's next, Ms. Boone?
Am I allowed to explain those?
All right, I don't know that any explanation is necessary, but go ahead.
In regards to the parenting plan, first and foremost, I would like to state that one moment. From my parenting or from my pretrial statement, please, I would like to say that my incarceration has nothing to do with me as being a human being and a mother to my son. I've done everything I possibly can to be a part of his life, regardless. And
that's why you're in this position right now, because you still don't get it. You are saying my incarceration does not define me as a human and a mother to my son, as if you being incarcerated is the issue at hand. No, that is a consequence and an after effect of you murdering someone. You said that doesn't define you as a human being when you have taken another human being's life. That is the issue at hand. That is the true issue at hand. Because you did this, you isolated yourself from society and were locked up. You have then tried to deflect and make it symbolic, or I don't know, dilute it down to you're treating me like this because I'm incarcerated. And she could play that little game before trial because innocent until proven guilty. I didn't do it. It's unintentional, yada, yada, yada.
But not intentional. My intention was not intention. I didn't do it intentionally. That was not my intention. But my intention, intentional. I intentionally did not do. Intentionally. Not intentionally. Intentionally. But my intent, unintentionally. Intentionally. Not intentionally. Intentional. Intentional. I promise you, it was not intentional, which I swore on my son's life was not intentional. Swore on my son's life was not intentional.
But now that you have been convicted of murder,
we, the jury, find the defendant guilty of murder in the second degree.
That will always be part of the definition of Sarah Catherine Boone Paulson.
Eating my peach.
You don't get to walk away from your actions like that. No. Sorry about it. Because I bet if you asked her, is your son a defining part of you as a human being and this and that? And she would say, of course he is. I'm his mother. That is basically her whole identity.
My son, where my son was located. My son, yes.
My son can't come over here because he's here. I want to see my son. I can have my son come over.
It's your house.
My son out of school.
That's fine.
And my 9-year-old.
Well, he's at school.
And that's what we're here to find out. We're just here to get the answer. The answers that you want, the answers that his family's going to want.
I just really want to see my son. I really need to see my son.
Everything else, I have no idea what it is. No idea what it is. Nonetheless, I've had my son over the house too, so why is it you all think that y'all don't know me, you don't know me, nope, would do something like that, especially having a 9-year-old son? I don't think you all understand who I am, where...
Okay. Well, tell me.
I mean, I've always been a straight-A student. I am an outstanding mother to my son.
Well, why is that? Because you gave him life. For you, that was a defining moment in your life. So what do you think happens when you take someone's life? Whether you want it to be or not, that is also a defining moment in your life. And because of that, everyone else's life has to change that was in your orbit or has to deal with you. And it's so annoying thinking back to when she said in the interrogation the day after, this has changed my life and I understand the severity of this. And he's like, he's dead. And she shouts, it's awful. It's awful.
See, and then it's all backfired on me. Like, it's all backfired on me. And I understand the severity of this.
He's dead.
It's awful. I know.
Okay.
It's awful.
As in, no duh, how could you remind me? Of course it's bad. Of course I understand the severity of this. No, you don't. 5 years later, and you still have no clue of the true severity of your actions. Because if you did, you wouldn't be shocked every 5 seconds when all of these things happen to you. But then no, also, because none of this made sense. She put in the exhibit of the parental parenting class certificate, the class she keeps talking about because she wants Brian to take it due to parental alienation and wah, he's not treating me right. He's doing all the wrong things. So you need to be taught a lesson, Brian, and you need to take this class. Whatever, right? So she accepts the exhibits and then she's like, well, am I allowed to explain them? You don't need to explain a certificate, but go ahead. Well, according to my pretrial statement, so you mean you're not actually explaining the exhibits, you're going off into a whole new tangent, which you could have gone off on anyway after they accepted the exhibits. But no, you said you have to elaborate on the exhibit by going the complete opposite direction. And then she had that stop-start of, first and foremost, I would like to give me a moment. And I've cut out a lot of spaces in between this because a lot of these times are uncomfortably long. I feel so bad for those who are in the courtroom because that must have been so cringe. Especially, it's kind of like I'm sure it was like a FBI, CIA torture because you never know when she's going to chime in. And it sounds like they have the volume cranked as loud as it can go. So I imagine it was just echoing in the whole room, and that's a lot. This whole thing is a lot.
I've done everything I possibly can to be a part of this life, regardless. And with the active parenting plan, my former husband has excluded me from my son's life in every way, shape, and form and alienated me, which is not part of the active parenting plan. So since 2020 of my incarceration to the present date without any modifications, he has followed the parenting plan in regards to trying to encourage the relationship as discourage the relationship. the point of my certificates of completion are to show the different topics that were covered in the court-ordered class that he had the understanding that he was supposed to abide by in regards to acting appropriate towards the other parents in front of the child, which he has not done. And the burden of proof is on the opposing party to show unfitness, and I shouldn't have to prove my worthiness. And I've done everything I possibly can in regards to be a part of my son's life. And as you heard the petitioner himself say, he doesn't care. He does not answer my phone calls. He does not answer my chat messages. He does not respond to my letters. He's not made any attempt to find out any contact information. He's not done anything in regards to have me be a part of my son's life, and is now going from having me speak to my son on an almost regular basis down to one 30-minute phone call. I believe that is more detrimental to my son as opposed to helping him when I have had my parental rights intact since day one of my incarceration, and have helped my son since the day he has been born. And I don't believe that they should be terminated, or a 30-minute phone call should be viable, because no alternative exists. My parental rights should not be taken away. That could just be a last resort, and I don't know why he's doing it.
Why is this happening?
Because George is dead.
And I am used to him saying he doesn't care. And I believe that my rights should be preserved, and I have all of my case laws stating such. So I don't know what I'm supposed to state that, or if this is my opportunity. I don't know what I'm supposed to do.
How many times do they have to explain this to you? I keep trying to let her spout off and play as much as I can, but we can never get any farther because it's just a mess. This is the time when you are supposed to make all your arguments. Everything that you have been objected to this whole time, everything she kept saying, stop talking about this, focus on asking Brian questions about what he testified and the reasons that we are here for today. We went through all of that. You got your ass handed to you on that questioning by Mr. Martell. Now we're here. Now it is open range. You can say whatever you want. And this is what you say. You haven't made any ground still. From the beginning of this trial, you have not made any ground for your side whatsoever. You keep trying to put the blame on Brian for absolutely everything, but at the same time admitting that he is the only one doing absolutely anything, which looks horrible for you saying all of this and all of that when you haven't contributed anything to the child or the relationship and trying to raise the child. And we know she's back to reading the pretrial statement because she goes to, quote, former husband, because she didn't say that earlier. She said ex-husband. But now that she's reading again, she had to remind herself, I choose these words intentionally when I write because I'm trying to add another layer of disrespect, not that it is a naturally occurring word that I default to. But she accuses him of alienated her in every way, shape, and form. And that is not a part of the active parenting plan. No definitions for any of this. What do you mean? Define these. He alienates you how? You have no examples because you alienated yourself when you got yourself arrested.
Why is this happening?
Because George is dead.
Brian is not the reason you are behind bars. You are. So he didn't do this. It cannot be parental alienation when your actions are what placed you where you are. Let's say you went down a noble path in life and alcohol didn't absolutely destroy any prospects you had at being a functional member of society, capable of contributing anything. And let's just say you were an astronaut, right? You were on NASA and they shot you to the moon and you wanted to talk to your son all day, every day. How is Brian alienating you when you decided to send your ass into outer space? While yes, this is a metaphor, the distance that you place between you and your son will always exist on some level, and that is not Brian's fault. And courts don't like hearing this all or nothing. It's fine when you're arguing in the real world, but we are dealing with facts, hard figures, and trying to make determinations based off reality. And when you say he's alienated me in every way, shape, and form, and you also admit he's paid for every single phone call and tablet message you've ever sent, that he's bought gifts on your behalf because you've instructed him to do so, then wrap them as though you did it yourself and give them to your son. Scheduling video visits, dealing with this, dealing with that, all of that means nothing when you say he has alienated you in every way, shape, and form. She doesn't give him credit for anything. And you're saying it's not part of the active parenting plan. Point it out. What parts? You just throw out wild accusations and say, well, I should win because I said those words. And what she'll say in the future is like, you didn't listen to me. You didn't listen to my heartfelt determination to be involved in my son's life. No, we heard you. You just said a crock of shit. And it didn't go anywhere. She's just cycling through the same things. Well, there is no modification. Yes, that's why we are here. You can't bring that up as an issue when we are here to resolve that issue. He should encourage rather than discourage the relationship, which is what he does not do. Again, no definitions. You're just saying these things. But you finally wrapped back around and you talked about the certificates you said you were going to talk about originally. And those certificates are to show the different topics covered in the class about acting appropriately to each other, which he does not do. Again, not defining. How about you tell me these topics? Topics on treating people appropriately as in blank, which he did not exhibit when he did blank. But no. You're just putting out these blanket accusations, and it's just the wolf crying wolf again.
I thought it was the boy crying wolf kind of thing.
If every single thing is cranked to the 11 and you are being so abused and mistreated and neglected and alienated and all this and all that, how come literal receipts prove the opposite? So then she keeps spiraling, being like, the burden of proof is on the other party to show unfitness. Yeah, and they have. 7 Ways to Sunday, they have shown how unfit of a parent you truly are. And they don't have to do anything. They literally said judicial notice of her court docket where she was proven guilty of murder.
We, the jury, find the defendant guilty of murder in the second degree.
In the second degree. That proves unfitness. There is nothing Brian could ever say or evidence he could show that would exemplify more unfit parenting than a murder trial. And she goes, I shouldn't have to prove my worthiness. Okay, cool, that's a cute idea, but you do have to prove your worthiness. You couldn't even prove your innocence. And now you want us just to assume your worthiness of all of this, the $1,000, the endless phone calls, and you keep warping what he's saying. You keep saying my parental rights are being taken away. They're not. This is not a motion to terminate your parental rights. It should be. They absolutely should have gone for it at this point. That's another reason why he's being so nice. He hasn't alienated you because he still wants you to be in contact. He is still going out of his way with his amended parenting plan to keep you involved in the child's life when he really doesn't have to. So yes, you do have to prove your worthiness and your fitness, and you have not a single argument to support that other than I'm his mother and I've tried very hard. But then she admits that it struck a nerve. It hurts to hear the petitioner say he doesn't care, and I'm used to him saying he doesn't care. She has such a weird obsession with care, and she said this throughout her entire criminal process, all the letters. I highly doubt I'm going to look for them, but just trust me, it's there. But she talks about how the justice system and no one cares and no one's caring enough for her and treating her with care, as if anyone has to care about her. They don't. You chose not to care about George. Why do we have to care about you? He has not done anything to have me be a part of my son's life. We know that is false. You are speaking from a purely emotional stance. You want him punished, sanctioned because he made you feel bad. You want all the money because you feel like it's court ordered and you're entitled to it. You want all the time in the world because you feel like you deserve that and that your time would help your son be a better person, even though the father asserts that talking to you upsets him more than not. And you admit, yeah, that's a possibility, but it's because you allow him to curse on the phone. She's made so many backhand admissions that she has no idea. As if it's his job to make you an active parent. How is it his job to find out contact info for you? You are the one in jail. You should know your contact info by heart. You should be bombarding him. And we know you do that because we saw with Philip that you put your address so many times when you think people have messed something up and don't know where to send things. Why have you not bombarded him with your address? You said that you've sent him mail. So obviously he at least knows some address of where it came from. It just shows a sustained pattern of refusing to take any responsibility or accountability for her actions whatsoever. And I've had my parental rights intact since the day I was incarcerated. Yeah, because things don't happen instantly. You've had your case law. You're talking about all the case law you want to bring up. But there's case law out there that incarceration does not in and of itself inherently terminate parental rights. Great. That's why you have to go through a process like this to do it officially. And I've helped my son since the day he was born. Okay, congratulations. Do you want a cookie? I'm sorry, parenting is a very thankless job, and you don't get brownie points for not abandoning your son when he was first born. Congrats. Glad you didn't. But it does not make you this saintly mother by simply harassing your child into loving you. And she keeps saying, like, I believe that would be more detrimental to the child than not. But she has no proof or any reason to back that up. Why? Why would that be detrimental? Well, because he needs his mom. I mean, she's not even saying that, but that's the inference. But you needed to provide reasonings for why you need to be in your son's life. I mean, you do the sunny Sunday scripture thing. You could have said, I'm needed in my child's life because I keep him close to his faith and I keep him, this and that. And Brian doesn't do this and doesn't take him to church. And so I bring this necessary aspect, something that, makes you stand out as a reasoning why talking to you is a positive, rather than the only evidence that you as well have agreed with, that he does not feel great after talking with you all the time. Okay, I'm rambling. Let's keep going.
The minor child is very aware of these ongoing hindrances and speaks about to the respondent and his desire to see her in person, which she also has been asking Petitioner about almost on a daily basis. The minor child apologizes to the respondent regularly that the petitioner does not do and prolongs their overdue time together in person. The multiple children's rights he has violated in regard to developing an independent and meaningful relationship with each parent because of the petitioner. He is present during the parents' personal battles while I'm trying to speak to him on the phone. To speak ill will, he has called me murderer and killerer in front of my son, which is another reason why I wanted to have the guardian ad litem, which has been denied, I believe, 3 times. He doesn't include me in any way, shape, or form in regards to anything that has to do with my son's life. I know a lot about my son. I know what his favorite color is. I don't believe that Petitioner even knows that much. The name of his girlfriend, the things that they're going through. I am part of his daily life. And for him to take that away from me is just out of bitterness and spite. I want to be a part of my son's life. And people forget that I have a pending appeal. So to prove my innocence, which is what I've been doing since day one, the reason why I was incarcerated in Orange County for over 5 years, or at least 5 years, was because I continued to fight for my case.
Yeah, that's literally what every criminal does before they are convicted. Everyone, quote, fights for their case. Oh my goodness, what? And she's just saying, because I was fighting, that means I'm innocent. That means I'm doing good things, even though a man is dead because of what you did.
And then it's all backfired on me. Like, it's all backfired on me. And I understand the severity of this.
You did it.
It's awful, I know.
Okay.
It's awful.
And you want more than anything for everyone to just forget about it, and we won't do it. I just want to know, is anyone ever going to explain to her that that is not what an appeal is for? We've gone over this multiple times on the channel, but if you don't know what the appeal process is, appellate courts are normally a panel of 3 judges who review the case docket to see if the trial court made all the correct decisions. The appellate courts do not relitigate the actual case. The evidence is only consequential in terms of context, not in terms of validity. Because this evidence exists, did the judge make the right call, and whether it's admissible under certain contexts or whether this or whether that, that's what they're judging, not whether the evidence is accurate or not. And for some reason, she has this false belief in her head that the appeals court is just the trial court all over again. No. Let's say they side with her. Let's say they say, making her go pro se after going through 8 lawyers was just cruel and unusual punishment. She needed at least 20 lawyers before we actually considered taking them away from her. So you win your appeal. Congratulations. What does that mean? That means they send you right back down to Kranick again. And you rerun the trial all over again. In some instances, you can get a new judge if you want. You know, that's not always guaranteed. But then you would just go through the exact same process again. And maybe instead of an 1.5-hour verdict, you can actually get them to deliberate for 2 hours. But at no point in that process are you proving your innocence, nor is release an option in your foreseeable future. I mean, forever, but even if you won the appeal, for an indefinite amount of time. And appeals also take years to go through. So she says she has a pending appeal, yet you will have a pending appeal for years, especially when you're on your 4th appellate attorney. Wow. So your pending appeal may be indefinite, and no one has time to wait for that, so we need to make these decisions right now. But yeah, if there are any friends of hers out there, please tell her her appeal will not set her free. But in terms of this chunk, she's just reading from the pretrial statement. The minor child apologizes to the respondent regularly. I mean, like, you're literally referring to yourself in the 3rd person as respondent, but whatever. Because the child knows everything that he does and is so apologetic because he can't believe what his father is doing to me. You are using that boy as a shield, and that is gross. Family court judges deal with this all the time. Like I say, she is the most stereotypical abuser that there has ever been. She checks all the boxes. Every time we enter a new realm of abuse and she happens to have crossed that realm and been made queen or high priestess or the patron saint of audacity to do the things that she does, she still finds a way to exemplify every single aspect of that abusive nature. And we are in the deadbeat parent realm, and she checks every single box again. This is I'm using the child as a shield in order to deflect my own inadequacies and my own issues and try to paint that on the other parent who is actually the one raising the child and being responsible. That way, as long as I make everyone else look bad and make you believe that they are bad, then that means I'm good, right? Forget the actions. I am solely focused on people's perceptions of me and not the reality and the facts of the situation. As if even if we bought the constructed perception you want to throw on us, that would not change the fact that you murdered someone and a jury of your peers found you guilty of murder.
We, the jury, find the defendant guilty of murder in the second degree.
You wanted to just say my criminal incarceration and criminal acts have nothing to do with this because this is family law. Your criminal conviction overrides all of this. So every time you keep saying he's parental alienation, he's called me murderer in front of the child, there's a difference, there's nuance. Has he told the child that you are a murderer, or has he told you you are a murderer and you assume the child is in the room at the time, thus overhearing you be called a murderer? Those things are different. Either way, he's absolutely in the clear because it is a truthful statement. You have been convicted and determined. You have been adjudged guilty.
She seems like everyone else, not to remember. I am innocent until adjudged otherwise.
Guilty of murder in the second degree.
She treats me as if I am not.
Guilty of murder in the second degree.
So the disparagement clause, which is standard in most parenting plans, is not being violated by talking about a truthful situation. Yes, you're not supposed to disparage the other parent, but speaking true facts is not disparaging. It is trying to explain and talk about a difficult situation that the son has to come to terms with and has to cohabitate with in some way. That nebulous elephant in the room that follows him everywhere, she doesn't care. She thinks you should ride the elephant to her and then thank her for bringing you such a nice gift. And she does what she always does in her criminal court case of saying all my constitutional rights are violated. Same thing here. He's been violating all of these child rights, these children's rights of him to develop and have an equal shared relationship. You can never have an equal relationship because of your actions, not Brian's. Brian's inactions, as in his inability or lack of ability or lack of willingness to go above and beyond so that you feel just as involved as a parent, does not make him legally liable for any of this. It just shows your feelings are hurt and you wish things were different. But they aren't. And you bring up the guardian ad litem again, and you said, which I think was denied 3 times. Maybe take the hint. If it was denied 3 times, denied by your Honorable Judge Jackson.
Miss Jackson, ooh, I am for real.
So it's like you're trying to scold her, saying all of these things, all of these very valid, true, legitimate issues are your fault because I tried to have a guardian ad litem in order to prove this. What does that mean? I wanted to get a guardian ad litem to use as a sword and have my son as the shield so that I could attack Brian and say, look how unfit he is. Look this, look that. This is what he's done. Failing to realize, because she doesn't think outside of her own benefits and her own thoughts, the damage that would do to her son. And that's why it was denied, because he doesn't need to be involved. Can you imagine if he were in that courtroom right now, listening to the way that she's been talking this whole time? No child needs to hear their parents going back and forth like that. Unfortunately, because of the virality of this case, he will see this at some point, but he didn't need to be in that room. And she tried her hardest to get him to be an equal third party in all this, to get the guardian ad litem to do this investigation. And do you know what this investigation would be, since she wants to get into the parental alienation? That guardian ad litem would have to go to the child and say, hey, has your father ever called your mother a murderer? And he can say yes or no. Let's say he says yes. He then goes, and how did that make you feel? Now the son has to connect with that word and is reintroduced to that traumatic experience, has to unpack what that meant to him, disclose that so that you can get the right answers that you want to show how much pain and suffering he puts your child through by calling you a murderer, ignoring the fact that you're a murderer.
guilty of murder.
And it's those details that just shows she's centering herself, and the child's well-being is not actually in this picture, which is the whole reason you would have a guardian ad litem. Then the next deadbeat parent checkoff box is the, I know a lot about my son. I know his favorite color. Again, in her mind, when she was arrested and he was 9 years old, he has been 9 years old ever since. I know my 9-year-old's favorite color might sound more appropriate or not as weird as a 13-year-old or 14, 15, I don't know how old he is, as a teenager. And then has the audacity to say, I don't even know if the petitioner knows that. I know the name of his girlfriend. If you know these things, how on earth would Brian not know these things? You think that he hid the name of his girlfriend from his father, but waited to tell you, someone who I'm sure hounded and twisted it out of him, because who's out here just giving out that information randomly? Well, I don't know, maybe. But it's so desperate because these are the same talking points she already brought up before, and Judge Jackson had to stop that and said, we're not doing this here.
Not on my watch. The majority of the time, I will tell you this, which you are unaware of because
You're
you
not
do not
telling anybody anything, ma'am.
Not on my watch.
You're not telling anybody anything, ma'am. You're asking a specific question. Ask your question.
Because you're not going into the son's life to further use him to manipulate. It's tacky, it's overplayed, and it's as obvious as can be.
I know that the petitioner understands the reasons why of the enclosed 30% time period because of the danger and safety. There's a lot of things that I was trying to protect my son from. I'm not that parent because I was trying to make sure he was safe and in a safe place.
Yeah, you're not a bad parent. You're a shit parent for putting him in that danger to begin with. That's just so insane. Again, if it's not your fault, it's Brian's fault. If it's not your fault, it's your son's fault. If it's not your fault, it's all the judge's fault. If it's not your fault, it's George, your murder victim's fault yet again. The true danger has always been you. It's because you wanted your son when you wanted your son. You want not to take custody of him to like actually do your job as a mother, as an outstanding mother, and care and raise your child. You wanted him when you wanted him. Brian mentioned how you would go over to his house instead of actually having him stay with you so that you can play house at Brian's house and all this and all that.
I mean, she told me like a week ago she had to escape from the house and wanted me to come pick her up. I told her I wasn't going to because I'm just tired of it happening. I mean, it was midnight. I mean, child's trying to sleep and just honestly, I don't always believe her when she said these things were going on. And
She called you?
Yeah. Okay. Yeah, and I mean, apparently she went back inside and slept well. Was in a fine mood the next day. I guess didn't really remember calling me, so I don't know if it was just
brought up again?
if it was just she wanted to come over to. I don't know. She keeps on trying to come over to like hang out or something like that, or she'll come over to spend time with. Rather than actually just having him over here like she's supposed to, but she wants to come over there and play with him. And so,
and then you get to go back to your little party mansion where y'all get drunk 24/7.
In excess. They didn't drink to drink. They drank to sunrise to sunset, all the time in between.
They were always drunk, like I was saying before, like always, like sun up to sundown type, like all the time.
They almost always seem either like tired or like tweaked out.
I do know that I have seen both of them intoxicated as early as 9 o'clock in the morning, and I mean staggering, falling down intoxicated, both of them. Sarah was actually wandering around the property very drunk, barefoot, not properly dressed, I'll say it like that.
And it strikes a nerve with her because she thinks, well, that's the excuse I've been writing for 7-8 years. that I'm only doing this and only not having him because of what George has done and because it's so dangerous. And George. She always has these default excuses, and now that her default excuses are literally dead, she's still spiraling because that's all she knows. All she knows how to do is blame others for her actions. A good mother wouldn't take her child and drive to go pick up her alleged abuser and then call Brian to come pick up her child because her alleged abuser is over and she can't have him over. And then every time Brian goes and picks him up, there's never really an issue. And it just so happens that as soon as your son's gone, your whole night gets better. And she always does this thing of the petitioner knows, and I know that they know the reason. Like she's done that multiple times where she just, again, pushes it on the other person of, I shouldn't even have to explain myself because I know that you know. So we all know that it doesn't even need to be said.
If I knew to be prepared, I know that everyone knows that I would be prepared, which I am unprepared because of.
That's certainly your opinion that you're entitled to.
My verbal statement is primarily to the Torres family, to the judge, to his daughters. I know you all know who I really am and that I did care for George and that I do still love George.
I don't love you.
I know that everyone knows that I would be prepared. I know you all know who I really am.
I know that the petitioner understands the reasons why.
Constant and sustained danger he was under while he was over, even though everyone recounts that George was a happy drunk or an emotional drunk. We get happy or sad real quick, but what did everyone say when you get drunk? You get violent, you get angry, you get abusive.
But I mean, she started just getting really angry when she drank a lot. She said last night she fell asleep. There were plenty of times where she just basically passed out from drinking. So,
and your actions track. So I'm still not buying this whole I couldn't take care of my son because my abuser had full control over me and I was just so helpless, and it just happened to line up with my own personal interest, and I had no issues bringing random strangers back home when I was still together with Brian and have them just shouting her name while their child is in that same house asleep.
the alcohol has gotten worse and worse and worse over the years. That's one of the main reasons why I divorced her. I just couldn't deal with it. I mean, it got to the point where, on weekdays she'd go out, and I guess the George person is one of the people she had met. Because I separated at one point and went over to my parents' house to live for a few months. And I guess she met him over at the pool place or something like that. But I'd come back and we were in therapy trying to work it out. And I mean, on a weeknight when he's got school the next day, I've got work the next day, I mean, she was out till 3 o'clock in the morning when the bar closes, and she'd bring people back over on the back porch. I mean, one time some random person walked in my house and started screaming for Sarah at 3:30, 4 o'clock in the morning when we're trying to sleep. I mean, I just couldn't get over it.
Not knowing these actual people's intentions. Great, you had fun at a bar and you want to keep the party going. Go to their house. Don't bring strangers to your literal child's home in the middle of the night, thus causing all this, because Brian said that was the straw that broke the camel's back of, I can't do this anymore. I can't get over this. The fact that you are bringing strangers. Cheating on me is one thing. We can work through this and we can just distance that. But when you bring your antics into the child's life, which is what you've done non-stop, then this is ridiculous and it needs to be cut off and your child needs to be protected. Meanwhile, a good parent doesn't introduce her child to the police after calling the police over a domestic dispute.
Who's this?
He wanted to meet you. Actually tell him what you want to be when you grow up.
You want to be a cop? Great job, man. Stay out of trouble.
Thank you. I'll call you later. Okay. But Dad,
That's your.
night, termite.
That's your.
I love you, baby head. Yes.
Oh, with your ex-husband?
Yes.
Okay.
And even the officer is just like, you can feel the tension in his responses of, why am I talking to a child at 1 a.m. right now? Good parents don't do things like that. Because the truth of the matter is, that she felt trapped after having her child. That's what Brian said, and it tracks. In every one of her actions, she had her midlife crisis. She was a married wife, mother, 13 years, had a kid, and now that wild child has been contained, so she can't do all the things that she wants to do. Then she finds George, someone who's also in the throes of the same addiction as she is, and who tells her all the nice words that she wants to hear. So she gets to create her alcohol-induced delusional world when she gets to have her pawn son when she wants, and when she doesn't, she gets to call someone to take him away, and she gets to have her pawn boyfriend George when she wants, and when she doesn't want him, she has someone take him away, either his parents or the police. She thrived on controlling every aspect in her life, and when it all got taken away from her, she lost her mind.
It seemed to have gotten worse and worse. I think more or less kind of since we had, and I think a lot of it was the fact that she kind of, I guess, maybe felt trapped or something.
Okay.
That, I mean, before that, I mean, whenever she wanted, you're outside having a drink, oh, I want to go play pool, you go over across the street, you play pool for a little bit.
Yeah.
That's not happening anymore when she got a kid.
Right.
So.
How old's your son?
He is 9. So, but I mean, she started just getting really angry when she drank a lot. She said last night she fell asleep. There were plenty of times where she just basically passed out from drinking. So,
you've witnessed her pass out from drinking?
Oh yeah.
I'm not that parent because I was trying to make sure he was safe and in a safe place. The time sharing, it's, of course, it makes no sense to have the realization was not what we're talking about now. I do not feel that it is right for me to have a 30-minute phone call with my son when I'm trying to do everything that I can to be in his life in every way, shape, and form that I possibly can, from having people in Australia purchase him a record. Anything that I can possibly do to go out of my way to do, I've been doing for him. So he remembers and knows that I am in his life and I am his mother, and I am doing everything I possibly can to stay that way, regardless of the petitioner and his counsel's attempts to deter me from being part of that. I try to communicate with the petitioner in regards to my son. I've been continuously excluded. There is no communication. I don't know what else it is that I can possibly do that I haven't tried to already. And a lot of these, too, I would like to remind everyone, these could have been solidified where they have had the meeting of attorneys and unrepresented parties meeting. A lot of this could have been had and resolved and narrowed if we were to have that meeting in regards to all of this. Nonetheless, if the petitioner would have answered a phone call or a tablet message, it's not fair to me that just because I'm here, it doesn't justify how I've been treated and excluded.
Okay, well, it's not fair. It's not fair. It's not fair that you guys automatically blame it on me. It's not fair. See, that is just not fair.
It's not fair to me that just because I'm here, it doesn't justify how I've been treated and excluded.
It 100% justifies why you are being treated the way you've been treated and been excluded the way you've been excluded. If cold-blooded murdering someone does not disqualify you as a parent, thus requiring distance and exclusion from some things, then there's nothing in this world you could do that would make you an unfit parent. Especially not in Sarah's eyes. She could do absolutely anything and not see a thing wrong with her and still call herself an outstanding mother to her son.
I don't think you all understand who I am, where...
Okay. Well, tell me.
I mean, I've always been a straight-A student. I am an outstanding mother to my son.
Okay.
I excel at everything.
With it, I would like to continue to have the regular phone calls and interaction with my son, which I have been doing, and all of a sudden now is being tried to be taken away from me out of sight, as opposed to my son and his growth and him moving properly and appropriately and lovingly forward with his mother.
And there it is. You're trying to use the court again to basically force your son to treat you lovingly and appropriately moving forward. Because you're coming to the court to say, no one cares for me, no one's treating me right, and after I get this court order that orders me $60 million, as well as all the time with my son in the world, I'm also going to use this order to say you need to be moving appropriately and lovingly with me, and it's all your father's fault for not doing so. So it's always just, everything is centered around her. If you think your son cannot function or grow properly and that you cannot impact them or have a positive growth or do anything without daily phone calls, then you're probably not good at what you think you're trying to impart on him. You can still make that impact. It's about the quality of the conversations, not the quantity, but whatever.
And I would very much like, please, after 9 months of asking for my son to please come see me, which is only 50 minutes away, which I think will change both of our lives with finally being able to see. I don't know if you can hear me, but there's incredible feedback. Static.
We can hear you. Can continue.
And
Yeah, we heard you. You're just mad because you're not getting any feedback, so you can't tell if any of this is landing, and it absolutely is not. Because you keep making the same statements without actually making a point.
I would like from the parenting plan my resolutions, please. If I need to, I don't know what I'm supposed to do if I say it again. If that's on record from previous.
Everything that you have said is on record. Oh my goodness. You don't have to repeat yourself ever. Of course it is on record, and you know this, you're just lost. So you're just spiraling again and again and again, and we're just going to keep returning to things. I'm waiting for anything new. Please. Just make up a lie at this point. That's right, Linda. Preferably a new lie.
Daily telephone call, personal space for him to grow up as the teenager that he is. He's going to be a legal adult in 3 years, which is why I'm unclear on why he's fighting for this. So
he's fighting for this because he's actually fighting for his son. Unlike you, who are fighting for yourself to be in your son's life, and you have stalled and stalled and stalled, and this has been 5 years that you have been out of his life, and he filed this petition to modify and to cut off all of this bull in 2022. So you have extended this 3 more years. That's why he's fighting so hard, so that they can get those 3 years of their life to themselves. Again, I get it. In your mind, none of this matters because you'll only be in prison for the rest of your life. So 3 years is nothing. But in the flip side, 3 years is nothing by your account. So you should just wait it out, continue to develop your relationship with your son, and then when he's 18, he will want to come visit you. All the times that you say he wants to visit you right now, he will have all the free autonomy and opportunity to do so.
the petitioner, nonetheless, I've not been included in anything major or included in an ending period since day one. So I don't understand. But I'd like to have, please, tablet messages, all the procedures, everything that I can possibly have still please to be in my son's life.
Everything I can possibly have to still be in my son's life. You are in your son's life. There are people who are actually out of their children's life. I don't know, for instance, George. And there are people who are alive who are out of their children's lives in prison for life just like you. You have access. You have admitted that you have access. You have admitted that you have been involved and that they just have not sided with you. So every time you keep saying, I've never been included at all, it's just a lie.
This is another reason why, too, that I was trying and adamant to have a guardian ad litem appointed. And I believe that I would like to suggest that some type of co-parenting course or counseling in regards to how to treat the other parent which he has already taken, but back in 2018 upon our original divorce. So he can be reminded, please, on how to treat the other parent and also look out for our son's emotional distress that he has been causing him by calling me names and not speaking to me and giving me the silent treatment.
Now, how does that make any sense? Again, it's so childish. I want you to punish him by making him take a course just so it reminds him of how to treat me right. So it's a shaming element. You want to shame him into treating you right. Not that you actually want him to be informed or to get necessary tools needed to co-parent under these situations. No, you want to punish, embarrass, and shame him into doing what you want him to do. And you are now saying that he is causing the emotional distress, which the only testimony to someone causing emotional distress has been you causing your son distress after the way you talk to him. We've been over the texts. It's deplorable the way you talk to that person. You shouldn't talk to adults that way, and you for sure should not be talking to your child that way. That is what is causing him emotional distress. Not you saying Brian is causing him emotional distress by calling me names, by not letting him talk to me, by giving me the silent treatment. Who is this? Are you saying that he's causing your son emotional distress because Brian gives you the silent treatment? How on earth would this affect him whatsoever unless you bring it to him every time you talk to him? And then blame shift and say it's Brian's fault for forcing you to do that in the first place.
When I'm trying to speak to him solely in regards to my son, I'm doing everything that I possibly can for my son. I've been avidly striving to and will continue my pursuit to be even more meaningful to my son in my continued hard-fought efforts to see him in person while temporarily located at DOC and in the meantime of my appeal and my release and all other positive aspects that I have with my son on the horizon. I've encouraged him, acknowledged him, understood him, listened to him, believed in him, and I make him stronger and more beautiful. Foremost and above all, meaningful means love with the respondent. Ceaselessly and immeasurably will always have a wholeheartedly provide for her son, which is priceless, and no circumstance or agreement or modification in any lifetime can change or end.
So she just went back to reading now. And I love that line, and I think I mentioned it in my original reaction in the future of, you hear that, Judge? She says, nothing you do can change anything. So this is all just a waste of time, and the only thing that can be gained here is me getting my money. Other than that, there is nothing you can do that will ever change my bond or get me a bond.
I'm hoping that the court can see my ceaseless attempt and whatever it is that I can do in order to stay in my son's life for longer than 30 minutes per week, please.
Boom, granted, because a million times people will have to tell you that that's not what's being proposed. One call a week is being proposed, not one 30-minute call. Ideally, just one 30-minute call, but we know you'd throw a fit, so you can do 2 half-hour calls just on the same day. So you misquoting this every single time just dilutes the overall impact of your arguments, because you're saying, oh, I'm not going to be included at all, and they're going to be like, okay, bet, now you're included, and then move right along. But if you made actual arguments about the necessity for that much communication, I mean, you don't have any arguments for that, thank goodness, no viable ones. But if you had made specific ones of, I need to speak to him this many times for this amount of time, you would be able to get somewhere. But you speak in absolutes of, I'm not included in my son's life at all. I would like to be included for more than 30 minutes. K-bet. Gotcha.
I have a lot to offer, and I can help him grow in multiple ways. And I am his mother, and I wish that I had the guardian ad litem or my son to be included in this, which, if I can also include, please, into evidence my It's the notice of filing the respondent's answer, the supplemental petition for modification of final judgment, which is number 7, please.
Okay, give us just a minute. You said number 17?
7.
7.
Yes, Your Honor.
Give us just a minute. We pulled the wrong one. All right. So what I have before me is it looks like petitioner filed a handwritten document on it's dated May 1st of 2022, but it looks like it was filed with the court on May 16th. And there was a notice of filing by Attorney Martell. Looks like he may have received a copy of it and he filed it with the court. Is that?
Let me just pull it up, Your Honor. I'm sorry.
It's okay. But I am seeing it both in the court file on May 16th of.
Is it an answer to our?
Yes, and it looks like you may have filed a notice of filing just to make sure it got into the court.
I no objection.
All right. So I'm going to receive what is presented as Respondent's Composite Exhibit 7, which is that notice of filing by Attorney Martell, as well as the actual handwritten answer. I'm going to receive that into evidence as Respondent's Exhibit number 5. All right, Ms. Boone, you may continue.
And this might be a good place to cut in real quick because they're going over this document letter that she submitted. And I haven't actually read it on this channel, but I do have it thanks to Tanika. Thank you. So I want to just read that out real quick. I might not do this if she brings up other letters later on, but I'll at least do this one so we know exactly what she submitted into evidence and where she's trying to go with this. Plus the letter is a disaster. May 1st, 2022, the marriage of Brian C. Boone, Sarah K. Boone, case number da-da-da-da. Dear Sir/Madam, I am writing in regards to a summons I received 4/22/22 stating a lawsuit has been filed against me in the aforementioned matter. As instructed, this letter will serve as my personal/individual written response to the supplemental petition, joint stipulation, and notice of appearance included. I am in the process of trying to obtain representation for this and diligently working day by day, doing the best I can, and am literally able with the little to non-existent resources I have available. Please know with great emphasis that I am doing everything possible to defend and protect myself as a person and a mother foremost, while incarcerated temporarily. I have nothing and no one to help me as both my parents, grandparents, aunt, and uncle are deceased. I have an older brother who is unable to be located and a younger brother who is currently deployed in Africa for the Marines. I also have no counsel of any kind. Per the summons packet, I have tried to contact a referral servant and legal aid via phone with no success due to the numbers being, quote, unauthorized in accordance to the rules of OCCD. I am working expeditiously to find an alternative way to contact and figure out some type of facilitator in the meantime. Your patience is greatly appreciated. As said, I am doing all I can to stress my dedication as well as the seriousness to this matter as a concerned parent and how it is of the utmost importance to be rightfully conveyed and understood as the very competent, caring, loving, hardworking, determined person that I am and whose, quote, mental ability to co-parent is undeniably obvious and without any doubt should be included in the ongoing nurturing of our son. My decisions, ideas, opinions, feedback, rules matter. To be excluded in any way just because of my current temporary
to life in the Department of Corrections
circumstances and location is wrong, unfair, and unacceptable. It makes absolutely no difference where I am. Jail, space, Australia. I am not and will never be useless, especially to our son. I am still his one and only mother who loves, cares, and adores him beyond measure. It makes his safety, mental, emotional, physical, and spiritual well being my priority and will for the rest of my life. I will never stop being his mother and using my God given talent and rights as his mother to remain so. One obscure, unfortunate incident does not define me as a person or my entire existence. I want my son to know and show him I am always willing to exceed any limitations placed upon me that would hinder my relationship with him as his mother and being included in every aspect of his life, then, now, and future. He is my life. Who is former husband to assume and to quote, think his sole decisions are the best, fairest, and most successful for our son. I have God, my giving heart, functioning well above average. Functioning well above average, brain and bold voice to be my son's best advocate as well as my own. I matter. If needed, our son should be included and asked his thoughts of his father attempting to remove my right in being his mother and only ever be able to ask about his video games and what he had for dinner. Nothing of moral value or life defining. I am not the worthless, mindless, heartless, unproductive, non contributing, poor, and pitiful footstool he would like me to be and tries to make me out as to others. It makes no difference where I am. It's who I am. Mother, now and always. And again, one incident does not define me or my entire existence. I have so much to offer in so many ways, and it would be extremely detrimental as well as a great loss to not be able to continue in the shaping of our son and his very extraordinary life. Is former quote husband able to handle the consequences, burden, and heartache should his decisions jeopardize or harm the best possible outcomes and inhibit the absolute success our son could have been or had? How will this sole great responsibility, should it be awarded, affect the former husband's mental ability going forward, as all instances, scenarios, and situations are not the same? That is why there are two parents, both to broaden all horizons, outlooks, and futures for their children, and in which I am so desperately fighting now to continue to do for mine, and all for the right reasons. I am no longer going to willingly make it easy for former husband to advantageously rob me of my last and only minute life resources out of bitterness, greed, and spiteful opportunity. At my weakest, broken, most vulnerable moment, he is attempting to take full advantage of such with this unwarranted, vicious attack, thinking, hoping, and assuming I will wave a white flag, which I do not own, especially when it comes to my son. He is wrong in doing so, knowing fully the playing field is not and has never been even. All odds are against me due to my monetary restrictions and lack of support system. It is illogical and futile to try and have a conversation or discussion that is real, rational, or legitimate with former husband about anything. Then during our marriage and now. His superiority complex and ongoing dishonesty have made it very difficult and sometimes impossible to work with him. This in turn has compelled me now to bring to attention some of my concerns in the egregious decisions he has made prior and during my incarceration, as well as from my son personally stating, quote, Dad's laziness, empty promises, and disappointments. Son knows without any hesitations or doubt I will do anything, anytime, anywhere all within reason, to help him, which is why I, his mother, have been his go-to person in many ways for many things throughout his life, including while being incarcerated. Former husband is penalizing me because I care nonstop and have regular ongoing concerns, questions as our son continues to grow that are important, needing to be discussed. Our son can and will grow better, stronger, brighter with my decisions included also, as they have been since I brought him into this world. Former husband and I did this together, and I may be obsolete to him, but I am not to my son, nor will I ever be. So stop trying. When trying to speak to or with former husband and have an opinion, idea, belief, feedback, etc., that is not in line with his or his parents, I have been laughed at, completely ignored, and disregarded, given the silent treatment, berated, and made to cry or hung up on. Most every time in front of our son. This to me is setting a poor example of how a man, husband, should treat a woman, wife. On top of being a bully, son hears and sees how former husband, his father, treats, degrades, and judges me, his mother. This is extremely confusing and sad to our son, as he knows I only discuss, or try to, anything that pertains to him. He hears me being told indirectly I am unimportant. This is unacceptable, damaging, and mean. Also having lasting effects, an inherited trait led by example of his father, and serves no purpose, quality, or value. A bad decision. What former husband is trying to do is sweep me in a dark, bleak corner and keep me there, hoping I find no way out. The quote, relief he is seeking means to remove any additional work, trouble, effort, concern, responsibility, etc., which would make former husband be the reliable, caring, consistent, honest person he should be. How especially to our son, and who I always wanted and needed him to be when we were married, possibly altering the current situation for everyone. Oh, okay. So now it's Brian's fault you murdered your boyfriend you cheated on him with. If I have no authority, power, or control, there are no discussions or interactions of concerns, ideas, plans, future our son does and will need involving both parents, me, the other parent included. Not only am I continuously disrespected, I am verbally threatened with some form of this looming lawsuit. In former, quote, husband's original verbal threat made sometime last year, early 2021, to take away my parental rights and funds necessary for my, quote, livelihood while incarcerated, after my sincere, heartfelt begging while sobbing to him while on the phone in the middle of my dorm, in my desperation asked why was he doing this to me, fully and completely knowing I have nothing or no one, and how meaningful it is to me to be called son's mother. His response was simply, quote, it will make you say yes now. If you keep doing as you have been, everything will be fine. I have been saying yes, as I had no choice if I'm even asked anything to be able to answer. I am unclear, as usual, when dealing with former husband, of his behavior with these new revised threats and demands that I have not already submitted to previously, seen, or even knew existed until now being served. I will not be erased or downgraded to nothing because former husband is bored and bitter. Totally unfair, and the cruel ego trip is disgusting and nothing to be proud of. What is the point? There is nothing left other than my dignity, which he'll never have. What would our son say? How would he feel knowing the truth? Please know, I do still have numerous other legitimate concerns needing to be addressed in the petition and personally, and should be by any decent parent respondent. This is not a one-sided attack and await the opportunity to clarify my specifics if when needed. I, the mother to our son, believe said concerns are very important. I've realized also this quote lawsuit may be my only opportunity due to my restricted resources to have them handled and hopefully remedied professionally, positively, and fairly. I am praying I can be heard, seen, and included by this letter in the ongoing proceedings, meetings, discussions, etc., futuristically. I am hoping also to have some type of representation to amicably bring this matter to a concrete conclusion, being beneficial to everyone. A copy of this letter is also being sent to legal aid. You sent this letter to Eagle to legal aid for review and assistance. Wow. No wonder they said no. In the meantime, I am still, quote, mom with my, quote, mom rights. The level of this, quote, lawsuit is unfair, unnecessary, and uncalled for. This lawsuit is also from one monotone side of former husband. I, the former wife, have a side also, intellectual, willful, and valuable, deserving to be heard. I am also fully dedicated and devoted to my son and his rights. His uninfluenced feedback should be included, and it is only fair to him to know the extent of the situation and the cruel attempts of his father to his mother. No one can tell the future or assume to. I was unaware former husband had a crystal ball. I have faith and will always, this being something no one can take from me ever. No one either is better than anyone in this or ever. And money can't buy everything, especially love, grace, understanding, and goodness. If former husband is willing to have a rational, reasonable discussion, however mediated, I am more than willing and welcome. If there is anything else I can do to show my very good intentions other than writing this letter expressing my desperation to continue to be included in my son's life, my understanding of the emergent need of counsel and sheer hope of a resolution, I am also willing to submit to a competency test or any kind of test to show my capabilities mentally and full ability to co-parent. I am not the ridiculous, ruthless, degenerate, felon former husband slanderously assumes I am. I love my son immeasurably and have a limitless abundance of positive, meaningful, solid, contributing life characteristics to share and have my son inherent from me, which is priceless. I can co-parent. I want to co-parent, especially if former husband is going to positively participate and understand rather than pillage and point fingers. A mother is her son's first love, in which I very much and with every fiber of my being want to still be. Thank you for your time in reviewing my formal written response in part of the petition. I am grateful for your understanding and hearing my side also, which is only fair and right to do. This is between both parents. I await your response and instruction. Please do not hesitate to let me know if anything further in my ongoing unreserved cooperation is needed. I am still in this, still a person whom former husband was married to for 13 years and has known for more than 20. Most of all, I am still the mother of our son and still important in anything, everything pertaining to him, come what may. Sincerely, Sarah Boone.
This was just me trying to be transparent with the petitioner's counsel and describing to them my need and want to be in my son's life back in 2022. Explaining my dedication and my decisions and ideas and opinions, they matter. One spirit enforcement incident does not define me as a person or my entire existence. And I'm trying to be my son's best advocate for myself. And two parents are involved. Just because I'm not there under the same roof to make the same decision, or at least I would like to be conferred with and included on so I know what's going on in the son's life. This is just me trying to know what is going on and to let them know what I'm striving for, that there comes to some type of cooperation or collaboration. It was just me emphasizing to them that I very much would still like to be in my son's life.
Is that what y'all took away from that letter? Because that's not really what I heard when I read that letter. She loves to, I say this all the time, she loves to get big and bold in these letters and then softens it when she's in court and she realizes how ridiculous it actually sounds if someone were to say those words out loud. So then she softens it and says, this was just me trying to show my heartfelt effort to be involved in my son's life and that my rules and ideas and thoughts and that they matter. Meanwhile, in the letter, y'all are...
I said, bitch, get the fuck out my face. Why are you in my face? Why are you recording me?
Why is she gonna take it?
Ain't you supposed to be security? Like, cause I don't give a fuck who you are. I don't give a fuck who you are. Security heavy. I said, that's a fucking lie. Fuck out of here. Just trying to get some money.
Who's trying to get some money?
She is.
I am his mother. I am a woman. I win. He's excluding me. He needs to do this. I want my son included. Even back then, she is trying to literally force him into a traumatic situation when she's going like, I wonder how he would think how you would treat me. Thinking like I'm trying to make you emotionally harm our child when he sees how you treat me. And I'm okay with that. Meanwhile, everyone else, Court, Brian's attorney, are like, let's leave the child out of this because he has nothing to do with this. It's just your sorry attitude that is holding everyone else up. And I'm going to try to hold back on my comments about that letter because I think I'm just going to clip that out and do a whole video on its own about that because I have so many thoughts on it. It was absolutely ridiculous. But yet again, she says, obscure, unfortunate incident. You are just a very disgusting human being every time you say that. These inaccurate, unnecessary modifications. The relief he is seeking could have been avoided until he decided to involve our son and my maternal rights again. One obscure, unfortunate incident. I'm sorry, what? It is so unredeemable and unconscionable that a killer would say that this is an obscure, unfortunate incident, as if this whole man's life means nothing, and you've done it time and time again. That's specific wording too. It's one thing if you do it once and it's already horrible enough, and maybe you change up the wording, you're still trying to downplay it, but it still sounds awful however you do deliver it. But to do the same exact wording means you stand 10 toes behind it. You are calling your murder, the murder that you committed, an obscure, just a random thing. It hasn't happened a lot. Unfortunate. Yes, it's awful. I get it. He's dead. Why do we have to keep talking about it? Incident. As though this wasn't a violent attack with a bat, forced confinement, and multiple assaults afterwards and up until the moment he died. Because we don't know if she ever stopped abusing him when she turned those cameras off.
That is my letter originally in answer to their modification of this final judgment, which we are in the process of debating. For also the parenting plan, which is still active, the original from 2018, I believe, I wanted to bring to the court's attention that it's been violated by the petitioner. Again, from previously, now I believe it's a time where it says the parenting plan may be modified or verified on a temporary basis when both parents agree in writing.
All right, Ms. Boone, Miss Boone, you have to agree that there's a lot that's not being followed with regard to that parenting plan.
Yeah.
Which includes even the time sharing that you're not able to do at this time.
Right.
You would agree with that, correct?
I just understand that, but that is my only stipulation. That's my only part
Okay.
that
All right,
I'm
you would
unable to
also
apply.
agree that that parenting plan was entered into back in 2018 prior to there being any criminal charges in your incarceration. Do you agree with that?
I do, Your Honor.
Yeah, double homicide.
But it
Okay,
was
and you
still
have
in
to also agree that when the parenting plan was entered into, if I remember correctly, you all agreed to the parenting plan as part of your mediated settlement agreement back in 2018. And at that time, neither one of you were contemplating any type of criminal charges.
Double homicide.
Or incarceration. Is that correct?
Bitch. No, I'm sorry.
Yes, Your Honor.
Yeah.
Okay. All right, you may continue.
Pause, cause not yet. Damn, the judge just went full lawyer on you and just cross-examined you because you would not stop going in a circle. Because after you keep floundering and floundering, you said, you know what? The way I'm going to wrap this up, I don't even know if this is wrapping up, but the way I'm going to tie this argument in the bow is I want to bring to the court's attention that the petitioner has violated the parenting plan. The one that everyone has violated at this point. That's why we're at trial, to create a completely new one and to figure out what we do with all the violations that have taken place. However, while Brian's side has accepted responsibility for anything that could be kind of shady and hasn't really shied away from anything, you have not taken responsibility for anything. You are saying that you are the perfect co-parent. You have done nothing wrong, and every single thing we hear is wrong, wrong, wrong. Abuse, 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 lie, lie, lie. The judge had to confront you and make you agree that you have also violated the parenting plan. And you go, well, yes, I understand that, but that's my only violation. We have gone through violation after violation that you have actually brought up yourself. We have all this information and most of it comes from you. It's because all she does is make admissions. When you said the parenting plan says that communication is supposed to be between the parents and not between the child. Well, if you don't answer my phone calls, then how else am I supposed to communicate with you other than through my child? What does that mean? I'm admitting to breaking the parenting plan. But I don't take responsibility because you forced me to do it. As long as she can blame George's death on himself and to say that he was a bad person so he deserved it, then she did nothing wrong, and why are people trying to treat her different because of it? I can tell already this judge is going to have a field day with her in this in this judge's order, because she has had it. And also what she doesn't know is that in Judge Jackson's background, unfortunately, her father was killed by her mother. I believe she shot him. So that is like a very foundational moment in her life and may have been the catalyst that got her involved in family law as a judge. So her trying to play this mother card, I'm a woman, he shouldn't treat me like this, how could you, this is so this is so that. Meanwhile, we see nothing but abusive and violent actions from you. I do not think it's going to read well with her. And I don't think that's going to bias her in one way or the other, but it's definitely not going to bias her in her favor. And that's what she has banked on all her life. She's banked on there's someone in the room who follows the social rules that she tries to manipulate and will take her side. You think she'd take the hint here? This is not going well. Maybe I should wrap it up or talk about something relevant. You know, the issues at hand.
So I would like to bring in the part of the divorce certificate, which includes each parent and everything they're supposed to abide by regarding being appropriate to the other parent, regardless of part incarceration or not. That's what I was trying to say. I've been excluded this entire time, and everyone has blamed my incarceration on it, which it shouldn't be like that because I'm still the mother of my son regardless of where I am. And what Petitioner has been saying and doing and not doing are unacceptable and to a certain extent unlawful, especially with the active parenting plan. It shouldn't be done anyway, with trying to hinder my relationship with my son. There's no reason for him to do that. And again, in conclusion, the continuation of his responses, I don't care. That's what I've done since I've been here. So do I bring case law up right now, or is that something I could?
All right, if you'd like to bring up case law, you can.
Okay, we have finally reached the case law section. I heard that this part was just a mess, so I just wanted to cut in here and say I think we finally finished with the major arguments, or the worst of it. I know this case law is about to be a mess, but in terms of like her just rambling incessantly, at least the case law is something that you can focus and hone in on. She has a goal of, I need to put in this case and misuse it and just prove how it doesn't apply to my situation whatsoever, but at least I could say I tried. Linda, you know what? You are absolutely right. We are past trying. Trying is no longer good enough. That'll get you some participation points in school. I'm sure you were great at getting your straight A's there.
I mean, I've always been a straight A student. I am an outstanding mother to my son. Okay. I excel at everything. I don't know what to do, how to do it, and I always know what to do and how to do it.
But here in this courtroom, we need to go past trying, and you need to make viable arguments, or you need to stop fighting this so much. You spent all these hours running around in circles, not making a clear, coherent point about anything, aside from he's making me feel bad, punish him. But not only did she submit the parenting plan certificates, or look, we completed this divorce class that said something, no parental alienation. Now I'm also submitting the divorce certificates, supposed to show how we do divorce. So I'm guessing there's 2 classes or 2 things they had to go through. Or maybe this is just the same thing and she looped back around and just had to talk about it again of, here are these certificates again. All you have to say is, we both took a class and we received certificates for doing that. You don't even have to say that. You can just say we both took a class. The judge is not going to be like, well, prove it. I'm not going to believe you actually took a class unless you submit the divorce certificates. It's such a weak argument to begin with. I don't understand why she spent so much time on it when it could have been 3 sentences. And the never-ending nerve to say, everyone's blaming my incarceration on this, and it shouldn't be like that. Because I'm still the mother of my son, regardless of where I am. And she said that before of like and nothing can ever change that. No modification or court order can ever change that. Again, giving an FU to the judge saying, I don't give a shit what you have to say here. I will never stop hounding my son to love me the way I want to force him into loving me, and to blame everyone else for whatever decisions I have to do to make that happen. These answers are wild, and this is exactly what judges hear when they hear, oh, we have finally reached the threshold of needing to cut as much contact with this parent as possible. And she always, she acknowledges the obvious of, in the interrogation, you're accusing me of this crime, you're accusing me, and a bunch of other things I'm being accused of. It's not fair that just because he has all this evidence that I beat the F out of him, it doesn't mean it was from me. Why are you guys automatically blaming it on me? And then ... Okay, yes, I did cause those injuries, and yes, I did do it intentionally, but I mean, I was just lying because I was afraid of getting arrested, meaning I lie when I'm afraid of losing things that I don't want to lose.
Because it makes it sound like, to me, like I'm being accused of something that was not intentional. I'm being accused of it. Mm-hmm. And a handful of other things that I'm being accused of. Okay. I'm not admitting anything about being intentional and I killed George. That's not the situation, but it's trying to be pinned on me.
Okay.
That was not my intent. but it's trying to be pinned on me. So however, or whatever it is I need to do in order for that to be proven, then I need to do so, which is why I'm trying to get my ducks in a row.
Can I tell you something before you call on whatever? I've been arrested before because I fought back. I did my best. So whatever he has or whatever it is, it's not me.
See, this is what happens. It's not fair that you guys, just because he has those, automatically blame it on me. Y'all are making me out to be a person that I'm not. Or will I ever be. It's both of us. It's both of us. And it's not fair that you all are assuming that the marks that he has on him are from me.
We asked you where they came from.
I have no idea.
Well, nobody else was there, so nobody else was there.
I have no idea. I swear I did not lay a hand on him.
Okay. You just zipped them in the back.
Nor he.
You made those injuries.
I did.
We've seen the photographs.
Yes.
We see the bruising. Is that from that bat?
Yes. Yes, I kind of pushed, like I held it with the skinny part here, and then I started with his hand, and his hand, he was still trying to get out. He was still trying to do that. So I started to push on the suitcase around it, hoping to have his hand retract and go back inside.
I swear I did not lay a hand on him.
Okay. You just zipped them in the back.
Nor he. What do I need to plan on? I promise you, on my son's life, it was not intentional. I promise you, on his life, it was not intentional.
I mean, you're promising on your son's life, that's fine.
That's how much it means.
Sorry.
That's how much it, look, that's how much it means. I hope you take that to heart. Please.
I lied to the police. Basically everyone, because...
Like I was telling her, like, yeah, that's bad. Like, which I swore on my son's life was not intentional.
I was extremely fearful of being arrested. I made the first attempt of me calling 911 by telling them what happened, and I thought they were going to help me, but instead I was arrested for calling 911.
So you made a decision to lie.
I did.
Did you stay with that lie?
I did.
Are you telling the truth today?
I am.
So that's why I'm trying to figure out what I need to do for myself.
Okay.
So obviously I'm going to lie my ass off in this family court trial to get as much punishment to everyone else and to get me as many things as I want. Can you just imagine if the roles were reversed? If Brian were in prison after killing his girlfriend and is demanding all of this, demanding that Sarah pay for his livelihood inside just because somehow, Sarah won the lottery and now he's getting spousal support and making her da-da-da-da. She would lose her mind at the idea of the father making those arguments. But because she is the mother, her son's first love, the one who brought him into this world, that means she gets special privileges that the other parent doesn't. And that means no matter what I do, you can't get away from me. Those are my God-given mom rights. It shouldn't be like that. It absolutely should, because then people like you would get away with it and there would just be a never-ending pile of victims. You've already left plenty in your wake, but that's why we have the court systems to finally stop you from inflicting more pain and suffering onto others. You wanted to say, George, all George caused you is heartache and pain. Heartache and pain is all you cause me.
You do everything to me all the time. All the time. Heartache and pain is what you cause me. Heartache and pain. How is that? Keep going. And I dare you. I dare you. I dare you. Get away from me. I'm gonna fucking hurt you.
I swear
there. I did not lay a hand on him. I'm gonna fucking hurt you.
That is all you cause anyone. You spread as much heartache and pain around you so that everyone else feels in your mind a fraction of how you're feeling on the inside. And because they made you feel that way on the inside, it's okay that you're trying your hardest to make them feel that way in return. And the nerve to say, and this is just unacceptable, everything he's done, and to a certain extent unlawful, seeing how this is the active parenting plan. The woman in prison for life for murdering someone wants to talk about someone committing something unlawful. Oh wait, I thought that criminal actions had nothing to do with family law, so why are we bringing that up? It shouldn't matter. Let's just say he did break the law. According to you, that shouldn't matter to this whatsoever. So why are you bringing it up? Because she wishes more than anything that Brian was the actual criminal, because that just fits her narrative that she's had all her life. And the fact that she's finally been shown a mirror of herself that she has tried to look away from for so many years, she's shocked that we see the reflection she doesn't want to see. That's right, Linda. I ate with that one just a little bit. I had a little nibble.
Security heavy.
But keeping it going, if she actually looked at that reflection, took it in, tried to make corrections to herself, tried to be self-aware and look at what everyone else is seeing, then maybe people would want the best for you. But they can't want that yet because you're not there. She is one of those people who has to hit her absolute rock bottom before even getting a spark of intuition as to her own role in all of her issues. And how does she wrap up her best arguments? The reason she's here for the proposed parenting plan, the alimony, attorney's fees, child support, all of those things. She says, in conclusion, all I've gotten in this whole thing from Brian is, I don't care. She is hurt so much at that. She really can't stand that people don't care for her. And I get it. That's hard to hear. And I get it. That would be painful for anyone. However, you can't just ignore all of the ceaseless actions you've taken. You have never once backed down, let up off the pedal. It has been full force since the moment you were put in those pink cuffs. You have thought that you still are entitled to everything, and anyone who tries to take anything away from you is abusive, wrong, unlawful, and should be sanctioned. They're the real killers in your mind, because they're trying to take your livelihood away and make you feel this and make you feel that. Who cares? We have gotten to that point of you can feel however you feel, and you need to feel that way. If you feel bad and think people are punishing you for your actions, it's because they're punishing you for your actions.
Okay. So, I'm looking. Excuse me, thank you for your patience. Children. Okay. In regards to children and the parenting plan, Hunter versus Hunter, the court ruled that incarceration in and of itself is insufficient to terminate or deny custodial rights unless continued contact is shown harmful or detrimental to the child.
All right, give me the case name again.
Hunter v. Hunter.
All right, do you have a case citation?
Yes, Your Honor.
The number, okay, give that to me.
540 F as in Sam, O, 2, D as in dog, 235, in parentheses, SLA, 3, D as in dog, DTA, 1989, in parentheses.
189.
Yes, 1989.
All right, you may continue.
Thank you, Your Honor. Also for that case law, the court has discretion to restrict visitation only to protect the child. The petitioner penalizes the respondent for her incarceration. Also, it reinforces that inability to communicate, not incarceration, is the key benchmark for limiting shared parenting. I have multiple ways of trying to communicate with my son. And I've been trying every single one and trying to share parenting as best as I possibly can while located here. In fact versus fact.
I'm sorry, were you done or are you looking for your next topic?
Forgive me. I was reading another case law to you.
All right, I have the Hunter case. I've gotten that. Do you have another case?
Yes, I do, Your Honor.
All right.
Please.
All right, hold on, give me just 1 minute.
Thank you for your patience.
All right, your next case?
Ogilvy, O-G-I-L-V as in Victor, I-E.
All right, just give me the citation for now.
Forgive me. 2007 SL 2D DCA. Ogilvy versus Ogilvy.
All right, you may have to give me the spelling of the name again. Go ahead. O-G.
I-L-V-I-E.
V as in Victor?
Yes, Your Honor. This holds
Right.
that...
Jennifer, hold on. Jennifer Ogilvy versus Dale Dean Ogilvy?
I don't have their first names, Your Honor. I just have Ogilvy versus Ogilvy.
All right, well, the case citation you gave me is not a formal case citation, so I have to figure out if I have the right case here.
If I may,
All right, go ahead and tell me your position on what you believe the case states.
It holds that parental alienation tactics, like disparaging the other parent or withholding visits, constitute interference and harm for the child. I have limited resources at the law library, so forgive me.
No, you're fine. I just need to make sure that I have the right case, and I believe I do.
And then I have another one after that that has the same type of...
Give me just a minute. All right, counsel, for the record, the court has found the Ogilvy case that I believe she is referring to, which is 954 Southern 2nd 698.
Yeah, I got it here too.
Which is a first DCA opinion in 2007. All right, your next case.
Logria, it's L-O-G-R-E-I-R-A versus Logria. I don't know if I'm saying that name right. Sorry.
All right, is that 322 Southern 3rd 155? Do you have that?
All I have, Your Honor, is 2021 3rd DCA.
All right, for counsel, I have that as 322 Southern 3rd 155, Florida 3rd DCA, June 2nd of 2021.
Got it. Thank you.
I'm sorry.
No, you're doing fine. We just have to locate it based on what you're saying, and I just want to make sure that I have the correct case, okay?
Thank you.
So give me just a minute. I believe I found it, and I just need to make sure that I give counsel the citation that I'm looking at. So that's why it's taken a little bit of time, just so that he's on the same page, that he's looking at the same thing the court is looking at.
Yes, Your Honor. Thank you.
All right, and why do you want the court to consider this Lagrera case?
Any restriction must be court-ordered, based on evidence and accompanied by a fair hearing. Unilateral actions are ineffective and wrongful. It also emphasizes the need for due process before suspending parenting time. I have 2 more after that, and I'm complete with it.
All right, give me just a minute. All right, the next case you have?
Thank you. Perez, T-E-R-E-Z versus Perez. And I have a citing.
Okay, give me the citation.
769 SO2D 389 parentheses FLA 3D DCA 2000 in parentheses.
All right, that was 760.
No, 769.
760. All right.
Did you
For
need
counsel,
the
the
summary
court,
part?
hold on a minute, ma'am, hold on. For counsel, the court has found the Deborah Perez versus Jorge M. Perez case at 769 Southern 2nd, 389, Florida 3rd DCA, 1999.
I found it.
Hold on 1 minute, ma'am. All right, why do you want the court to consider the Perez case?
Because this underscores that restrictions on parenting time must serve the child's best interest, not a parent's convenience, retaliation, or preference. Also, courts require proper legal process and evidence, not unilateral action to alter the parenting plan's time sharing term, regardless of where the parents are located.
Hold on just 1 minute. All right, you may continue.
Yes, please. If I could please add 1 more. I have 2 more and then I'm complete.
All right, go ahead.
Thank you. It's just stated as in regard to adoption of children by LAS, and the citation is 650, capital A is in apple, 2D, 214, in parentheses, 1994.
All right, that was 650A2D202.
214.
Also, if you had
I couldn't find it.
we cannot find that case.
Yes, please, if I could put a substitution in.
If you can do what?
May I substitute one for that? I have another one in place of.
Okay.
If I could just give you the citation.
Yes, that's fine.
It's 996 SO2D 930 parentheses FLA 2D DCA 2008 in parentheses.
Counsel, the court has found RE versus Department of Children and Families at 996 Southern 2nd, 929, Florida 4th DCA opinion from 2008.
Got it.
All right, and why do you want the court to consider this case?
Thank you, Your Honor. The court found that incarceration alone is not grounds for termination of parental rights, and they still have the right to raise, contact, and participate in their child's life unless proven unfit on other grounds. And one more.
Before you continue, hold on, before you continue, I have not heard any arguments or evidence that anybody's trying to terminate your rights. That's my understanding. That's not what's happening here. Is that correct?
Yeah, this is not a TPR proceeding. Yeah.
Got it. All right.
Hello?
All right. You said you have another case? All right, just actually hold on. Before you go, Ms. Boone, I don't know if you heard the court wanted clarification from counsel for petitioner based on everything that I've read and the testimony that I've heard here today, this is not an action to terminate your parental rights. Counsel confirmed for me that that is not what petitioner is seeking in this case. Okay, now you can go ahead with your next case.
Yes, please. If I may comment on that, it is in regards to me speaking to my son one day a week for 30 minutes, and that's what I'm trying to
terminate. I understand that, ma'am. What I'm saying to you is the case, and the court does understand, and there is a distinction between terminating parental rights and requesting a specific parental responsibility. So, you know, this case is not about terminating your parental rights. And the court is not considering a request to terminate your parental rights. But you can continue with your next case.
Okay. I'm just trying to clarify what my parental rights are.
No, you're not. You're trying to force your own definition of what you think your parental rights are. You're not trying to seek clarification whatsoever. You are mad that you don't get 8,000 phone calls a week. You're mad that Brian is proposing you have one phone call a week and you can't take it. Your eyes have just seen red ever since. So him limiting you to one phone call, even though he's going to have one in-person visit monthly, is him terminating your rights, getting rid of all of your rights. You can't use this all or nothing big, huge language in the court system. Words mean things. So when you say your rights are being terminated, they have to respond with, no, they aren't. And then you freak out saying, yes, they are, because I deserve unfettered access even though I'm locked behind bars for the rest of my life. That still shouldn't prevent me from having all the access in the world to him. And if you try to limit that in any way, then you have terminated all of her rights. This type of language does not work in courts. And I'm trying to let it play out as much as it can because this is just cringe. And I cut out a lot of dead air in between these things. It's like the spelling bee from hell, hearing just letters, numbers coming out of this loudspeaker. I can only imagine what it was like in that courtroom. Nightmare fuel. And it's like, I get she's over the phone, but she's also over projecting way more than she knows she needs to. But she wants to overemphasize, I'm over the phone, so I need to make sure you hear me. And that reminded me of in Volume 4 text messages when she was mad because she didn't have access to the break room because they put her in a small closet next to the break room. And she said, they yelled at me because it's so loud and everything echoes. Long story short, she's basically screaming in that small closet in order for them in the next room to hear her, since it was a very thick glass by her self-description. So if you make her upset and you do something she doesn't like, then she's going to make sure you know about it, and she's going to make sure it's your problem too. Because once you fix all of her problems, she'll stop being a problem for you, which is the rhetoric she has used against Brian for years. If you just paid me all my money and did absolutely everything I said, I wouldn't be hounding you, would I? Your relief would be sought if you just did what I said. Translation, I'm an abuser who will beat you down until you give me what I want. And then we'll be shocked when they take that away. And I've let these cases play out because half of this sounds just like some ChatGPT mess. Like, the fact that they are struggling this hard to find these cases is embarrassing. And it's like you just took sound bites from the cases. It just shows that you didn't actually read the opinions, that you were just looking for sentences. And that one sentence, what was it, I think it was the Hunter case or something, the saying disparaging comments constitutes harm to the child and this and that. Basically everything she's been saying verbatim that is hyper specific to her situation. Of course, that case covered that specific topic using that specific phrasing that just so happens to be the phrasing she's been using this entire time. And also, we can't seem to find the case. And then when she finally does get cases in there, they're for the most basic and blandest points ever that no one's fighting you on. Incarceration alone does not automatically terminate parental rights. Got it. No one's trying to terminate them. Won't stop you from continuing to say that. And then all these other cases are very minimal points that don't actually lend itself to her situation whatsoever, and only unravels that. She's given so many cases that goes against her own arguments. Every time she says, this can only be limited in the best interest of the child. Yes. It has been documented and testified to, and evidence have been shown that you are detrimental to that child's well-being when you have no limits. And you have no proof to the contrary. You keep doing this second person hearsay of, he apologizes to me all the time. He says his father's this, he says his father's that. You're just using him in reverse. You're saying he talks disparagingly about his father to you all the time. That just so happens to be something that you remembered so that you can use it in these hearings as a weapon. And it just so happens that your son's not here to corroborate any of this. But you're going to say that you wish he was here so that he could confirm all of the lies she's been pushing because she thinks she has such a manipulative stranglehold over him. And when they're in one-on-one conversations, he may be more passive and gives in to the antics of just, this is me getting through the phone call. And Sarah, because she's done this with everyone, she thinks she's actually good at manipulating people, which then backfires on her every single time.
See, and then it's all backfired on me. Like, it's all backfired on me. And I understand the severity of this.
You did.
It's awful, I know.
Okay.
It's awful. And I will tell you both this right now, too.
So she would be absolutely befuddled and shocked if the son got on the stand, which she would have forced him to do in order for him to be involved, forcing the child to be sworn under oath to give testimony just so that you feel better and make a few points, still not supporting your argument of why you need alimony and shared parental responsibility. Brian argues that you make terrible decisions, and that would be a terrible decision. Brian says you didn't want to get your child vaccinated. That's another terrible decision. You just have a track record. You leave people in suitcases thinking they're going to survive. You zip your son in a suitcase thinking there's nothing wrong with it, so much so that you post about it on Facebook, and it's so funny to you that other concerned parents had to actually call CPS on your ass. It's a never-ending string of terrible decisions. It's just the confidence that she says all of her ludicrous claims is so conflicting to all the evidence that surrounds her, that it's almost impressive and makes you second guess, well, am I being too critical? Am I the crazy one? No, this is absolutely absurd. Someone who killed someone and has been convicted to a lifetime sentence in prison for said murder has no right, room, or space to make any of these demands. This is a mess. Yeah, I'm going to keep trying to let it play as much as I can because this case law debacle is a nightmare.
Speck v. Speck, S-P-E-C-K. The citation is 225 SO 3D 319 parentheses FLA 3D DCA 2017.
So it's Brown versus State.
Speck v. Speck.
Okay, I need a citation one more time. I'm sorry.
Sure. 225 SO 3D 319 parentheses FLA 3D
All right, the court is not finding a Feck versus Feck case. That is a citation for Brown versus State, which is a 2017 opinion regarding waiver of appeal arguments dealing with a sentencing order.
Okay, one moment, please, if I may. I'm looking through really quick. Okay. I'm just trying to locate. Okay, Your Honor, forgive me, that's what I have for that one.
I'm sorry?
Okay, that's the 225, that's what I have for that, which apparently is
All right.
not right.
All right, any additional cases?
No, Your Honor.
All right,
For
all
that, no.
right. Any additional evidence you want the court to consider?
In regard to the parenting plan,
In regards to any of the issues that we're here on today that I have recited over and over, I think I might be on time number 7 now.
Yeah, double homicide.
in regard to alimony, I would like please to add case law.
Oh, Lord. Again.
No, God!
A fucking again. Nothing new, nothing
God,
changed,
please,
same old
no,
shit.
no,
Same old fucking shit.
No! No!
Okay.
Florida statute 61.14, I believe.
All right, repeat it for me, I'm sorry.
Just one moment, I'm trying to make sure that I have everything pulled up. Okay, I'm going to start, please. Would you like to have the citation?
Yes.
39 SO 3D 453 SLA 2D DCA 2010.
All right, is that Malik versus Malik?
Grigsby versus Grigsby.
Say the citation for me once again.
39 SO 3D 453
Okay, now say the name of the case for me.
Grigsby, Grigsby.
Got it.
Not have to do with alimony.
All right, the court has found Grisby versus Grisby at 39 Southern 3rd 453, which is a second DCA case from 2010 dealing with the issues on sole parental responsibility, reestablishing time sharing.
This, I believe, was in regards to alimony.
It is not regarding alimony. All right, give me just a minute. We're going to have to go off the record for just a minute. We're going to take like a 3 to 5 minute break.
Okay.
My laptop, because something happened about 4 or 5 months ago, it only charges with a specific charger. And so my computer is telling me it's about to die. So my judicial assistant is running up to grab a charger that's actually going to charge my laptop so it doesn't die. Okay?
No problem.
And I do apologize for that. But meanwhile, I am going to make sure I save my notes so that they don't disappear. If my computer should all of a sudden go completely out.
This is just so funny to me because just this is another instance where someone's laptop or someone's recording device has gone out when working with Sarah. She just can't catch a break when it comes to losing lawyers or when it comes to faulty technology that once they come back, it just buries her.
No, I don't remember that.
For everything you've done to me. For everything you've done to me.
Your battery's about to die.
Shut it down.
Oh, okay.
This is because it did technically stop and I wasn't able to say the time that it stopped prior. We have not talked anything further, not on recording.
Correct.
Okay. And you do understand that you don't have to speak with me if you don't want to, correct?
Yes.
Okay, perfect.
Ms. Boone?
Yes, Your Honor, I'm here.
Okay, all right. I don't know if you were able to hear me earlier. Just so you know what's happening in the courtroom, I am in a different courtroom today. And even though my laptop has been plugged in to allow me to see on a separate screen, it was not charging due to an issue with my laptop that happened about 3 or 4 months ago. So now we have a charger for my laptop. I am back up and I am ready to take your next case citation regarding alimony.
Yes, Your Honor, thank you very much. My next is Bowen, Bowen versus Bowen. And the citation 471 SO 2D 1274 SLA 1985.
All right, give me the number after the 2D.
1274.
Got it.
Parentheses.
Okay.
Okay.
All right, for counsel, I have the Bowen versus Bowen case, 471 Southern 2nd, 1214, Florida Supreme Court, 1985.
I've got it. Thank you.
All right, go ahead, Ms. Boone.
Arrearages and alimony are vested rights and enforceable. While the court-ordered alimony period has now ended, the expiration of that period does not erase arrears that accrued while the order was active. Florida law is clear that past due alimony becomes a vested right, and the obligor remains responsible for payment regardless of whether the alimony term has since expired.
All right, anything else?
Yes, I have, the citation is 418 SO2B 1113. It's Florida 5th DPA 1982.
What's the case name?
Lamb versus Lamb.
All right, that was 418.
SO2D 1113.
All right, 418 Southern 2nd 213.
2D 1113. So 1113.
I'm not seeing that one. That site.
All right, give me the full site. Start with the first numbers again.
418.
418 SO2D
1113.
213.
in parentheses, Florida, 5th, 5th, DCA,
The court does not
1982.
find the Lamb case at this citation. 418 Southern 2nd, or do you say 2D or 3D?
2.
All right, that is not a citation for a case named Lamb.
Oh,
All right, and I need you. How many more of these you have? We were down in 15 minutes, and I got to give counsel an opportunity to question you, and then save time for closing arguments.
I'm not sure. That's why being on the phone is very difficult. I'm sorry. I'm doing everything that I possibly can to properly represent myself.
Cute rehearsed line, but no, you aren't. You're doing your best to cause as much of a commotion as possible, trying to restate the same exact point 10 million times without ever making any ground, and just trying to find new ways to point the finger and put the blame on someone else. It's not my fault. It's the correctional facility, the clerk's office. They told me to lie on my financial affidavit. It's not my fault. It's Brian who forces me to use my son as a pawn. It's not my fault. I have to abuse the court system because they won't force my former husband, to pay money to me despite the fact I'm in prison. It's George's family's fault because they didn't stop him. It's George's fault because he died on her. It's everyone else's fault but hers. And it comes through in every single conversation or point she tries to make. Because now when the time has run down, she wants to point the finger. It's the telephone's fault. As though I'm just going to imagine there is a clock in the room that she's in. And if there isn't, maybe there's one on the phone. I just don't believe that there isn't. She could have managed her time better. She chose to go round and round and round and said, did you include me? Why are you only giving me a 1 30-minute phone call? Don't forget my arrearages. I want to be in my son's life. This is unfair. I shouldn't have to prove my worthiness. The petitioner is so evil and wrong, and this would all be fixed if he had just paid, or if he had just mediated, or if he had just had the meeting of attorneys and unrepresented parties. It's always something. And then has the audacity to say that everyone else points the finger at her when it's just, I don't know. But this is her doing the best she can to properly represent herself, meaning I'm going to ceaselessly argue until you cut me off and I'm dragged out of the courtroom by my uniform while still trying to speak. Then I can say I represented myself properly. And if you don't side with me, it means you weren't listening. Unfortunately, we've been listening this whole time and you have said jack shit nothing. Truly, now reflecting back, she hasn't made a single argument for why she should have all of these things. She has only made arguments of complaint, asking for things, asking for punishments, and her only defense is that it was court ordered in 2018 when she was not contemplating any criminal charges, which I will push against that because that was the time she was arrested for a 3rd-degree felony strangulation.
Hands behind your back.
For what?
For battery domestic?
Me?
Both of you. You two hitting each other.
Is this for real?
This is for real.
Why am I in trouble though?
Because of
Why
the
am
marks
I in
he has all on his neck and the inconsistencies
That's
of
me
the story.
fighting back. Why? Because I fucking fought back?
And Brian had to bail her out. So, I don't know how far along they were in this when they were agreeing to the settlement, but the warning signs were clear up front, and she lived up to everyone's fears and expectations.
They're gonna think I killed him.
Why would they think that?
They always have said that. They've always have said that.
Everyone fears that she was a bad influence on her child and the way that she neglected him and then love bombed him, and then that never-ending pendulum cycle of forcing your child to self-regulate you. as well as forcing George to self-regulate you and to self-fund you, also while abusing, berating, letting all of your internal anxieties and all your internal inadequacies, letting them loose on him to where he couldn't do anything right. He was always the abuser, thus you were always justified in doing anything you wanted to him at any moment. All of this to say, I am definitely rambling, but just no. Please, just stop. Stop this. Put an end to your suffering. None of this will help you.
Lamb is not Bowen, Burger Bowen. Tindall, Tindall.
All right, give me the citation.
It's not on here, forgive me. They did give it to me.
They? Who's they? They didn't give it to you? Another person to blame? Would this be one of your contributors that doesn't exist? Whoever typed up your pretrial statement? Dang. Can't take responsibility for anything. I hope y'all heard that. All your hard work, y'all didn't give it to her. Then maybe you should only cite cases you've actually read. Could avoid a lot of whatever this is. Because also, like, even the cases you do cite that are accurate, as in they actually exist, not necessarily that they apply to this situation, those don't really matter less and less every single time you have been found to give a fake citation or an inaccurate citation, because it's like, oh, okay, you obviously just searched for anything you wanted to throw in there. Again, you don't take this process super seriously and want it to overwhelm with the number of cases and not the quality of the cases. But I digress.
All right, without a citation, the court cannot find a next case.
I'm sorry, my classifications department is speaking to me. Hold on one moment, please. I'm sorry.
Hello, excuse me. Your Honor.
Oh no, this is so cringe. Not the security guard or the prison guard, whoever, barging in. You're not sworn in, you're not anything. Why are you here? Yikes, this is not going to end well.
Hello, Your Honor.
Yes.
This is Classification Officer Santiago. I work at Lowell Correctional Institution. Due to our procedural operations over here, she's going to need to be off the phone at 4:50 in 5 minutes. And I just thought that I would come on here and let you know.
Your Honor,
And
may
then- And then
Okay.
also, for future court appearances, they are requesting that communications go through the classification officer so that we can make sure that she has plenty of time to complete all of this so that we're not having to rush her off the phone.
That's probably the dumbest thing you could have said. They're in trial right now, and you are saying, and can you make sure next time that you contact us? Girl, if you don't go sit down somewhere, no. Not trying to get set. This is a literal trial. Your procedures can hold off for half a second. Yikes. But this is what happens. Sarah has wasted so much time. So much unnecessary time. Wow.
Right. Information was sent regarding this final hearing.
Mm-hmm.
And we, my office has been in contact with the Department of Corrections for quite some time over the last couple of months trying to get this set up, because we had initially requested that she be transported to Orlando for this hearing.
Oh, so they wanted to have her there in person the whole time. So she causing this big stink and blaming the court for not doing so was actually because the prison did not want to ship her ass over here. Nice.
So there has
Right,
been contact. All right, but right now you are slowing us down and trying to get this finished. So give me just a minute. Hold on. Yes, counsel.
Your Honor, what I would suggest, I have no other questions for Ms. Boone. So what I would
suggest is that perhaps the court allow both me and Ms. Boone to have a certain amount of days, not a super long amount of days, but a certain amount of days to provide written closing arguments to the court, and then the court can take the case under advisement and make a ruling, so we can get this done today.
All right. All right, so what the court is going to do is we're going to go ahead and finish up, I believe. Other than case law, Ms. Boone, did you have any other evidence that you wanted the court to consider?
Yes, I did. I had some other exhibits that I would like to have put into my evidence, and then I also was supposed to speak about the attorney's fees.
Then why didn't you do that? You have been sitting here for hours and hours and hours saying, I don't want one 30-minute phone call. I have so much to offer. I am my son's only mother. Brian doesn't include me. He says he doesn't care. He's so mean. I need my money, this and that. You have had nothing but hours to get through stuff. And now that you're about to get dragged out of the courtroom by your uniform while still trying to speak.
Said order being ordered and me being pulled by my uniform to exit your courtroom while still trying to speak. She was pulled from the courtroom by her uniform.
Now you can rattle off exactly what you need to talk about. Well, I had all these exhibits to get in, and then I had to talk about attorney's fees. You already talked about it. Is having an attorney a choice? You would have just said the same thing again and again. But now you have urgency. Now you want things to go in. Of course you do.
I've given you lots of time to speak about all the issues. The fact that you didn't take that opportunity instead of going into other issues is not what the court is going to address now. What specific exhibits do you would like to move into evidence?
Your Honor, forgive me, but I'm here on the phone trying to do all of this.
When I ask you what other exhibits that you want to put into evidence.
Yeah. Double homicide.
Oh, Miss Jackson has had it. Wow, that is incredible. Because that's what she does. She always tries to, well, it's not my fault, it's this. Well, excuse me, I'm on the telephone. Excuse me. Tell me if you have any other useless exhibits to enter. Let's speak now or forever hold your peace. But here's the thing. Sarah always backs down to women. So as soon as a woman pipes up with her, she gets real submissive and moves right along. Yeah, it can't be any clearer how bad you lost this.
My number 10, respondent's correspondence. I'm sorry, number 9, respondent. Motion for contempt.
All right, I'm not considering a motion for contempt with regard to a final hearing. Okay? Anything else?
It was my understanding it was held in continuance until this actual moment, which is why it's been waiting to be heard.
I think she's referencing, Your Honor, the motion for contempt on the non-payment of alimony, not the most recent motion for contempt that she filed.
Okay.
Yes, yeah. This was done,
the court will take judicial notice that you have filed a motion for contempt with regard to the alimony. Okay? And that is something that that is something that I am considering because I've got to deal with what the alimony that was not paid, okay?
Yes, Your Honor.
All right, so with that clarification from counsel, I will take judicial notice of your motion for contempt with regard to the alimony.
Okay. And then also the petitioner's account statements, which is my number 15.
Counsel, this looks like Truist bank statements.
Okay. We gave it to us in discovery. Yeah. No objection, Your Honor.
All right, hearing no objection, I will receive into evidence what was pre-marked as 15 as Respondent's Exhibit number 6.
Yes, Your Honor. And then number 21 through 25. Respondents.
Correspondence to judge regarding non-payment of alimony, parental alienation, and requests for case management conferences.
Very good. All right. These are filings within the court. The court does not need to receive this as evidence.
Okay, if I may ask for judicial notice.
All right, the court will take judicial notice of documents that were filed on October 18th, 2022. January 31st, 2023.
There should be 5.
February 22nd, 2023. I do not see a filing date with regard to number 21.
They should be 2022 through 2023.
For the record, counsel, Exhibit 20 is a notice of filing prepared by yourself. Looks like, again, filing some documents that you received. I think, oh no, this is notice for trial for 20. All right.
I'm going through it as well.
All right, so also court's going to take judicial notice of the notice for trial filed on, August 17th.
That's not part of my evidence. You may have gone one too far.
You just told me 21 through 23. All right, so that's 20, so we don't need that one. All right.
21 is respondent. 22 is
All right.
respondent.
Exhibit number 24 is not indicating that I don't see anything on it that it was filed with the court, but it is a.
It was probably cut off from the copies that I had to obtain.
All right, the court does not need to take judicial notice of a request for case management conference, so the court will not take judicial notice. Anything else?
It's trying to show my exclusion in the case.
Oh my gosh, move on. Like literally, this has literally given me a migraine, so I'm sorry I'm running out of commentary because I can't even think straight anymore. This is insane. All of these points are useless. She's made them before and they fell flat. This is my exclusion in the case. So how is a request for a case management showing? It's all self-serving hearsay. They've said it a million times. Self-serving hearsay is when you are trying to use out-of-court statements and use them as though they are facts that were testified to in court. You don't need to show letters that you sent because you can just testify to it. And that testimony outweighs any written document you could provide that says those words that you testified to. Oh my goodness. Well, I hope we're almost done.
The court has ruled I am not taking judicial notice of a request for a case management conference. Anything else?
Number 27, 28, and 29.
All right, 27, it looks like it's a letter dated March 2nd of 2023 to Attorney Martell. Any objection to this?
If it's a letter to me, it's self-serving hearsay, so I would object.
All right, I'm going to sustain the objection as to exhibit number 27. I have a November 26, 2024 letter addressed to Attorney Joshua Martell as exhibit 28. Any objection?
Same objection, Your Honor.
Sustained. Number 29. Appears to be handwritten letter to Brian dated May 12th of 2024. Marked as exhibit number 29.
Same objection, Your Honor.
All right, sustained. All right, anything else?
Number 31. Respondents, witnesses. letter.
So letter to whom it may concern.
These are my character witness letters.
Character witness letters? What do you mean? This isn't criminal court. You're not at sentencing and you have character witness letters where they are trying to say, hey, don't give her life in prison because she's actually not that terrible of a person. You think there are character witness letters for you getting alimony and having more than 30-minute phone call with your son? Oh my goodness. The plot has been completely missed here.
It's your what letter? I'm sorry.
Character witness letters.
Objection hearsay.
And next.
Number 32.
Number 32. Current judgment interest rates.
Those are in regards to alimony arrears.
If it's just reciting the statutory interest rates, no objection, Your Honor.
You review the document.
Let me see.
You object or you don't. Deputy, you could hand him this.
I haven't seen any of these exhibits, Your Honor. My apologies. No objection.
All right, hearing no objection, I receive into evidence what was pre-marked as 32 as respondent's exhibit number 7. All right. Anything else?
Number 35 and number 37. They're telling me I have to go.
All right. Number 35. You can approach counsel.
Okay, thank you.
Looks like something dealing with the canteen.
It's the canteen items with current pricing. That's for snacks for medical reasons.
Security heavy.
That's for snacks for medical reasons.
All right, hearing no objection, I receive into evidence what was marked as number 35 as number 8 and what was marked as number 37 as respondent's number 9.
The JK communication features and current pricing.
All right, next.
The number 37, which is JK communication features.
We already admitted that into evidence as exhibit number 9. Next.
Okay. And you have the GCL communication?
Oh my gosh, will you ever stop? I literally had to go lay down to finish this video. I've had to relax myself as much as possible just to make it through. They have all of the whatever communication prices that don't make any lick a difference. You had nothing but time to introduce all of these things, and you decided to hurl insults and accusations instead of literally introducing the evidence that the judge is going to consider.
I have no idea what that is. If you next piece of evidence that you want to, next exhibit that you want to admit into evidence. Anything else?
I think we're missing one because I'm going to put in the JK communication. I put in the GCL communication, but not the JK.
We have number 35 admitted into evidence as number 8. Number 37 admitted into evidence as number 9. Next.
Number 36.
I can look at this, Your Honor.
You can stay up. All right, we're receiving into evidence what was pre-marked as 36 as respondent's exhibit number 10. Which is also
Yes,
a J letter. Next.
That's all I have for right now, Your Honor. I'm being rushed out.
All right, I'm going to give you all until next Monday at 5. I'm going to say by 5 p.m. That includes, Ms. Boone, you need to put it in the mail by next Monday, a written closing argument on the issues we're here on today. Okay? So I'm going to give you all until 1 week to provide written closing arguments, no more than 5 pages.
No more than 5 pages?
That is correct.
Parenting plan, alimony, attorney's fees.
Counsel.
Can I submit real quick 2 exhibits before we end?
All right, what are they?
I just have, these are more for demonstrative purposes, but I have my proposed child support guidelines worksheet that was marked for identification purposes as petitioner's B, and then my case law, which is in hard copy form marked for identification purposes as Exhibit C. This is all
Or what was the child support guidelines? What was it pre-marked as?
B.
B as in boy, and then the case law as C.
C.
All right. Ms. Boone, do you have any objection to what was pre-marked as petitioner's Exhibit B or C, the child support guidelines or case law?
No, if someone explains it to me though, if we have a chance to, I don't understand it.
All right, hearing no objection, I'll receive into evidence what was pre-marked as B as petitioner's number 4 and what was pre-marked as C as petitioner's number 5.
Please, if I may, before we hang up, the closing arguments are for parenting plan, alimony, attorney's fees, and...
I am not repeating myself, ma'am. You need to make a closing statement. You need to put it in the mail to me no later than next Monday, which I believe, actually, that's a holiday. So I'm going to give you all till Tuesday, which is September 2nd. I will not accept anything that is postmarked beyond September 2nd. Again, this is closing arguments on the issues we're here on in trial today. No more than 5 pages. Thank you and have a great day.
And that was the family court trial, a culmination of 5 years in the making, and it went just as chaotically as we thought it would. Actually, I thought it would be more tame. I didn't think it could be just as insane as her criminal trial. But we got a taste of how the artist formerly known as Miss Boone Esquire handles the courtroom, and if she was forced to go pro se for her criminal court case, we saw just a little glimpse of how disastrous that truly would have been. As of this moment, I'm not sure if Sarah submitted her closing arguments. Brian did. I wanted to do some commentary on it. I don't have the mental fortitude after this. She has beaten me down. Or no, just doing this whole process has. But I did read it, so I'm just going to insert the closing arguments here, and then when we do a verdict video, I'll probably have my reaction to it there. All right, petitioner's written closing argument. Petitioner Brian C. Boone, former husband, respectfully submits this closing argument in support of his petition to modify the parenting and support orders and in opposition to the respondent's requests, states as follows. 1. The evidence at trial and applicable law overwhelmingly support granting the relief Mr. Boone seeks for the benefit of the party's minor child. 2. Since the respondent's former wife incarceration in February 2020, Mr. Boone has single-handedly provided a loving, stable home for the child, covering all financial, emotional, and logistical needs without any contribution from the former wife. In contrast, the former wife, now a convicted murderer serving life in prison without parole, has been completely unable to care for or support the child, having had no overnight contact since her arrest in 2020. 3. At trial, the former wife stipulated that Mr. Boone could relocate the child to blank Florida. However, she did not agree to Mr. Boone's proposed parenting plan that provided for sole parental responsibility for Mr. Boone, 1 monthly visit with the child and the former wife, and 1 weekly phone call between the former wife and the minor child. 4. The former wife has shown no genuine accountability or remorse for the actions that led to her incarceration. The evidence demonstrated that she continues to deflect blame for her predicament rather than take responsibility. This lack of insight into her own wrongdoing heightens concerns about her judgment and fitness as a parent. 5. A parent who cannot acknowledge such a grave error, a homicide that left her in prison for life, is ill-suited to make decisions affecting a child's well-being. Florida's public policy strongly condemns violent criminal behavior. A parent incarcerated for a heinous, intentional act cannot simultaneously fulfill the obligations or enjoy the benefits of an active parent. 6. In fact, Florida law recognizes that a parent's lengthy incarceration for a serious felony is so contrary to a child's welfare that it can justify termination of parental rights. See MSB v. RB. While Mr. Boone is not presently seeking to terminate the former wife's parental rights, this principle underscores how profoundly the former wife's situation has undermined her role in the child's life. 7. Florida law presumes that shared parental responsibility is ideal, but that presumption yields when shared decision-making would be detrimental to the child. Here, sole parental responsibility in the father is not only warranted, it is essentially compelled by the circumstances. 8. The former wife has been entirely absent from the child's life for over 5 years and will remain so for the remainder of his minority. By virtue of her incarceration until life's end, she is unable to participate in day-to-day parenting or any meaningful decision-making. 9. Mr. Boone has already been exercising sole responsibility in practice since 2020 out of necessity. Formalizing sole parental responsibility in the father is necessary to avoid any confusion or conflict in decision-making going forward. 10. Awarding Mr. Boone sole parental responsibility will serve the child's best interest. The child is thriving under Mr. Boone's sole care, which provides stability, consistency, and safety, all of which would be jeopardized by giving the incarcerated former wife any decision-making authority. 11. It is simply not feasible for Mr. Boone to consult with a prisoner serving life without parole on major decisions about the child's education, medical care, or general welfare, especially when the imprisoned parent will have no financial stake or personal time investment in the decision itself. 12. More importantly, it is not in the child's best interest to do so. The former wife's inability to accept responsibility for her crime raises serious concern about her judgment. The trial evidence showed that rather than expressing remorse or cooperating in the child's welfare, she has made unfounded, inflammatory accusations against Mr. Boone. For example, accusing him of parental alienation simply because he has protected the child from exposure to trauma. Such behavior reflects a mindset that is not conducive to healthily co-parent or prioritizing the child's needs. 13. Consistent with the above, Mr. Boone's proposed parenting plan should be approved as it is tailored to the child's best interest under these unique circumstances. Mr. Boone's plan is generous yet prudent. It permits the former wife to maintain a relationship with the child through supervised monthly visitation at her correctional facility and weekly telephone calls. This plan ensures the child can have some contact with his mother, preserving their bond to the degree possible, without compromising the child's safety or welfare. 14. The former wife's durational alimony award should be terminated retroactive to the date that Mr. Boone filed his petition to modify in April of 2022, due to the substantial change in circumstances and the elimination of her need for support. 15. Here, the former wife has no legitimate financial need for alimony at this time. Her incarceration means the state of Florida, at taxpayer expense, is providing all her essential needs, including housing, food, clothing, and medical care. She pays no rent, no utilities, no grocery bills, no insurance. The primary living expenses that alimony is designed to cover have been entirely assumed by the prison system. Any minimal personal expenses she might have, such as commissary items or phone minutes, are negligible and certainly not expenses the former husband should be ordered to finance. 16. In short, the entire premise underlying the original alimony award, to assist the former wife's post-marital living expenses and transition to self-sufficiency, has been upended. Given her life sentence, she will never re-enter society or incur the normal living costs that the alimony was intended to defray. 17. Put simply, the former wife's incarceration has extinguished any reasonable claim of need for alimony, and it would be inequitable in the extreme to force Mr. Boone to keep paying. 18. Moreover, the former wife's incarceration and conviction amount to a substantial change in circumstances that was not contemplated at the time of the divorce. 19. The former wife stipulated that Mr. Boone does not owe him child support since she was incarcerated in February 2020. 20. However, Florida law does not automatically extinguish a parent's duty to support a child due to incarceration. See Wilkerson v. Wilkerson. A parent's duty to support, quote, exists as a result of parenthood and is not erased by a criminal conviction. 21. In other words, the former wife's incarceration did not terminate her obligation to contribute to the child's support. It merely rendered her unable to do so. The unfortunate result is that Mr. Boone and the child have borne the full financial burden with zero assistance from the former wife. For over 5 years, the former wife has paid nothing toward the child's needs. She also failed to exercise any visitation. 22. Mr. Boone testified that between February 2020 and April 2022, he provided the former wife with direct monetary support averaging $600 per month, in addition to paying $240 per month for a mini storage unit on her behalf. 23. During this same period, the former wife had a child support obligation of $367 per month to Mr. Boone, based on his exercise of 100% timeshare and imputed income of $60,000 annually to him, and minimum wage imputed to her. 24. Extrapolated from February 2020 through the child's age of majority in October 2028, a span of 104 months, that obligation totals $38,168 in child support owed by the former wife. Child support she will never satisfy given her life sentence in prison. 25. Even without giving Mr. Boone any credits and assuming that Mr. Boone owed the former wife the maximum amount of $26,000 in alimony arrears from February 2020 through the filing of the petition to modify in April of 2022. The former wife's child support obligation alone more than offsets any such claim. 26. This calculation does not even account for the substantial sums Mr. Boone actually paid her directly, the storage expenses he covered, or the more than $14,000 in attorney's fees he has incurred in protecting his child's best interest against the former wife's persistent obstruction. Accordingly, any claim by the former wife for arrearages must be denied, as the equities and evidence overwhelmingly establish that Mr. Boone owes her nothing. 27. For all the foregoing reason, petitioner Brian Boone respectfully requests that this court A. Grant his modification petition and deny the former wife's outstanding motions. B. Award him sole parental responsibility. C. Approve his amended parenting plan. D. Terminate his alimony obligation and order that neither party owes the other any arrearages for unpaid support. E. Order the immediate release of any clerk-held funds to Mr. Boone. F. Deny all relief sought by the former wife, including claims for alimony, sanctions, contempt, or attorney's fees. Certificate of service, I hereby certify that a copy of the foregoing has been applied to the Mr. Joshua J. Martell. Great job, you ate with that one.
So yeah, I thought that was a great closing argument. I mean, he really hit the nail on the head, gathered her together, and just made it as cut and dry as it can be. I have no idea what her closing argument could look like. She sounded shocked when she said, I'm only limiting it to 5 pages. Yes, the sign of a really true seasoned judge being like, I know exactly what type of person you are, and I know the arguments aren't actually going to extend to any place relevant besides complaints and accusations. So get it in 5 pages or don't at all. Honestly, she'd probably have a stronger chance if she doesn't submit one. But yeah, there was one part that I overheard. I saw a little bit of Hear Me Out's reaction to the trial after he saw it. And he said at one moment when there's a lot of silence, because I cut out so many silence and pauses that were originally there. And he said during one of those long pauses, or I think it was during the break in between cross-examination and coming back, that during the criminal trial, apparently George's family only ever wanted to hear her say, I'm sorry. I'm sorry that George died. I'm sorry that I killed him and caused his death. And she couldn't do it. She couldn't even pretend to show remorse. She got up there and instead of fake crying and saying, I'm so sorry and not even meaning it, she said, I forgive you for forcing me to murder that man. And allegedly, Brian said that sorry does not exist in her. The phrase, the feeling of I'm sorry does not exist in her. And the evidence pans out. And now it's the same thing here, just in different ways of Brian and the son forced her to be this way because they didn't treat her properly. Honestly, I think Linda said all that needed to be said. So with that, if you enjoyed this video, remember to like, comment, subscribe, dislike if you're feeling it. Until next time.